Oh. Hi. Are you Matthew?
Yes.
Hi, I'm Jane. Thank you so much. Thank you so much. No, I have to flash. I forwarded it to her and she wrote back this morning, thanks. I think we're good. Okay. And my apologies because my head's everywhere. So like, it didn't occur to me that like, you had said, and written materials.
It didn't
It
occur to me until last night that I was like, well, actually, never submitted it properly.
Well, I think it's all good.
I'm standing, right? Amy, you gotta come sit up here. You're next.
It's fine.
You need someone to take a picture for us. No, she's not coming. She's gonna stay and we got
I
a
mean,
lot.
I know, I know. I'm just saying, I saw her Melissa was like, she's great.
She had messaged me on the weekend and she's like, should I stay at the office? And I'm like, yeah.
She watched the recording. To the extent she doesn't know.
Any, I was gonna say, like,
Are you ready?
yeah, I'm ready to go.
You ready?
Are you sure you want to make sure everyone's?
Well, I mean, we're gonna get started.
I mean, I'm coming up there to speak, right?
What's your presentation? All right, good morning, everybody. We're gonna go ahead and get started. Can everybody hear me okay? It's hard from here to tell what's projecting. Well, my name is Jamie Perez. I am of counsel at Rubin Family Law, and I'm currently the secretary of the Family Law section of the State Bar of Georgia. And the Family Law section is led by Chair Jonathan Dunn, who's out of Savannah, and Vice Chair Jeremy Abernathy, who is out of Marietta. And he's the genius behind this year's Family Law Institute, which is coming up in May. And so this is nuts and bolts of family law, which the secretary gets to put on every year. We've taken a hiatus for, I think, the past 2 or 3 years. So we're finally back and excited to get this up and running again. This is for not only new and newer attorneys who want to get a good foundation in family law, but this is also for people who've been practicing a long time and want to, get back to some of these the roots of family law and, stay in touch with the base of the whole practice. So before we get started, I wanted to say thank you to the State Bar, Mary Jo Sullivan, Charlie Smith, and Lane Sosby. They're the people who are at the registration table. And they put this all together and did the production behind all of it. I also want to thank all of the speakers. We have a really talented crew of people who are going to be presenting today and have been practicing for years in this area. Please make sure if you didn't already sign in and you want CLE credit, you have to sign the CLE sheet out there, and that includes for speakers. You're already registered as a speaker, but if you want CLE credit, you still have to sign in. Breakfast, as you saw, is provided out there. Lunch will also be provided. Both will be hot, which I just think is nice because those sandwich things that we sometimes get aren't that delicious. So hopefully this will be a big improvement. Parking validation, if you didn't already get it, make sure you get it on the way out through security. Bathrooms are right out here through these doors. And next, really quickly, I want to talk briefly about the Family Law Institute because the executive committee of the Family Law section of the State Bar of Georgia puts on the Family Law Institute every year. This year, it's May 30th through June 1st, 2025 at the Omni Amelia Island. You've probably seen emails go out about the hotel block opening, but registration, I think the email for registration is coming out this week. So keep an eye out for that. The original email with hotel information also included links to nominate people for scholarships to the Family Law Institute. It's a $2,500 flat rate scholarship for people who not only focus on family law, but show a dedication to public interest work as well, or sole practitioners who may have a harder time being able to attend given the costs. And then it also had a link to the nominations for awards. It's the Turner and Tuggle Awards. The Turner Award is only given out when appropriate, given who's been nominated. It's not an every year type of thing, and the Tuggle Award is an every year professionalism award. So please take a look at that. And if you know anybody, we welcome nominations from across the state. Doesn't have to be an Atlanta area attorney. And then finally, as I mentioned, the costs of Family Law Institute, costs of things like this, costs are rising everywhere. We are working really hard on the executive committee to keep costs as low as possible for everyone. Anyone who may have attended this in the past, the cost for today is probably a third to 50% of what it used to be. And that was very intentional. And that's with us working with the State Bar and them graciously putting on this whole event for us. And the Family Law Institute, you may have noticed, as the years have passed, the cost is going up. I just want to point out that this year we work with ICLE on the production of that event, and they proposed a cost of, I think, $650 or $680, $690 for registration. And we on the executive committee did not love that. And so we decided to keep costs lower. Tell me what it is again, 590 or 580? I think it's 590 is what we're keeping it at, which is still an increase from last year, and we don't love that. So I want to point out that the reason we're doing that is because we do have section funds that can help subsidize those costs for whatever the registration fees do not pay for, but we rely heavily on sponsorships as well. So if your firm is considering sponsoring and has not yet, I'm going to let Megan Wiss, our sponsorship chair, talk briefly about that. It's very important we do that to be able to keep costs low. Also, just so you know, moving forward, we are about to put out an RFP for the 2027 Family Law Institute so we can get bids from various production organizations or production companies to put Family Law Institute on in the hopes that they can come back to us with some lower costs so we can not keep having to raise the cost of registration every year. So with that, I will turn it over to Megan to briefly talk about sponsorship.
Hi, everyone. My name is Megan Wiss. I'm the chair of the sponsorships from the Family Law Institute. This is, I think, my third year doing this. And so we're kind of getting into our stride about raising funds for the Family Law Institute. There are sponsorships opportunities from $500 all the way up to $10,000. It really does help. Every sponsorship helps us. Your name will be on promotional materials. Your name will be featured in the Family Law Institute. And like Jamie said, we have really worked hard over the past 2 to 3 years to understand kind of where our money is going for the Family Law Institute and being fiscally responsible for our section. So part of that is raising funds when we need it, and that the Family Law Institute has always been funded by sponsorships from firms, solo practitioners, people who are committed to continuing the Family Law Institute and continuing the education that we get from Gathering as our kind of biggest seminar that we have each year. So if there's any questions about sponsorships, I will be back there in the back this entire seminar. So please come talk to me. I'm happy to email you or share any information about sponsorships. Right now we are on track to raise what we raised last year, but we're hoping to raise a little more to help kind of cushion that, cushion the extra costs that we're absorbing as a section. Thank you so much.
Thank you, Megan. And with that, I will introduce our first session, Streamlining Discovery in Family Law Cases, with Kevin Rubin of Rubin Family Law. You're going to hear the name Rubin Family Law up here a lot. And it just so happens that we were all on executive committee before we moved over to Rubin Family Law. It's part of Kevin's little plan to take over the world, starting with the family law section. William Alexander and I both came from other places before we moved over here. So that's why we're all listed under that name today. Kevin is a graduate of Emory University School of Law. He's a member of the American Academy of Matrimonial Lawyers. He also sits on the State Bar and Atlanta Bar's Family Law Section Executive Committees, where he is the head of Technology and Social Media Subcommittee on the State Bar. And with that, I will let him start his presentation.
Thank you, Jamie. Good morning, everybody. And one more plug before we get started here. There is and it's only on Facebook right now, mostly because I don't know how to do Instagram as of yet, really. But there is a group or something or a page on there. It's the Georgia Family Law Institute. I'm pretty good about if there's any emails that come out or information about like the Institute or General State Bar like today, getting that information up on there. So if you're still using Facebook, feel free to get on there. And get that. That's where you can get some information as soon as it comes out, as soon as we get it. I post up there, including about, everyone's always asked me, when's the room block coming out for FLI? Because it is exciting. It's nice to go to the beach for, a business trip. We do have a good time. And if you are interested in sponsoring, please do. This way we can bring shrimp back to the second night dinner. That would be great. But all right, let me get started. So I'm going to talk today about streamlining discovery in family law cases. And as Jamie said, they were not here on in my firm before when I joined the executive committee, but yes, I have grown and it's been exciting. We have a great work environment. So I'm happy that they are with me. So we're going to talk about streamlining discovery. I presume I just hit there. Nope. How does this thing?
Maybe that.
Okay. There we go. All right. Good thing I have an IT degree. All right. So discovery, what is it? Exchanging of legal information, or really information, so that all sides can find out and know the facts of a case. It's obvious for those of us who remember, or I don't really remember, but I remember hearing about it, there are no Perry Mason moments where you surprise someone in court. Everything needs to be exchanged. Everyone needs to know what everyone's going to put in evidence, what you have. That being said, so long as you ask for it, and you have to ask for it. If you go in and you don't ask for discovery during your case, then the other side has no obligation to give you anything. But let me throw out some things here. As I was preparing for this, I was looking through, and I love to read the statutes. And I always say, start with the statutes, then go to the case law, because it's very interesting what you find in the statutes. So OCGA 24-1-1, which is the first statute under the evidence code, is called Objective of Legal Investigation. And there it says the object of all legal investigation is the discovery of truth. Rules of evidence shall be construed to secure fairness in administration, eliminate unjustifiable expense and delay, and promote the growth and development of the law of evidence to the end that the truth may be ascertained and proceedings justly determined. I thought that was pretty interesting to read. I'm sure most of us never really read these statutes or the preambles, or when you look at the bills that come out, what's the intent behind it, but it is pretty interesting. So with respect to discovery, a colleague of mine told me that cases are won or lost in discovery. And how is that true? Because, and this is not, a great legal scholar or philosopher, just a colleague of mine, but I would agree with her there because, and while a key component of what I'm going to talk about is streamlining discovery, if you don't do discovery and you don't ask for the right discovery and you don't really figure out what your case is about, what your theme is about, and then tailor your discovery towards that, you're going to miss out on great opportunities. And really, if you go to mediation and settle there and you have all the facts and you're able to advocate on your client's behalf, or if you have to go to trial, or lately, there's a lot of us are doing arbitrations for a variety of reasons. And I mean, just imagine, like I said, going into court without having any documents from the other side. Your case has been pending for 6 months and you're there for a final trial. It's scary, but it does happen, and I've heard it happen, and it just sort of boggles my mind when you have the tools to do it, and every case allows you to do it. Let's see, there we go. All right. So what are we talking about? You got to know the statute, you got to know the rules. So when we're talking about discovery, we're talking about the Civil Practice Act, and specifically, I'm talking about OCGA 91126 through 91137. Those are the key ones you're going to utilize in civil cases, i.e. family law cases. Title 24, the Evidence Code of the Georgia Code, and then Uniform Superior Court Rules, specifically Rule 5 covers discovery in civil actions. And I just want to talk, there's a bunch of rules in there, but specifically Rule 5.1 talks about when discovery ends. And like in most civil litigation cases, you have anywhere 6 months, I'll say, from when the answer's filed, or 6 months from when the answer should have been due, to complete your discovery. And while most judges, I would say, are pretty lenient in terms of allowing that to extend open, especially by agreement of counsel, some judges are not. Some judges are like, this is your time to do it. And some judges are setting trials, particularly, I think one judge in Fulton County, before the 6 months even expire. So you got to get a jump on this. As much as, each case is different and you want to be pragmatic, you also got to get your discovery out there so you don't miss that opportunity, because key thing of this rule is that you can't use the court's compulsory processes to compel discovery if you don't send it out. So you got to make sure you're aware of, and I always calendar, all right, this is when discovery ends, 1 month before, 2 months before. So I know if I'm making strides towards settlement in a case, we're not really trying to go the litigation route heavy, but I also know, hey, we're coming up on this deadline. Let's get it in there. All right, so what are we talking about in terms of the general provisions governing discovery? This is really, you want to look at 91126, and that's the general provisions regarding discovery. B1 talks about the scope of discovery, where parties can obtain discovery regarding any matter not privileged that's relevant to the subject matter involved in the pending action, whether it relates to any claim or defense, anything along that line. And it's not ground for an objection that the information sought will be inadmissible at the trial, so long as it appears reasonably calculated to lead to the discovery of admissible evidence. This is what guides us in terms of discovery in cases. And again, we're talking any matter. And when you have a particular, let's talk about a divorce case, and you got a marriage. I'm starting a 4-day arbitration of a divorce case tomorrow, and these people have been married for what, 32 years? So, I mean, there's a lot that happens in a marriage over 32 years. So this is a long period of time, and pretty much I'd say everything goes in a divorce case for the most part, obviously except for what's privileged. And, the privileges are pretty clear and they're spelled out, and most of them are, I would say statutory. I mean, really, you look at the evidence code section for this, and it's all under 24. Well, it starts with 24.5501 that covers attorney-client, patient-therapist, which is huge in the family law world, because I usually ask my clients to go to therapists because they're cheaper than talking to me. And half the time, honestly, that's, my wife will hear me on the weekends talking to clients who are in emergencies, but really, I'm not giving them legal advice. I'm just talking them off the ledge. And it's always great when they go there, but that is privileged communication. All right. The fact that they go to the therapist is not privilege. The fact that when they attend, how much they pay, that's not privilege. It's the communication. Same with us. It's not that they come and consult with us. It's what they talk to us about that is privilege. I want to make sure everyone understands that, because there's a lot of lawyers who will assert that privilege and don't necessarily understand that we're talking about the communication, not the fact that someone went to a lawyer or went to a therapist, or, there's also accountant client. So, but that is, again, only communications. The fact that your accountant does your taxes is not privileged information. Now, there are limited exceptions to these rules as well, and you always got to be careful, and I would warn your client from the get-go. I think I have this in my engagement agreement about waiving your privileges. Don't forward your emails. Don't copy your girlfriend, boyfriend, your mom, your dad, everybody on the emails. You're potentially waiving, or you are waiving, your privilege. There's also, additionally, under the evidence code, there's communication with ministers, priests, and rabbis. I presume that, maybe by case law is expanded to other religions and other aspects of faith. And there's also something that we call, or I colloquially call, the Georgia privilege. It is 245505. Basically, you can assert this privilege where you may either incriminate yourself, so like the Fifth Amendment of the United States Constitution, or if it'll bring infamy, disgrace, or public contempt upon a party. So it's broader than the Fifth Amendment, I'd say, and it's definitely something you want to assert. Key thing with this, too, is that you have to assert it at the first opportunity. Otherwise, you waive your right to assert it later. And you're going to run into instances where, your clients aren't always forthcoming with you. And I mean, for example, I was in a deposition once, and my client wasn't forthcoming. All of a sudden, we started seeing all these Apple iPhone messages or Apple Watch messages to a variety of places. And he didn't tell me, so I couldn't tell him to advise him to assert the privilege, and that wasn't helpful. So again, I always tell my clients from the get-go as well, I need to know everything good, bad, ugly on both sides. Otherwise, I can't protect you. And part of it is knowing when to assert these privileges and telling them when to assert these privileges. So that's that part. I have up here work product. We all need to be cognizant of what is work product. We all went to law school. I know they drill it down to us in, evidence and civil procedure. But, it is something that is done internally. It's our mental impressions. And a key thing here, and then there's also the testifying experts. So those two code sections are right next to each other under 91126. It's actually B3 and B4. So testifying experts, when you retain an expert, and in a divorce case, or family law in general, there are experts who come in. We'll bring in a financial expert. You're going to hear from one in a little bit and possibly later today. You might bring in custody experts depending on the nature of the case. And you want to be sure, and I'm always certain when I email these people, I always put confidential work products so they know that that's not part of what they're relying upon to testify. That's them working with us. And there is Georgia case law that says that an expert can wear two hats. So I know in some other jurisdictions, I'm in the American Academy of Matrimonial Lawyers. I talk to my colleagues around the country all the time. It's so interesting to hear how their evidence codes and what they can do in discovery is completely different from ours. I think we have a very broad approach to discovery. Some states you can't even take depositions, or you're limited, and you can't serve discovery about experts. We pretty much have a very wide swath of what we can and cannot do. You're gonna give me a reminder, right, when I'm running low? Yeah. Okay, cool. But there is a case, McKinnon versus Smock. There's a series of these cases where it basically says an expert can wear two hats. So you can have a financial expert who's going to testify about a certain matter, but then they can also assist you with maybe coming up with settlement scenarios or other things along that line. And I don't think I put it in my materials, but if you search it, McKinnon and versus Smock, SMOCK. It's 264 Georgia, 375, 1994. There's actually a series of cases on this. It's pretty interesting. But with respect to what we do, though, you want to be careful about, you can have one expert. We're talking about people's personal money. Not a lot of them want to hire two experts just to have one who's testifying and non-testifying. Well, I say most of them don't. There are cases where it could be warranted. But you want to be clear what's work product and not in that situation. So that's something there. What are the discovery methods under Georgia law? These are pretty much all across any civil case. But you have interrogatories. I put RPDs, request for production of documents. That's under the Civil Practice Act. A notice to produce, that's under the Evidence Code. We'll talk about that in a second, the distinction. Requests for admissions and depositions. Now, these you have, it's OCGA, I don't have it in front of me, but I know it's later. But you can do a lot. You can pretty much do any of these. And they don't have to be in any order. They don't have to be, there are certain time restrictions, especially if you're the plaintiff on when you can start this stuff, but you can choose your method of discovery and go with it. and do what you want to do. But let me focus on a couple of them. So interrogatories, that's under 91133. You are limited. Now, those require responses under oath. And it always shocks me when I get responses back that are not verified. And that's usually one area where I push back on because I want to rely on your client's answers. So I always push back on that. Another thing there is you are limited to 50 interrogatories, including subparts. A lot of people think that just means, okay, well, interrogatory 1, 2, 3, 4. Well, interrogatory 1 is 25 subparts, and they don't, well, it's just one question. No. So be cognizant of when you're drafting these, what you're sending out. And there's no magic formula I've seen. I just use common sense. That was what was drilled into me by my first person I worked for, my mentor. You know, for example, some people might say, if you're asking for the name, address, telephone number, and email address, that's 4 different things. Use common sense. That's really contact information. I always say that's 1. And at the end of the day, who are you going in front of when you're dealing with these disputes? You're going in front of a judge. And you want to look like the reasonable party so that you're not getting, A, attorney's fees against your client or you potentially. And also you can show the judge, look, I'm trying to be reasonable here. I mean, they're telling me that that's 4, and I'm saying, you know, I'm at least saying, admitting that's only 1. So be cognizant of that. And also, if you get discovery served on you and it's more than 50, but it's, you know, you got to weigh the pros and cons of, you know, where you're going to pick your battles in this case. You might just say, all right, I'll respond for purposes of getting the case, moving it forward, but I reserve the right to assert that objection afterwards, especially if you supplement, you make a big deal out of it. And you also want to be, now when we're talking about interrogatories and RPDs, NTP, sorry, you want to be strategic on what you're asking and when, because you are limited in interrogatories. So if there's information you can get from documents, you don't want to necessarily ask it in an interrogatory and waste one of your 50. I mean, the court can allow you to do more, but you know, this has to be a monster of a case, from my opinion, to be able to ask to do more than 50 interrogatories, including subparts. So be strategic. What can you get in RPD versus what you need in an interrogatory? What can't you get in an RPD or NTP that you need in an interrogatory? And the key thing there, and I'm always surprised by this, is you can't ask someone to create a document. You cannot ask them to create, you know, people will be like, well, send me your DERFA in the RPD, MPD, NTP. Well, I'm like, well, and sorry for those who don't really, that's the Domestic Relations Financial Affidavit. It's a key document in most cases. And people will put that in an RPD, NTP, and it's like, okay, that means I get it to you when I'm required under the statute to provide it to you. But a workaround to that I always include, especially in counties where it's not required, like Fulton, you have to do it in a divorce case or most litigation at the first status conference, which is about 45 days after you file your case. So I usually include it in the interrogatory, and I say, give me your monthly budget. Give me what you spend on this. It's a sort of a, I hate to say it, a backdoor way of getting a DERFA. And I said, you can use the form if you want to, but here's what I want. I want your income. I want everything that's on the DERFA. I'm just not asking you to give me a DERFA. So be cognizant of that. You can't ask them to create things in a document request that you can in an interrogatory. Another key example there, I would say, is, you know, if there's a safe deposit box, a vault. And you could ask them to bring it to you, but you can also say in an interrogatory, you know, tell me what's in it. Or I love when people do it the other way, though, and it's quite interesting. Bring everything, but if you don't want to, give me a list. So there are many ways you can go about getting that. And I see some people do it, you know, both ways. But again, you're using one of your interrogatories for that purposes. Now, what do you want to ask for? You want to be strategic. You want to know your case. Typically, what you want to ask for is you want to identify expert and lay witnesses. People are going to come testify. And you're also going to want to ask who are persons with knowledge, because they may not be people who they're going to call to testify on their behalf, but they may be people that you want to reach out to and contact and possibly depose and bring in for your case. You want to ask, I always love conduct. I wrote sex, drugs, and rock and roll because, again, it is family law. Everything comes in here. Everything comes to play. And I just remember once I asked for, you know, prescription narcotics, and someone asserted a doctor-patient privilege. And I'm like, what? That has nothing to do with this. I mean, you could take the privilege, the Georgia privilege, that's fine. But there is no, and I'll get to this in a second with objections, there is no doctor-patient general privilege in Georgia. So you can assert that. You want to ask about educational background, what are the contentions in the case? What are the contentions regarding custody, parenting time, alimony? Can they work? Do they need help? How much are they asking for? I mean, most of the times you'll object and that's work product, but put that out there at least and see, because sometimes people actually do respond and it's quite interesting. And like I said before, you want the safe deposit box vaults, because again, you're dealing with finances. People will keep items in their house in these places. Shocking how many people keep a lot of cash in their safes as opposed to the bank, but it's there and that's an asset, and you want to make sure that you're accounting for all the assets. Let's see, I talked about the DERFAs, and okay, so let's go on. And the other thing too is under 91133C, and a lot of people get this wrong, but that is a statute where you can say, all right, in response to this interrogatory, pursuant to the statute, look at the documents I'm producing. AKA, it's called, they say business records, but there are no businesses. And I mean, it's a family, it's a divorce. But I think the general concept is look at the records I'm producing. So for example, if you're asking, the interrogatory asks for income information, I typically do something like, all right, pursuant to the statute, look at the tax returns, the pay stubs, the W-2s, everything I'm producing over here that has the information on there, or bank statements, or if they're asking for financial records, account information, balances. It's amazing what people ask for, honestly, in interrogatories. I always say, look at the documents. That's where you can go get the information. I don't have to put it on here. You can go look at the documents, and I'm literally giving you all the documents. I mean, so long as you're giving all the documents, I think you can fairly say that. If you're not giving any documents, then, which people do, then you're going to have an issue there. So that's one way there. Now we get to RPDs and NTPs. Now these are separate tools, yet for whatever reason, people seem to, and the only term I can say for this is bastardize them, by putting them in the same thing, by saying first production of document or request for production and notice to produce. They are separate tools. They're under separate statutes, and there's different things that you can and cannot do with them. So with an RPD, let me start with that. That just 91134 governs it. I think I put this in my, this is all in my materials. And really read these statutes. They're very interesting when you read them and what you can and cannot do with them. For example, you can use the statute to say, I'm coming on your property to inspect it. And while most of the time, and we're dealing with real property, usually people cooperate and say, yeah, my appraiser can come by at this time. I had one case where I think the guy owned like 50 F1 cars, and the other side did something like this. Now, we objected because the first time they came around, their idiot experts set off the safety mechanism in one of the cars and turned it into a giant marshmallow, is what happens, I guess, when you crash these things. So we were like, hold up, we're not doing that in this situation. But it's interesting what you can do and not do with this, especially if you're thinking they're hiding stuff. You can then say you want to go in. Now, that doesn't prevent them from removing anything. You obviously want to maybe get a PI to keep tabs on it. But you can do a lot of things with this, and you can get documents. And one thing I want to say, though, and you can also do non-party requests for production documents. Now, you can subpoena non-parties, but you can also do a non-party RPD. And lately in my cases, and probably Jamie would attest to this, I've been doing a lot of those because people are just not turning over documents for whatever reason. As well as if you're getting bank statements, not all banks will put the checks on there. And sometimes you want to see where people are writing their checks to and who they're paying. Are they paying their legal fees? Are they writing money to someone else? Is the money going out the door and, but it's in cash? The check is to cash, and who's checking, where's it going to? Are they hiding money in another account? Oh, shoot, I got 5 minutes. All right, NTPs, let me skip over that. That can be used for this. All right, documents, third party, God. All right, objections. Let's talk about objections real quick. Let me give you just some practice pointers. While there's no cases on point, the federal rules don't require or don't allow for general objections. And Georgia models itself on the federal rules, and my suggestion is don't do general objections. I hate getting discovery responses where they list out 20 general objections, and then in every single response it's subject to the general objections. Well, which ones are we applying here? So my suggestion is, and what I do is I do a general objection, but I object to the instructions, because after 20 pages of instructions from the other side, which I don't have to do under the Georgia Civil Practice Act, I want to let them know I'm objecting to that. I'm not going to do everything they ask me to do because I don't have to do that. I have to just follow the rules that are in the Georgia Civil Practice Act. So my suggestion, what I typically do, is I do a general objection provision to the instructions, definitions, whatever they want to call in their preamble to their requests. I say I'm going to supplement, and there I might also, if it's more than 50, say I reserve the right not to respond in the future, potentially. All right, let's talk about some privileges. Like I said earlier, people assert the doctor-patient privilege. There's no such thing. If anyone can find it for me under Georgia law, please reach out to me. I've never seen it. I've had people assert that. I was like, this doesn't exist. HIPAA, in family law, a lot of people like to assert HIPAA. That is not a valid objection either. I'm sorry. But when I get that, HIPAA essentially prevents doctors from selling your information to third parties like pharmacies and other things like that. It doesn't prevent you from giving over your own medical records. Yet people object on that ground, and I always have to say, no, this isn't how it works. And there's something called McEachern. It's a case that talks about post-separation conduct. A lot of people will object on that. It was decided under the old rules of evidence, and really there hasn't been anyone taking this up on appeal yet. It'd be fun to, because it basically does say post-separation conduct is not admissible. Now, people get mixed up with there's admissibility versus discoverability. Well, you can discover it. My suggestion always is to, if you are having an affair after, or if you're starting, it's not an affair because the marriage is done, you start seeing someone else, take the privilege and but delineate the time period, because the conduct during a marriage is pertinent to property division, as well as if you're asking for alimony, but you were having an affair and that's the reason the divorce is occurring, that is a bar to alimony under Georgia law, regardless. So, a couple pointer tips there. Let me see. Requests for admissions, 9/11/36, they're good to use in certain cases. For example, if you're dealing with a prenup, a postnup, and you want the other side to admit, yeah, I freely entered this, I was fully aware, I had there's certain prongs under the Georgia law on this. Use that to get them to admit it. This way you don't have to take their deposition, potentially, and you get them to admit it, and then you can use it in a motion for possibly summary judgment. Also in motions for summary judgment, do it for that too, depending on what you're doing. If you're doing a motion on separate property, have the other side admit, hey, isn't this his separate property? I hate to say his. Isn't this my client's separate property? Yes. Didn't they have it before the marriage? Isn't it titled this way? You can only admit or deny, or you have to detail the reasons. You can't state either way. But if you know that, yeah, this house was titled in the name before the marriage, get them to admit that. Use an RFA. And that being said, you got to be careful with, I've had some people send out like 500 RFAs, and it's like, are you kidding me? I know, 1 minute, I'm getting there. All right, so next thing is depositions. Those are in the code 9/11/30, 9/11/31. Uniform Superior Court Rule 5.3 addresses how long. 1 day, 7 hours, unless you agree or the court otherwise says. I remember I had a case once where we agreed to 2 days of depositions per party. It was a big trust case. They're not always necessary, depositions. You got to look at your case and say, all right, do I need this deposition? Like I said, I have the 4-day divorce arbitration starting tomorrow. I decided 2 days before I was going to take the wife's deposition. I don't really need to. Why would I want to clue them in to what I'm going to basically, put in evidence at the final trial to give them the opportunity to tailor their testimony and blunt that? And this is not a Perry Mason moment. I've exchanged all the exhibits. I'm just going to use them in a strategic fashion. So when the wife in that case is going to come in and basically say, oh, this happened, I'll be like, really? Then why did you send this greeting card to him saying, I love you, you're the best? Yet you're saying all this abuse stuff occurred over here. And also, while I'm saying limit, be thoughtful about what's your case, what are the issues, what's your theme of the case, what's your argument going to be, you still want to be a little broad. Because also for this trial, I have, hopefully opposing counsel's not in here. I have I don't think so, but I asked for job applications, and it was shocking that I got this one job application. I gotta say, Jamie did an awesome job in the outline for it, where, you think it's just a job application, what you do. Well, the wife did a 2-paragraph narrative about her marriage, about, all this stuff, and I'm just like, this is like manna from heaven for my case. To tomorrow. So, you're never going to know where you're going to, where good stuff comes from. So you want to be a little broad, but you also want to be, really thoughtful about what you're asking. And also read the statutes. Start with the statutes. It's amazing what's in there. It's amazing that a lot of our colleagues don't. And if you're also on, if you're on Facebook, there's a group on there. It's always shocking to me that people will put questions out there that I'm like, did you try researching this? Because it takes 1 minute to find the answer. It's really easy. But like I said, and if anyone has any questions, feel free. I think I'm out of time. Jamie, right?
We are out of time.
Okay.
If anyone has 1 or 2 questions, the rest you can attack them afterwards.
Thank you. All right.
Thank you, Kevin. That was excellent. Kevin seems to be one of the most knowledgeable people to me on discovery. And so I thought it was really important he speak on this one because there's so many good tips in there that, I had never known coming into working with him and the nuances of each of those. So thank you so much. Our next session Oh, okay, perfect. You can go ahead. Our next session is statutory changes and unique issues in child support. Amy Saul Mollengarden is going to be presenting. She is a partner at Connell Cummings and a graduate of Georgia State University College of Law. She's a member of the American Academy of Matrimonial Lawyers. She's on the Atlanta Volunteer Lawyers Foundation Leadership Council. And her law partner, Katie Connell, of course, helped draft the new legislation for child support. So their firm's particularly experienced in being able to, or knowledgeable in being able to talk about this issue. So as soon as Charlie has it set up, I will pass it over to Amy.
Good morning. I am Amy Mollengarden, and as Jamie said, I'm an attorney at Connell Cummings. And today I'm going to spend some time talking with all of you about some of the changes to the child support guidelines. Before I get started, I wanted to get a show of hands. So raise your hand. I just want to get a feel for the room. Who here has been to a seminar or a lunch and learn and has heard something about these changes to child support? Okay, good. That's what I was expecting, a lot of hands to go up. So this is just, for me, I've heard about this probably over the last year, once a month. So if not more, and then of course it's coming up in my cases. So again, I hope for all of you that have heard a CLE or been to a lunch and learn on this topic, that this is just a refresher and continues to kind of create some knowledge, and you can issue spot and be prepared in your cases. And if this is your first time, I hope you learn about this. Feel free to ask questions, and so let's get started. So there is a child support commission, and their job is to stay apprised of relevant issues in child support, make updates, and for many, many years, they have been working on some updates to our child support statute and our child support calculator and worksheet. And in the last year's legislative session, some of these laws were finally passed and changed. And so what happened is I've highlighted here some 4 changes to the child support guidelines that, and they take effect in 2 parts. So the first part took effect in July 1st, 2024, so last year. And so that first part is going to be updates to the basic child support obligation table. And you can see there's this, again, many years ago, already 3 years ago, there's an economic study, right? We have the basic child support obligation table that says this is how much it costs to raise a child, and this is how we should, base our child support obligations off of. And they did this economic study to say, hey, we need to make some adjustments. It costs more now than it did 20 years ago or 15 years ago, to raise a child. And some of you will remember and have noticed that there's always been a blank Schedule C on the child support worksheet. And that was intentional because now, and again, this comes to point 4 up on the PowerPoint, parenting time adjustment. I believe Schedule C is now going to be a parenting time adjustment calculator added into the worksheet. And this is something that has been known was going to be coming, but it takes a lot of time and effort to study this. I understand that the Child Support Commission was looking at a number of other states, who's doing it right, who's doing it wrong, troubleshooting, and really getting a great model for us. Now, point 4, the parenting time adjustment is not going to take effect until January 1st of 2026. So that's why child support adjustments are rolling out in 2 phases. Now, the law has passed. So this, you can go read the statutes. The law on all of this has passed. It's just the implementation of that parenting time adjustment has not taken effect yet because the government needs to create that Schedule C, the parenting time adjustment, the technology, and that just takes time. There are also 2 other things I want to point out to you. Number 2, there's a VA disability credit. And I believe, let me go back a second. And then there's also a low income adjustment. So I'll talk a little bit more about those in a few minutes. So this, again, reiterates that there was updates to the table, the basic child support obligation table. So the first thing is that the actual amount of child support has changed. They've looked at, again, what does it cost to raise 1 child? What does it cost to raise 2, 3? And they've updated the basic child support amounts. Now, they've also updated the vertical access. So if some of you remember, previously, it was capped at $30,000 combined income. And if you had a family that monthly income, excuse me, and if you had a family that made more than $30,000 a month in combined income, you were in this position to ask the judge for a discretionary high income deviation. Well, now the vertical access of that basic child support obligation chart now goes up to $40,000 a month. And so you don't have that same threshold yet of having to ask for that high income deviation. And I've heard, I'll throw Kevin under the bus here, but Kevin Rubin said, he left, so I can do this. So he said at one point, well, why didn't they expand it higher? We need, people are making $1 million a year and $2 million a year. And the answer I've heard is, well, that's not the majority of Georgians, right? And it costs a lot of money to study this and to implement, to create this chart. So we are at a $40,000 a month cap on that basic child support obligation chart, and anything above that you're going to be asking for a parenting time deviation, a high income deviation. Another point I want to mention is effective July 1, the child support calculator has been updated. So if to reflect these changes. So if you are using an old worksheet, an old calculator, that is no longer going to reflect the correct numbers. So an example I can give you, you had a temporary hearing in June of 2024, you're using the old worksheet. You now, April 2025, have a final trial. Don't go into that old worksheet. You need to recreate it because it's not going to show the correct numbers. Well, and then again here on the left is the even older version. So, we've all seen if you're using the Excel version, you're, I don't know how many years behind. So just make sure you're using the current calculator online, both the current calculator. Okay, so I don't know how many of you have had cases with where a child is receiving Social Security disability benefits, but if they are under I'm not sure on which title, but a certain title, you can get a reduction in the child support that the non-custodial parent pays. So there's been a new change as well, that VA disability benefits being paid to the child can also decrease the child support obligation. I can tell you I don't know how many years I've been doing this, 13 years of practicing family law, I've never had a VA disability case, but it certainly would be something to pay attention to because now it impacts child support. The low income adjustment as well, it's a safe, it's a fail-safe mechanism to make sure that someone is not paying a certain too much out of their income. So again, if you have a case where they fall within this low income category, just be prepared to think about, hey, is this a low income family where we need to look at the low income adjustment? So I mentioned some of this already, but this is the parenting time adjustment and eliminates this is I think an important, important to point out. Currently, the parenting time there's a parenting time deviation. So currently you have to go to the judge and say, hey, this is a 50-50 parenting time situation. We need a deviation, and that's discretionary. And come January 1, 2026, it's going to be called a parenting time adjustment. And adjustment's mandatory. It's going to be required by the courts. And so just learning that term of art, the difference between a discretionary deviation versus a actual adjustment, I think is important. Again, as I mentioned, this is already the law. It's just our technology is not up there, is not updated yet. So that's why we're waiting until January 1, 2026. Now, here's the question. Should you be doing this already? And I think that the majority, Katie Connell, my law partner, who's on the Child Support Commission, I've heard her say many times, yes, we should all be going ahead and doing this. You can calculate it. There's ways to figure it out. Go ahead and do it. We don't want to be in a situation where January 1st, 2026, there's modifications left and right, especially if you're working on settling your case or finalizing a case right now. You don't want to be in a position where you come back and you have to litigate again in January of 2026. Now, I think there are some exceptions to that. And so you do want to be somewhat strategic. Perhaps you represent the custodial parent who's the recipient of child support, and they have a 16-year-old child. That might be a case where you might not want to do the parenting time deviation yet. You might want to try to settle your case without it because it's 2 and some months left of child support. If the other side's sitting in here and here's this, they're going to be saying, no, no, no. I know that there's a parenting time adjustment coming up. We need to go ahead and implement that now. So I think there is some strategy you could do to not do it, but I think the general advice that I'm hearing and what I'm practicing in my practice is that we are going ahead and looking into this and implementing it. So currently, your deviation, so again, it's a deviation currently, it's not an adjustment, and it goes on line 10. That's where you would add it. Now, because this is in the statute, this is really small, so I apologize if y'all can't see it. You should have it in your materials as well. But because this is already passed into law, you can actually figure out how to calculate the parenting time deviation or adjustment. It's a big math equation. I don't personally know how to do it, but someone smarter than me in my office created a parenting time adjustment tool. I do believe we're sharing this, so feel free to reach out if you would like a copy. And so what you would need to do it is you need the basic child support obligation for the custodial parent, the basic child support obligation for parent B, the non-custodial parent. So this would be what's on line 5 of your child support worksheet. And then a 2-year average of each parent's number of overnights, days per year. It's the days per year that they have of parenting time, but you do calculate days by looking at the number of overnights that they have. If you have a parenting plan where there's no overnights, but it's frequent visitation, there is a part in the statute that tells how you calculate that. You would basically total the hours throughout the year and divide by 24. But generally, you're looking at overnights. So this is just to show y'all, this is the Senate Bill 454 that has the language on how to do this calculation. On the left is some of the formula that's used. Again, someone smarter than me, Ivory in my office, did this. And so now we're going to get into some examples. And before I jump into these examples, actually, let me go back a page. So it's really hard to see here, but to calculate the 2-year average of days, until Georgia's calculator is ready, the following free calculators are recommended. And so what this will do, this is Minnesota and Oregon. I personally like Minnesota. I use the Minnesota calculator, and what you can do is you go in and it lets you pick, who's the custodial parent, who's the non-custodial parent, and you can click on a calendar and insert the days. And so then it will calculate the average for you. There's some trouble, there's some issues I've already seen with it. So hopefully when Georgia comes out, it fixes some of the issues I've seen with Minnesota's. But for now, it's a great tool to help you. And I have an example of that coming up in a few slides. All right, so here's our first example. Primary physical custody with Daisy Duck, and there's 3 children. Donald has parenting time every Friday to Monday and every Wednesday. So that's a long weekend and every Wednesday. In summer, each parent gets 3 weeks, and the balance of summer is Donald's regular schedule of parenting time. Holidays are divided and rotated, and an expense of $125 a month is in Daisy's column on Schedule D as a monthly health insurance premium. Okay. Donald's gross annual income is $75,000 a year, and Daisy's is $45,000 a year. So this is hard to see, so I apologize. Y'all have this in your materials. Hopefully it's easier to see. But Donald's monthly child support before the parenting time adjustment would be $1,479. This is a pretty standard worksheet. The only item there is on line 6 is the adjustment for health insurance. Okay, so now we need to figure out the parenting time adjustment. So the first step is going to be to figure out how many days the parties both have with the child. And so this is an example of the Minnesota's, the end result of the Minnesota calculator. It is really user-friendly and helpful. So it kind of helps you plug in days and names and dates and stuff like that. So you end up with something like this at the end, and one parent is green and one parent is blue. And you do it 2 years, you enter the dates over 2 years, and it gives you an average. So some of the issues I've seen with this, just so y'all are aware, it's not editable. It's hard to say. Editable. So once if you would want to complete it, save it as a PDF. But if you come back later, it's gone, right? There's no working copy. So another thing that I think is a really good idea, and I believe these will be circulated at some point in the coming months, or we'll all have one in our mediation notebooks and trial notebooks, but is some sort of cheat sheet, right? That says, okay, the number of days, if you have a standard every other weekend schedule, this is the number of days. If you have a week on, week off, that one's pretty easy, but this is the number of days. If you have a every other weekend, but 50-50 in the summer, these are the number of days. And I think we'll all end up having some sort of cheat sheet if you don't already have one. Because it does just, especially in your negotiations, if things are fluid and changing, it is a little bit hard to go back in. You have to redo it, basically. So I made a list of some pros and cons. So with these changes, I don't know how you feel about this, but it's more work. That could be a pro or a con to some people. More work, more billable hours. more work. Hey, we're all overworked anyway. So there's going to be more argument over parenting time because as parenting time goes up, child support will go down. And so you may have a situation where you have let's just say, I'm just going to use traditional gender norms here, but it could of course be anyway. You have a non-custodial dad. He's perfectly fine every other weekend, but he really doesn't want to pay child support. So he might all of a sudden, before in the past, not made a big deal of it, getting his every other Friday to Sunday or Friday to Monday. And now all of a sudden he's saying, well, I want Wednesday to Monday, right? Because he knows it's going to decrease child support. And then you might have a situation where he then doesn't even exercise it. So we want to, it's a balancing act of, is this legitimate? Is this parent really going to be exercising this? Or are they just trying to get out of child support? The intent of this is it's economically better for the families and makes more economic sense that we're shifting, we're paying attention to who's got the kids. So that's hopefully a positive. And consistency, right? It's gonna be seen as consistent. It's a little less of a parenting time. We're not gonna have the deviation, which is completely discretionary. And I think it makes your negotiations harder. But everyone here is super smart, capable. We're gonna do great with this, but I do think in general, as I mentioned, negotiations become a little harder. Okay, so again, this is the calculator that my office created for a temporary basis. We're still waiting on the Georgia government to come out with our updated child support calculator. But for now, what you would do is you would enter in the custodial parent's basic child support obligations that's already on your child support worksheet. And then you enter in the parenting days for each parent that you've just calculated on your Minnesota or Oregon calculator. And it will tell you what the parenting time adjustment should be. And you would enter that parenting time. Again, now it's still a deviation, so it still goes on Schedule E, and it ends up on the first page of your, that is line 10. Okay, so you would still have to fill out the questions, the findings of fact on Schedule E to explain to the court why we're doing the parenting time deviation at this time. And you can see that it ends up lowering Donald's child support obligation from almost $1,500 to a little over $900. So again, you can see how this is going to impact child support, and it's less money to the custodial parent than it used to be. One exception to that is because they actually updated the child support obligation table and recently, it's like the child support went up a little bit and then it's going to go back down. So everything's a little bit fluid, but ultimately the child support will be going down with this adjustment. Just another way of thinking about it, this is in your materials. This gives you some scenarios of, how income, parenting time, how it relates to the final child support in different scenarios. So y'all can take a look at that in your materials. Okay, let's do another example. So Mickey has parenting time every other Thursday and then Thursday in the off week. Summer is week on, week off, and holidays are divided and rotated. And for all of the following calculations, I didn't include any expenses for private school or anything else. I did include $125 kind of placeholder for Minnie's monthly health insurance premium for baby Mouse's health insurance. Okay, so in this situation, Mickey makes $302,000 a year and Minnie makes $116,000 a year. That's over $400,000 a year, but just so y'all know, that still is not that $40,000 monthly income that I had mentioned earlier. So this is still not, again, this is so small, but it's still only $34,833 a month. So we're not, now previously that would have kicked in that high income deviation conversation, but now it doesn't because our chart goes up to 40,000. This results in a child support amount of, before any parenting time deviation, of $2,199. We go to our Minnesota child, thank you. We go to our Minnesota child support calculator. We plug in the schedule, and it tells us that Mickey's average parenting time is 148 days and Minnie's average is 217 days. Again, we look at a 2-year average of parenting time because some years someone has a longer summer, or someone has more Christmas time, or so, so we do look at a full 2 years, but it's an average. And then this results in, then we come to the parenting time adjustment calculator. Okay, so just to reiterate, you run your child support worksheet with the regular information, then you do your parenting time calendar, then you do your parenting time adjustment calculator, so you can see already it's more work, and you plug it in, and then with this one, it results in an $809.86 deviation adjustment, we'll call it both for now. Again, I keep reiterating that it's more work because I might do this preparing for mediation. And I do a prep of this before a mediation with my first position. But throughout the day at mediation, we're changing parenting time. We've offered every other Friday to Sunday. They're offered now saying Thursday to Monday. Then all of a sudden we're doing, instead of 2 weeks in the summer, we're doing week on, week off in the summer. And every time you change the parenting days, you have to then come and update your calculator. What if then also now you're arguing over what someone's income is? Everything trickles to the next, I saw someone looked confused, so let me back up. So if you're in your mediation, you're negotiating this, and you think you have a plan, and you show up to mediation, and all of a sudden you're negotiating income, you're negotiating parenting time still, you're all these factors, it trickles down to each worksheet calculator analysis that you have to then go back and redo. So I personally think having some sort of cheat sheet is going to be our best friend in all of this. Yes.
Is it always going to be the base? There's going to be the base amount, and then it's always going to be a downward deviation after you do this parenting time? Or is there a set number of days that's going to make it that the base is the base?
Good question. It is my understanding. Well, let me put it this way. In my experience so far doing this, it's my understanding that it will always decrease it, but there may be an exception, and I'm happy to look into this further if it's a low income family. So at a certain threshold, I don't know if it would do that. But generally, yes, any amount of time is going to decrease the child support. Okay, so when we enter this one on the worksheet, it decreases his child support from about $2,200 to right under $1,400 a month. Here's another scenario kind of that y'all can look at in your materials. And then just a reminder, OCGA 19615D, it says the guidelines enumerated in this code section are intended by the General Assembly to be guidelines only. And any court so applying such guidelines shall not abrogate its responsibility in making the final determination of child support based on the evidence presented to it at the time of the hearing or trial. I think that's important to remember. So I'm going to stop here. Does anybody yes, go ahead.
Have different parenting time schedules. So like a younger child would have a more structured, half the time with mom, half the time with dad. And older children are whenever they want to.
It's a really good question. I have not had that situation come up, but I think I would probably run the parenting time deviation with each situation. Yeah, that's what I was, thank you. Okay. No, I appreciate it. If someone knew that, please chime in. Yes.
Based off of home standard Friday to Sunday with the holiday. Um, Your recommendation is even with the standard Friday to Sunday rotate, go ahead and put that down.
Yes, that's the recommendation, is that you should be running this calculation for any parenting time. That actually, when they first came out with parenting time, it was assuming, I'm gonna say this wrong. It was assuming, I think, no parenting time. That makes sense. So if you're having any parenting time, it should be included. Any other questions? Yes.
Is this model, with the child, the parents home adjustment and the amount of money, this is based on the premise that you have a custodial parent and then you have a parent who just is subject to the other parent's parenting. Right?
Repeat the question, please.
I wanted to confirm before I ask my question that this model is based on the premise that you have one parent that is the custodial parent, child lives with that parent, and is subject to other parents' parenting.
Yeah,
Right.
that's how it's in non-fiction.
Right, that's it.
Yeah.
Okay, so given that I got that part right, so if you have joint custody, because I did have a case where it was joint custody, and so they agreed that no one would pay child support to either person. But what kind of consideration is given where there is joint custody, but one parent makes considerably more money than the other person? So is the income of the parents considered, or does that become a maintenance issue?
Yeah, great question. It's my understanding that you should be doing this across the board, even in joint custody situations. And really what will happen is it will factor in the differing income. So if you have they have equal parenting time, but let's just say mom is making more money than dad, right? Then the child support statutes, the parent that makes more ends up paying child support. So that parent will be paying the other parent child support, but will get the adjustment down based on the parenting time. And really, you can do this calculator, and I did it. If you plug in that they have equal parenting time and you plug in they make the exact same money, then that's a situation when you get zero. But other than that, it's not going to give you zero. It's going to factor that in.
So if they say, I don't care, we'll both take the same time, no one pays anyone child support, you wouldn't really, that's disadvantaging the person who makes less money.
Correct. They are effectively waiving a right that they would otherwise have. You may settle your case for that for some other reason. Maybe you say, well, we're not going to do child support, but the parent that makes more is paying all the extracurriculars or going to pay for all summer camp. There may be a reason you do that, but yes, they are effectively waiving their right if they choose to, even in a 50-50 situation, if the other parent makes more money and they're choosing to waive their child support, that's something they're choosing to do. Okay.
Thank you.
Thank you. If y'all have any other questions, I'll try to answer them. Y'all just come find me.
Yes, where are you seated? Right, yeah, let's give her a round of applause. Yeah, Amy's seated in the middle here, so, and on breaks or anything, if anybody else has any questions, feel free to, grab her. Next up, you're welcome over here. I'm going to go ahead and introduce, our speakers for our panel on forensic accountants. Sherry Holder with the Holder Group. She's a graduate of Georgia State University, and she has served as a forensic accounting expert in many cases over the years for many of our firms. Special bonus point, also offers her firm services pro bono for Atlanta Volunteer Lawyers Foundation. And I will say most of our panelists who are very elite family law attorneys all offer their time pro bono for one of the legal services organizations. So thank you to all of them. And then we have William Alexander, who is also a partner at Rubin Family Law, as we discussed before. He also handles appeals and serves as a guardian ad litem. He's a graduate of Georgia State University College of Law and serves on the Family Law Section Executive Committee. So I will turn it over to them.
Morning, please. Good morning. Can everybody hear us? All right. Are we blocking what's behind, or you just see our big heads back here? Our apologies. It should just be the paper, so hopefully you've just got that up in front of you. But as Jamie said, I'm William Alexander. I practice exclusively in the area of family law, and I'm excited to be here with Sherry today, who has bailed out quite a few family law attorneys like myself, and I'm sure a few in this room as well. But one of the things that we wanted to talk about today is, as this is a nuts and bolts, just kind of go over some of the basics. All the time when I'm engaging a financial expert, I am looking for those magical letters that come after their name. And that was one of the first things that we wanted to hit on. I certainly know what a CPA is, but that's about where it stops, where just the intuitive nature comes into play and I have to Google, ooh, ABV, CFF, ASA. So hopefully today we're going to be able to get over that hump and y'all will be able to look at these financial experts and know who is best fit for your case a little more easily and intentionally guide your clients as to who is the best fit and what type of financial expert is going to be the best fit for your case. I'll let Sherry talk about some of these what I called post-nominal designations, because that was the way I could make it sound fancy. But certainly just the letters that come after the experts' names.
Okay, so we'll start with CPA, which most of y'all are going to know is Certified Public Accountant. Most of us who serve as financial experts or forensic accountants are going to have that designation, but not all of us. So if you are looking for someone who can speak about taxes or basic accounting, you'll need to ask, are they a CPA? Are they qualified to talk about taxes? But most CPAs are never going to have any training in the specifics of family law. There are some programs out there now that have forensic accounting classes. When I went to school a very long time ago, I didn't even know there was such a thing as a forensic accountant. My daughter just graduated from Auburn, which has an excellent accounting program. She didn't have any forensic accounting classes. So just being a CPA is not going to give someone the training necessary to work in this space. They're going to need additional designations, additional training. So another one you might see is an EA. That is an enrolled agent. So it is someone who can practice before the IRS, but they are not a CPA. They have not passed the CPA exam. So, I mean, I'm sure I'm kind of a snob because I sat for the 2-day exam and it was really, really hard. So I kind of think of that as a lesser designation, but they have passed tests and have been permitted to practice in front of the IRS.
So we bring up EA because that's somebody you certainly might encounter as you go through your work in a case. It's not necessarily, it may be, now again, I want to be clear, but it's not necessarily someone you're going to run into as an expert. And certainly if it is, then perhaps on the other side, you're going to look to engage a CPA or someone who does have that extra accreditation, just in case you end up in trial and the court is certainly weighing between the two experts and who they're going to give more credibility to.
Right, but when you are looking at the tax returns and you look at who signed that tax return as the preparer, you might give weight to what letters are after their name when judging how much confidence you have in those tax returns, because we all know no one ever lies on their tax returns. After that, we have some business valuation designations. So there is accredited in business valuation, which is through the AICPA, much to many of the CPA's chagrin, they now allow non-CPAs to obtain that designation. So just because you have an ABV through the AICPA doesn't mean you are a CPA. There's also an ASA, Accredited Senior Appraiser. That's a designation through the American Society of Appraisers. And then there's a CVA, a Certified Valuation Analyst, which is through the National Association of Certified Valuation Analysts. Those three designations relate to valuing businesses. So if you have a case that has a closely held business, you are going to want someone with one of those designations or more of those, more than one of those designations to value the business. I have had cases where we got to court, the other expert had let their business valuation designations lapse and they were excluded from testifying. So you want to make sure ahead of time, if you have that business valuation, that the expert who shows up to testify actively has those designations. That's key. They all require additional training and testing, required continuing education. We have to have as CPAs 40 hours a year of continuing education, and then our designations sometimes even more on top of that.
And I'm going to put Sherry on the spot real quick, which she
Yeah.
did not know I was going to do. But if we have a case with a closely held business and we need it valued, is there one of these experts with certain designations that would be preferable in that situation? Or is there a certain type of business that would be better suited for one versus the other or anything like that?
Actually, I think they're all pretty even. I mean, those of us who have one kind of are probably a little more on our particular designation. I think the ASA is when I did research about them, someone just spoke about the designations themselves in our continuing ed. The ASA is on the downturn. I believe they said the CVA is increasing in numbers, but they all are those that require you to have additional training and testing. It's not a at-home exam that you just get your booklet and you pay your fee, right? You're going to have to actually go and pass a test. That's not easy to get any of those designations. The ASA is more not for necessarily testifying experts. They require that you submit a full written report that's like 70 pages long. Most of us in the family law space don't write written reports because our testimony is our written report. So for instance, I did all the ASA classes and passed the exams, except for the last part where you had to do the report, because I like numbers, I don't like words. I didn't want to have to write a 70-page paper. But any of those are good designations.
Well, and then we have the CDFA, which is something that is a little bit more, my understanding, a little bit, you have less requirements in terms of being a CPA or taking a certain number of continuing ed hours to be able to get that designation. I have run into that designation, and I know Sherry can talk to it more intelligently. I'll just say from my experience, people with this designation, I've worked with them in collaborative cases. They tend to be able to kind of work more individually with the party and talk to them more almost as like a financial planner kind of way, as opposed to coming in and talking about tax implications, business valuations, things like that.
Yes, so it's a certified divorce financial analyst. So it's more, I view it as more as people, like a lot of the financial planners may get it because they're looking to get in during the divorce and give advice and then work with the client after the divorce. I have always avoided that because I think it would affect my ability to be a voice of my own opinion and not an advocate for my client if I were trying to get work after the divorce. But there are people who have that, and it's in general good training. You just need to think of the designations when you're hiring someone.
That's right. I think of CDFAs more as very, client focused, whereas opposed to these other designations, I'm thinking of them more as how am I going to utilize them as part of my case, as part of the buildup of my case, as part of my trial strategy. CDFA, I'm more looking at as part of perhaps my team to talk to my client, to help them feel more comfortable about what could happen after the case is over, help them see some projections after the fact, kind of what they're going to be able to live off of, perhaps help them with their budgets, things like that. So not necessarily like we've been talking about, like a CPA might get into, like we've got a case with Sherry right now talking about unrealized capital gains, right? That's something that a CPA is going to come in and help with as opposed to someone like a CDFA. Which helps bring us to our next point, which is really when do you engage a financial expert and what do they do? What do they help with? And certainly, again, Sherry can talk more about how the sausage is made here when she talks about what the experts do for us. But certainly, they can do a range of things for us. Anytime numbers come into play, I love to be able to just heap that over to my financial expert and say, hey, make this make sense for me, right? So anything from a marital balance sheet, which is going to be hugely important throughout your case in terms of determining what's equitable division, what makes the most sense for your client, what kind of assets are we looking to split? If I have a bunch of IRAs and couple 401ks. I'd love to just split those IRAs. That's going to be a lot easier. But again, depending on who I represent, I might want to hold on to those IRAs. And again, your expert can help putting those marital balance sheets together. Again, there's also our DERFAs, our domestic relations financial affidavits. That is certainly something that your experts can help with. Because in a lot of instances, say we do have a closely held business, finding out what your client's true income is not always the easiest answer. They're not necessarily W-2 employees. And Sherry can certainly speak to more about how that can play out.
So I always say financial experts handle all the financial aspects of a case, with the exception of we don't value real estate. So you're going to need a real estate appraiser, and we don't value personal property for the most part. We'll go pull a Kelley Blue Book. I come from, we might know information about certain things or have had experiences with jewelers we can recommend for jewelry or that type of thing, but we don't testify about those values. What we do is pretty much all of the components of your domestic relations financial affidavit. So from the start, we can assist with the income. That's W-2 income, pass-through entity income, all of those aspects. We look at averages. We consider, taxable wages aren't necessarily the wages that were received, because if they contributed to a 401k, they're not in those taxable wages. So you can't just pull that number of taxable wages off the tax return. You actually need to look at the pay statements and the W-2s. Businesses may be showing losses, but they may be getting distributions. So we need to understand why that is happening, or looking at the income from equity awards versus regular wages and bonuses, things of that nature. So on the income side, a big part of what we do is what we call an income analysis, where we get into the details. We spread that for 5 years to help y'all come up with the numbers on that income section of a financial affidavit. We also do spending analysis. So sometimes our clients don't know what they spend. So we try to help them figure that out. In really big cases, we may actually take a year worth of information and analyze that spending. Under that spending analysis, we may also do dissipation. Excuse my language, I call it sometimes the hookers and whores analysis, right? You go in, you got to figure out what they spent on things they shouldn't have been spending on. We've done it for gambling. We've done it. One time I had to add up how much somebody spent at Starbucks in a year because they had a Starbucks habit. Not my proudest moment, but I was asked to do it, so I did it. So there's a lot of different things that we look at for that spending analysis, both for the expenses and for your arguments of dissipation. And then finally, the marital balance sheet, which to me is kind of, that's the big part of our work. Under that marital balance sheet, other than, cash accounts and securities, are things like valuing pensions, valuing equity awards, understanding the marital versus separate property. So we trace those assets to know what needs to go in a marital source of funds column and a separate source of funds column. And then business valuations, which is a whole other exhaustive process where we look at that business. And then if that business existed at the date of marriage, we're going to have to go in and do an active passive analysis of how much of the appreciation of that business is going to be considered marital and how much of it is going to be considered separate. But it all flows back to that domestic relations financial affidavit.
That's right. And I'm excited next time that you testify or we get to talk about the hookers and whores analysis.
Yeah, it's a good time.
That will be fun for the court.
My staff knows the ATM machines in every strip club in Atlanta. So if you have a question, we've identified them.
That's right. And truly, if you can Google, we'll turn them up. If you see some ATMs and you're not sure where they come from, throw them in Google, you'd be shocked.
Yeah.
Where those are coming from. And so one other thing that you want to keep in mind as well when you're engaging a financial expert to assist on your case is, how am I utilizing this financial expert? Are we just talking about litigation strategy in the background, or is this going to be a testifying expert, right, who's going to ultimately potentially end up in trial and testifying for you? So in those situations, certainly you're going to want to find someone with that experience, right? There are lots of financial experts out there who have these designations, but who may not have this trial courtroom experience. And certainly, as many of us have been in the courtroom, things can seem really good outside of the courtroom, but that person gets up on the stand and all of a sudden everything's tends to or starts to kind of crumble and fall apart. So perhaps you're going to want to find a financial expert who, even if they haven't testified, perhaps they're working for one or they have a mentor who've certainly who has had that experience and can assist them with that. And that's something you really want to keep in mind because you may even shift them during the litigation, right? I'm going to identify them now, but not necessarily as a testifying expert, or perhaps I'm going to amend my interrogatory responses later to identify them as a testifying expert. So it's good, in my opinion, frankly, to have one person from the beginning who can take on those dual roles so that you're not having to necessarily switch and have a new expert come up to speed. So ideally, from my position as a litigator, I'm thinking about somebody, worst case scenario, we're going to end up in court. I always hope to settle my cases, but we're going to end up in court. And so I certainly want someone who can be prepared to end up in that situation, which plays into one of these topics that is a really hot topic these days, which is something called hot tubbing experts, which Sherry can certainly speak to, as she spoke on it in a bathrobe last year.
Yeah.
To really drive home the point of hot
Another proud
tubbing.
moment, another proud moment.
And so hot tubbing is a way, it's actually, I think it originated in Australia.
Yeah, their court system uses it, actually.
And it's a very interesting concept that is starting to come into play more in the US through arbitrations of having your experts testify essentially together. And Sherry was telling me as we were preparing for this about an experience where they quite literally did this and kind of volleyed back and forth. And I'd love if you wouldn't mind talking to them about that experience and kind of how it worked. Because it's fascinating to me as well. I know the concept, but I can't say that I have ever actually used it before. It's just starting to really gain traction here.
Okay, and just so y'all know, I've thrown out, we should call it bar stooling, because I think that's a much better word for it than hot tubbing and the visuals, but
I think more people will be more comfortable with that too than the idea of jumping into the hot tub with your opposing expert.
But so I actually hot tubbed or bar stooled last Wednesday. So we had an arbitration in front of Judge Boterford. He had mediated the case. The other expert and I, our values, we had kind of brought our values in line, but we couldn't bridge that last gap of agreeing to a number. So we went before Judge Boterford. We sat next to each other like this, and the attorneys that we had hired us asked us questions. He asked us questions. We asked each other questions. We could kind of get to the meat of it. Because oftentimes, once you get to that point, the attorneys may not know how to dig into what affects the marketability discount on a business, a technical issue, or what affects our capitalization rate, a technical issue. The other expert and I can break through that really quickly and get to the meat of it so the judge can understand. I was arguing there shouldn't be a marketability discount because my client owned 100%. It was a veterinarian practice. Those sell all the time. They're highly marketable. The other expert didn't agree. She made her points, but we didn't have to go through somebody trying to figure out the right question to get there. So it's much more efficient, and we can really help the trier of fact understand the issue so that they can ultimately make the decision. My guess is he's going to split the difference because he respects us both, but it does help us to get quickly to the meat of the issue and cuts down on the time that is required, especially in an arbitration situation.
And so I'm curious, if you don't mind, to expound upon a little bit, what were the lawyers doing while you were doing that?
So the attorneys initially asked us each questions, and honestly, then they just kind of sat back, and the expert and I went back and forth, and then Judge Boterford would say, "What about this?" But it was really just us having a conversation, and she would say, "I think this," and I'm like, "Well, I get that, but what about this?" So it was kind of like a debate, right? But it gets to the heart of the matter, is more efficient. What William and I talked about is, though, before you agree to do that, make sure you think your expert can do it, right? Because if you have a really strong expert and you have an expert perhaps who isn't as strong or isn't as vocal, right? Then they might get railroaded, right? So you really need to understand. And the judge asked, they agreed to do this before we got to that situation. But it does have its risks. But if you have two well-qualified, well-experienced experts, say you've worked with both of them and they can each hold their own, then I do find it very effective.
You certainly want to make sure that you have the right personalities as well for this. When Sherry and I were discussing it, my mind, of course, went to worst case scenarios. And Sherry was talking to me about how, of course, reasonable minds can differ and we're professionals, we can keep things professional. Of course, lawyers, reasonable minds differ all the time. I can't imagine, I can think of a lot of lawyers off the top of my head. I wouldn't necessarily want squaring off against each other and to keep it civil, frankly, right? So you're going to want to find some experts who I think work well together, who know each other, who have worked together in the past, because you do run some risk of, as the lawyers, my concern would be, that's my witness, and I have no control over what is happening right now up there, right? And as a litigator, that's like my biggest fear, right? Don't ever ask a question you don't know the answer to. Well, imagine having your expert just go up there and, all right, well, y'all just talk it out, right? That scares me a lot. However, if you know your expert, if you know your opposing expert, then you can have a lot of confidence in it, because truthfully, they can speak to the court and to each other in a much more intelligent way than likely we could get out by sometimes asking the questions. Sherry's a wonderful testifying expert because a lot of her answers start with, well, I think what you're asking me is, right? And then she can just basically say it in a more intelligent way and give the answer that I was probably trying to evoke in the first place, right? So it is really a wonderful tool if you have the right fit for it. Again, this is something we're looking at more for arbitrations, because candidly, under the Georgia Evidence Code, under the Civil Practice Act, I'm not so sure it would really stand up in an actual trial court. Now, there are some similar ways that people are trying it, like having the experts testify back to back and things like that, not necessarily going out of turn when it's the plaintiff's or the defendant's case. And that's one way things can work, and it's perhaps helpful for the court. But really, truly, Barstool, we're going to rebrand it here today to Barstool, you're going to really have to be in an arbitration setting. Because as Jamie mentioned, I do appellate work, and my head might pop off if I got a transcript with two witnesses talking to each other in a trial court and what I'm supposed to do with that on appeal. So certainly it's something that we're trying in arbitrations. And I think because these arbitrations, we can really create the rules for these families, for these individuals. It's a really wonderful thing to allow these experts to be experts and to really educate everyone in the room, which is what we have them for. I want to make sure Jamie gets back on track from a timing perspective. Oh,
Okay.
5 whole minutes.
Yeah.
Amazing.
You want to do the tips or questions? Do the tips quickly,
Well, do
maybe?
y'all have questions? Okay, tips it is.
Okay, awesome.
Oh, we do have one question.
I stocks that was marital because it was for past performance. And it was like a couple of $1 billion, but it was not divisible by the company. So what we were able to do was to offset it because they had a lien imposed that we just gave to the home. So what do you do when you have something that's a marital asset that's not divisible, but you don't have anything to offset?
Well, so in the instance of stock, right, if it's not vested and it can be divided once it's vested, in Georgia, we typically do what's called if, as, and when. So as that stock vests, then we divide it, and it's held kind of in what we call a constructive trust. So it's held for the client's benefit that isn't the employee. They get the rights to whatever happens to that stock when it happens. If not, then, there's payouts over time. You find other assets, other ways to do it.
That's exactly right. I've run into a situation recently where these employees were given big grants of stock that did vest, but it was not a publicly traded company. So the employees really couldn't do anything with it. Occasionally there would be a round of funding and some employees would get to sell some of their stocks, but they were pretty limited. So in that case, we do have what Sherry called this constructive trust, where essentially the employee spouse is acting almost in a fiduciary role for their former spouse. So that when they have that next round of funding and when they can sell those assets, they have a duty to then get in touch with their former spouse, let them know what's happening, and then divide it once they get it in as was agreed to or ordered perhaps.
All right, you want to,
Jump into some hot tips?
Yep.
Of course. Well, one of the first tips is certainly, and I think I mentioned this, is involve the expert at the beginning, right? If you have consulted with the client, you know you've got some complex assets, or you know you're going to have some issues with income, or there's some premarital property, right? We hear that a lot. Well, I already had X amount of dollars in my retirement or my bank account or my brokerage account before we got married. Isn't that mine? Right? Well, those are the cues that you're going to want to go ahead and get an expert involved from the beginning. And that also allows your expert to get with the client, get up to speed, and then you've got them abreast of the entire case the whole time, instead of bringing them in later and really trying to triage them, get them up to speed.
okay, I'll take number 2.
Sure.
Okay, unless you are an expert at Excel, be very careful running your own marital balance sheet. So there's, all too often, even from experienced, attorneys with accounting degrees, sometimes I'll get their marital balance sheet and it doesn't balance, which kind of violates the whole point of the marital balance sheet. So, just a pro tip, make sure when you're putting those numbers down, you go back and have somebody add them and check them. If you're not using an expert, because there's nothing worse than settling a case and realizing there were adding errors on that marital balance sheet.
That's right. I have personally run into that before when I pretended to be an expert in Excel. Now, one of the other tips is to really think of your expert holistically, right, and comprehensively, that you want them to help with the entirety of your side of the case, assuming that they have the experience and the credentials to do so, which ideally they will. For example, you wouldn't necessarily want your business expert, your financial expert, to only value the business and not necessarily be able to lay eyes on anything else in your case. For example, if we have income as an issue and we have an expert who's valuing a business, turns out the business is worth a healthy 7 figures, and then I have a tax return, of course, that says somebody's making $35,000 a year or showing losses year over year, right? I've got an expert who really hasn't helped me with the entire case, and I've kind of pigeonholed them to staying here on the business valuation. And I've really set them up in a bad way if they're going to testify, if I haven't really brought them in on the income side of things, or perhaps I'm taking a position on the income side of things that is not going to jive with their business valuation, right? So you're going to want them to be able to speak intelligently about the entirety of the estate, the entirety of your case, including income, expenses, dissipation, and the like, so that you're really setting your expert up for success when we ultimately get to that moment of being in court. Hopefully not, but if we do, we prepare for it. Hopefully get to that moment of being in court, we've set your expert up for success to support the entirety of your case.
Right, and I'll just add on to that, and I think we're out of time, but the key thing is there may be assets in that business that we've considered in the business valuation that should or should not be on the marital balance sheet. So sometimes there'll be a building in the business and we've considered it part of the value of the business, and then it gets duplicated on the marital balance sheet. And so unless you talked and understood, then you can have a double dip of that asset. So everybody needs to make sure we know where all the parts are and where they flow.
Thank you all.
so
Thank-
much.
Mhm.
All right, we're going to move on to our next session, and don't worry that we fallen behind a few minutes. We'll make it up over lunch, so I promise I'm not going to keep you guys late at the end of the day. Our next session, you all can go ahead and come on up here, is maintaining professionalism in highly contested cases. And I think you all don't have okay. Do we? Yes, we actually do have a break. Thank you, because I wasn't looking at that. Yes, we have a break. Sorry. Go ahead and take your break, and then I will introduce everybody. Hey, thanks so much for being here. Hi, I'm Jamie Perez. Nice to meet you. Oh, sorry.
No, it's me.
Okay.
I just want to make sure I can shake your hand. Where do you want us, Jamie?
Oh, right over here, and I will set these up. I think because it's a break, yeah, Charlie's been waiting in the wings, and I was like,
Yes, I'm coming to
no,
change.
you're fine.
change them
I
out.
just, didn't have my agenda pulled up at the time. So we're gonna switch these out and, you can all sit over here.
All right.
Do you have a preference
Sounds
in
good.
how you sit compared to them? Do you want to sit on this
I'll
side?
sit on the side 'cause I have
Okay.
legs.
Okay, so let me take this. Then do you guys have a preference in who's next? Don't care. Okay. Okay, Judge Benton, we'll put Judge Harris. Okay. Thank you, Eric, for letting me. know that.
And then you will be, so when we do these little vignettes, where will you?
She's gonna be over there. You can help me.
Oh, am I?
Yeah. I texted you and you didn't respond about that.
Okay,
I was
that's fine.
good for you.
You
That is
want me
fine.
to sit over?
Either way,
I get to be the non.
you're the nice.
No, that's fine, as
That
long as I have something I can.
Yeah, so they're all gay. They're all, that's.
No, I remember you texting me, but then I never had like.
I was like, she's my friend. She will tell me.
So what are all these white and all? of these?
They're, you're Jamie and.
Oh, there's three.
There's three of them. Yeah, we're.
You're Jamie and all of them. No, I got that. I got that. It's somebody who's just.
Mhm.
Do you have a plan for the summer?
Well, we have
okay.
a 40th anniversary coming up.
You want me to sit
And believe it or not,
I mean.
my husband likes to play golf. I actually enjoy watching it.
Uh-huh.
And
Thank you,
the
Elaine.
lottery to the open, they have a lottery
Oh, wow.
for tickets to the open.
Yeah.
Just like they do for the Masters.
Yeah.
And he won 2 tickets for Saturday.
Oh, wow.
So we're gonna go to Ireland for sure, and we're thinking because that's where the open is this year,
Yeah.
is in Ireland, so we're thinking maybe a
Somebody
few
else has
days there.
copies. Do you have copies?
I do,
Okay, perfect.
of course. Remember, I'm the straight A.
I know, but I have brought extra because I too am the straight A student,
I
so I
have
brought extras.
I have copies, I made notes, I mean, God, I'm hard to
Okay,
believe.
y'all.
Mainly it's because I forget where I was, but it was like, okay, this is really boring, I'm gonna do something else.
If not, I'm just gonna.
It was not.
Come up
Oh,
and help
that's
me.
fine.
In fact, I don't think he had said.
As long as it takes no,
No, it's all right there.
yeah, I'm good.
I will say,
Um,
other than being a pain to get to if you're in Cobb, and I'm not complaining.
in any
Stay with
breaks.
the office.
It's so
Yeah.
weird. I just had, like, I made this little run of show thing, but didn't build in
It's-
breaks in
Yeah.
it.
Yeah.
so-
Hotel.
See,
How are you?
Yeah.
Good, good to see you.
I just think it's
you
for
got it.
me.
Yeah.
All right, and so then I don't know how often. you
I
have
think
to be up
so.
here as
We've
a-
had very good attendance.
Holding this up.
Perfect.
Five, and then there's one,
And
and then.
the,
Should be good.
Yeah.
One time.
You guys.
I mean, I know
Nice
one
little
night
hour,
our food
so.
was, one night.
I'm
I
going
forget
to
which one it was.
Okay, thank you.
I remember it was like, wow, classic night, it was just like place.
And I have a.
Yeah,
I
I agree.
everybody
Food
that
has been
evaluation
I
now,
agree.
so it should
Yeah.
cover the professionalism.
I think I
Like,
told
I'll
them,
be
I'm
there
like,
about
the
eval over.
world, it was like so overcooked.
Oh,
So
yeah.
Hopefully we get that credit.
I mean, but still, better than a hotel.
Yeah, the hotel bar. I was like, this is just unbecoming for careers and to be in a hotel bar, like that's just gross. And I did move it back from 5:30 to 6.
That was very helpful.
That
to us.
was. I-
Those of us who work in the hinterlands.
Yeah.
5:30 was
It's a
just,
great
it
idea anyway.
never happened. I think the earliest I ever got there was 6:15. Okay.
Good.
Oh, well, what happened was, apparently the internet's down on top of everything else.
really?
Because
Yeah.
why not?
So how have you been?
We had, let's see, it was white sauces delivered.
We were trying to
28
figure, it's like, this is a really big
Friday.
group. And some of these
And
lawyers look
people
older,
supposedly had
so I'm trying to
7
think, are they new to family law? Are they desperate for CLE?
This is the placebo.
I wondered maybe
effect,
if-
so, like.
Okay, or I just wondered if they were desperate for CLE, because I think the
Just a little
deadline,
cough, cough.
coming up.
There's a couple of them out here.
Yeah. Like, we used to get white powder
Yeah.
delivered way back in the day when I was a prosecutor.
You're like,
And you're like, okay.
So. You know what, just in case, it'll be like me to have a coughing fit
Yeah,
and have
there you
nothing but
go.
coffee.
okay.
Very good to see you. I really like that jacket.
The other end that the Emory end that we did the joint meeting with, they
Right.
were so jealous. They were
Where do
like,
they meet?
they meet like at law firms and, you know, they don't
All
have
the
a meeting
verses that I
place.
got, yeah.
Yeah.
Boy, I bet they were jealous.
Yeah, they were just like, oh my God.
And I will tell you, me personally, not having a, what is it that we lost by going there? We lost the end of the year party, or we lost, whatever we lost, for
You
me
don't miss
personally, I don't miss it.
Either.
We
I
could
don't.
do an end of the year, just a party, but I'd rather have one less meeting
I would
and just
too.
have an open bar.
Yeah.
Cherokee won't let you do a, pay for drinks. You can't pay. You have to run everything through the member number.
Sure.
So I'm like, I will do I'd rather have an open bar and just forget the end of the year thing. People are busy in May anyway.
I was about to say, to me, Christmas in May, 2 months where I don't need another event to go to. I just don't.
No,
And I love y'all
March
to
to
death,
May
but I
is
just
like
don't.
A whirlwind for us.
it is.
Yeah,
Kids activities, but even
kids' activities, everybody's out there trying to get their court stuff done because everybody disappears over the summer,
Summer.
you know?
there's, but December with all the Christmas
Oh.
parties, especially judges have to go
Oh.
to, you know,
I-
every different group. It's like something all
Every
the
night.
time,
It's like
every night.
something
I can't
every
imagine.
night.
And I was like, no December, no May.
Nope,
Y'all can be mad if you want to be.
No, nobody, I
I'm
don't
not
think
doing
it
it.
was
anybody's
an
mad.
excellent decision as far as I'm concerned.
Agreed.
I mean, just, wow. I mean, we kill ourselves all day, every day. Just, we're done. So, anyway, we'll just get 5 good programs.
And that's it. And that's what people want to do.
Yes.
100%.
I also think the programs have been good.
Yeah.
You've been good this year.
Yeah.
Sure.
So anyway, since Nels is like, I'm up to my
Oh,
ears,
right.
learning my job, who should we pick?
Mhm.
Who should we ask?
Was Judge
Well, you could
Benson supposed to
ask
come
when
last year
you
and then
preside.
He did.
Oh, he did come?
He spoke.
Do you want to ask the new, you could ask the new presiding, because that's going to be, what's her face, Warren.
Sarah,
You
yes.
could ask
Sarah Warren would be good.
Warren, and you could ask, or maybe ask Warren and ask
Benson did
who'll be the presiding Board of Appeals.
There's somebody
Do they have a
before-
presiding?
Somebody couldn't come. I'll have to look back.
I don't know, but Card did, I mean, Card did speak one year,
Yes, I
but,
remember when Carson.
Sarah Warren's a good speaker. She's spoken to a group of me before and she was very good.
Board of Appeals have a
Is it rain out
presiding?
here, or is
I thought they would.
I don't know.
It's just people to see.
I've never seen
Oh, it's
that
not right.
title.
But maybe just Sarah. I mean, I was just trying to think if Sarah would have enough to say, or if it would be good to have two, you know?
What about illustration?
Yeah,
You guys talk about the legislation.
That's always a good point, and
Yes.
I always forget when I'm up here. That would be nice.
Yeah, yeah.
Yeah. repeat
Not a
that.
bad
Yeah,
thought.
definitely.
Thank you for reminding me to talk about the notary bill or whatever.
Well, let's, maybe illustration, it would be good to at least look and see what passed and see if there's family law stuff that was,
That would be worth him talking about.
yeah. Or, you know, there's nothing wrong with judges and lawyers building good relationships with those people downtown. Illustration might be a good, I mean, he might be a good one to go.
Maybe.
You know,
You just ponder it.
Yes,
If anybody does ask questions, I don't know if you're gonna open it up before, or like during or the end, but if somebody asks the question, will you repeat it?
Sure.
Somebody
Yes.
always forget these, and then like, they never kind of. So.
Yeah, good idea.
oh, is there not, there's not a pass around?
Yeah, so
Okay.
I'm gonna give feedback to the people in charge of that, but just moving forward.
Yes.
Now, are you planning when we get started? The only reason I was wondering is since our vignettes are staged a little bit, we're not gonna be able to see. Are you gonna
Oh,
be
yeah,
sitting
you
down
can-
here, do you?
Yes, she had offered, and I was like, you do
Yes,
whatever,
I
but
can
yes,
move over
move
here.
over.
If you guys prefer that, I have no problem.
Yeah,
So I'll
let's
move
do
over
that.
there.
Yeah.
Sounds
And then that way we're,
Yeah,
since
let's-
you and I are the judges, we're trying to kind of,
Perfect, that's a good idea.
Yeah.
You were right.
Eric and I are buddies.
You know, we
so,
go way back.
we tease
She'll
each
do.
other on the Eric I asked you.
Yeah,
if you
we're-
were over here.
My first family law job out of law school, Jamie and I worked together.
That's
And
fun.
with Tina and Gwen,
got each
Tina and
other's
Holland Roddenberry. All those years ago.
why have you been a lawyer?
They're both
And you
really
look so
good
young.
Yeah,
He's 12.
but my hair is graying. I'm like, come on, Gray, it'll age me a little bit.
It'll be there. You'll be there before you know it. You don't have to wish it.
12 years.
Oh, wow. Okay.
No,
Okay, so I think it's about time.
Yeah, so just keep pondering. Who you think?
yeah, I'll
Right
keep-
back to me.
Good.
okay, perfect.
Well, and the interesting thing is, the political landscape's gonna be real hot next year, because that'll be leading into 26.
Wonder if you could find, are there two legislators on opposite sides of the aisle who get along fairly well, who could both come speak as a duo? I don't know who that, I don't know enough to know. Brian Strickland does some family law.
Well, Chuck Abstration does, he's the floor leader.
Yeah. It would be, maybe somebody like Alana Parrott, maybe.
All right, everyone, we're going to go ahead and get started again, and
That's what.
hopefully stay back on track. This is the fourth session. I'll get to that in 1 second. I wanted to make sure you all know that an email came through, or you should have received an email from Charlie Smith. That includes an evaluation for today. It's really important to us that you fill that out so we can continue to improve this program for the future. And then it also included a link to the materials to the extent you didn't already have one. There's also a QR code at registration for those, but it's now in your email as well. So please keep an eye out for that. And when this is over, fill out that evaluation. We're going to move on to maintaining professionalism in highly contested cases. And I'm so excited about this panel. We have Judge Ann Harris out of the Cobb County Superior Court. She currently serves as the Chief Judge for the Cobb Judicial Circuit. She was first elected in 2014. She's a graduate of Vanderbilt Law School and is a former prosecutor. We have Judge Alice Benton with the Fulton County Superior Court. As many of you know, she joined the bench in 2024 and went straight to the family division, the best division. And she's a graduate of UGA School of Law, and she practiced family law for years, but was also a former prosecutor. So we've got a lot of good knowledge on professionalism from both civil and criminal here. And then Eric Chambers is a partner at Stern Edlin Graham. He also serves as a guardian ad litem and a parenting coordinator, right? You need to update that bio on the website. And he's a graduate of UGA School of Law as well. He serves on the Family Law Section Executive Committee. He's the head of the Legislative Subcommittee and is our legislative liaison for the current session. So I am going to pass it over to them to get started.
Thanks, Jamie. Thank you, Judge Harris and Judge Benton, for being here. Good morning. So yes, professionalism. For any of us who have practiced family law for any length of time, or really any law for that matter, we probably have some good experience with an unprofessional opposing counsel or even a pro se party on the other side. I often joke that lawyers have the reputation we do for a reason, right? There's a reason there are lawyer jokes, right? There are lawyer stereotypes, and it's generally because professional stereotypes come from a small subset of the professional population that cause the most heartburn, right? That cause the most grief, and then someone turns it into the latest meme, joke, or inappropriate saying about lawyers. So we are going to try to address some of those things that most get family law attorneys in trouble, we think. But why is it particularly challenging in family law to maintain professionalism? And in my paper that's in the materials, I really came up with two reasons that I think, and I'm going to get the judges' perspectives as well. The first is Gwen Holland, who is my first boss and mentor, told me that we often see really good people at their worst behavior, right? They're going through one of the most emotional experiences in their life. And sometimes that can lead them to try to hang on to any type of control that they have left. So entrenched ideas, unrealistic demands, distorted expectations all come with being in the middle of what they're going through when they come in through our front door. So we have a lot of expectations on us from our clients. The second is because of the personal nature of what we're dealing with, right? It can be a natural risk to take on the persona of our clients, right? What is important to them naturally becomes important to us. But also with that, sometimes their tone becomes our tone. And it can lead to the condescension, the demeaning language, the interruptions that this presentation is trying to help us avoid. So judges, I'm going to turn to you, Judge Harris, starting with you. Why do you think it's difficult in these cases to, particularly in contentious custody cases or high asset divorce cases, to maintain professionalism?
Well, first I echo what you said, the reasons that you gave. I also think sometimes, lawyers rightfully want to advocate for their clients, and they want to advocate to the best of their ability. And And so you have to be sensitive that your advocacy doesn't cross the line into all those things that we know constitute unprofessional behavior. So I think that's some of it as well, is you get so wrapped up in being the advocate for your client. And we'll touch on this a little bit later on. You still have to kind of step back and say, who's the judge that I'm dealing with? What are that judge's, tendencies? But you have to remember that you wear a couple of hats. You do have the advocacy role, but you also have the duty, for example, of candor to the tribunal and the duty of professionalism. And, sometimes you lose sight of that just in the advocacy aspect.
Judge Ben, what about you? You practiced family law before going on the bench, so you have both experiences.
Yes, and I think where people get drawn in is in the gaslighting of the opposing party or even the opposing counsel. And it's just not necessary. You can advocate for your client without the gaslighting and just the nasty letter writing. It's usually in a letter or an email, and it delights your client, but it enrages the other party and the other lawyer. And I've even had, and you can raise your hand, have you ever had an attorney call you and say, hey, I'm about to send you a really nasty letter. I'm sorry, but my client wanted me to send it. Anybody have the heads up phone call? Yeah. So, if you know that you gotta send that message to the attorney behind the scenes of, hey, this is them, not me, don't do it. There are ways to advocate strongly for your client or to let the other attorney know that there's been misbehavior by their client, or, advocate without the nastiness. And I think that it just really is demeaning to our profession. And in the end, it doesn't necessarily get them a better leg up in the litigation just by being nasty, because those letters are going to get attached at the end of the case in an attorney's fees motion, and it's going to be in front of a judge who's going to see the very ugly behavior. And it's not probably going to bode well for that attorney or the client who's just been very nasty in the litigation. So I would say, if you know better, then don't do it.
And if I could add one thing to that, judges, I hate to say it, but judges remember that kind of stuff. We remember the really good lawyers we have. We don't necessarily remember the average lawyers, and that's fine. But oh, excuse me, you don't want to be one of those lawyers where we see your name on the counter and we go, oh no. But we do remember the really bad behavior. And also judges talk. Y'all talk about us, we talk about y'all. So just remember that too.
With that, we're going to transition. We thought to keep it a little more fun for professionalism hour. We're going to do some scenarios. We're going to do a little acting up here for you, and then go over kind of what rules may be involved. And the other piece, in your materials, there are two documents. One is the lawyer's creed, a lawyer's creed I encourage you to take a look at. And then also the aspirational statement on professionalism that came from the Supreme Court of Georgia. We're going to be talking about those some as well as we go through, but those are important. As I was preparing this, I thought to myself, I really need to put those up on my wall and remember that for the hard days, or when I get one of those letters that I wish I had gotten a warning about before it came through. So we're going to get started, and Jamie has graciously offered to kind of play the other lawyer in each of these scenarios. So Judge Harris,
Lawyer, apparently.
the nice lawyer.
All right, so we're going to go ahead and call the case of Jane Doe versus John Doe. Ms. Perez, I understand we're here on your motion, so please go ahead.
Your Honor, thank you, and may it please the court. I have the privilege of representing Jane Doe, a devoted wife for 20 years and a
Yeah.
mother to the party's 3 beautiful children.
Oh, God.
Mr. Chambers,
Yes,
Is there-
Judge.
is there a problem, sir?
Oh, no problem, Your Honor, at least not other than that every word that's come out of Ms. Perez's mouth has been a total lie.
Mr. Chambers, she has made 2 fairly benign statements. I would ask, sir, that you be mindful,
Yes, Your Honor.
please, of how you
Yes.
present yourself in the courtroom. Now, Ms. Perez, if you'll go ahead.
Thank you, Your Honor. As an initial matter, Mr. Doe's brief in opposition of our motion fails to identify the Smith case that stands directly contrary to Mr. Doe's position. He provides no explanation. It also cites two cases that I cannot find at all, despite several Lexis searches. I tried to address this with Mr. Chambers, but I received no response to my handful of
Oh,
emails.
Mr. Chambers, please, that's enough. If you can control yourself, sir, were you familiar with the Smith case? If not, why not? And if so, why didn't you cite it?
Oh, of course I was familiar with it, Judge. Everyone knows the Smith case, but it doesn't help my client, so I wasn't gonna cite it.
And then she's represented that you cited cases that she was unable to find?
Well,
Did you
Your,
bring those cases with you today, sir? That would help her as well as the court?
well, Your Honor, I used ChatGPT to input those, okay? And so I'm confident they're there. They're there. I know they're there.
Okay, and Ms. Perez says that she raised these concerns to you? Did you bother looking them up before you submitted your response?
Well, of course I did, Your Honor, and I couldn't find them either, but I know they're there. ChatGPT said they were. All right,
Alrighty
in
then.
scene. So that's our first scenario. So
I was gonna say, can we tell who is on, was it mock trial or moot court in law school?
So judges, we're gonna go over what rules may I have violated in this particular scenario. So and Judge Benton, we'll start with you. If you want to give one, and then Judge Harris can do the same.
Okay, well, rule 1.1 competence, comment 5 talks about competent handling of a particular matter, and that includes adequate preparation. And the required attention and preparation are determined in part by what is at stake. I think that, should you be using chat, GPT? Should you research the law? Should you, if someone's brought it to your attention, they can't find cases, you shouldn't cite cases to the court that aren't there. And, also, if you have controlling law that's opposite your position or your fact scenario, you have a duty to acknowledge that to the court as well.
Judge Harris?
Well, and I was gonna say, just to elaborate on that point, and I mean, I think we can all see that, Rule 3.5 that talks about impartiality and decorum, his conduct, Eric's conduct was clearly disruptive. And of course, we see y'all, you're sitting right there in front of us. I didn't have the pleasure of actually seeing his conduct, but, you're not doing your clients any favors, as we've already talked about that. You're not doing your client any favors at all. Your client may be impressed with your histrionics, but I can assure you the court is not. And what you don't want, and I can tell you as judges, we try to be very objective in our evaluation of the motion and the response and who is correct under the law. But it's hard, you make it very hard for us to be completely objective if you're behaving in such a disrespectful manner. All other things being equal, if y'all both have valid arguments and you're behaving badly, that's not going to help you with your point. The other thing is, and I can remember when I was in practice, I used to feel like, well, why do I have to bring up contrary law? That's the other side's job. But you look much better as a lawyer. In addition to having a duty to bring it up, you look much more prepared and better as a lawyer if you bring it up and you distinguish it. If there's a tough case out there for you, figure out how to distinguish it. Figure out how to say it's factually not on point. Figure out how to say that, your case has something a little different in it that makes that case, it may make it relevant, but if you can figure out a way so that it's not dispositive. And certainly acknowledge, I like nothing better than when a lawyer says, I know we've got this case out here, but Judge, I'm asking you, respectfully, I think this is something where I'd ask you to think about, whether that law needs to be extended or whether there is a workaround. We really appreciate that. Because I can tell you at the end of the day, the last thing we want to do is write an order and it goes up and we get reversed. And it's like, why didn't somebody tell me about this? You know, we try to do our best, but we have a lot of hearings and a lot of orders. And so we depend on y'all to be effective advocates, which includes candor to the tribunal. So
Yeah, so the only other rule I would point out for today is Rule 4.1, truthfulness in statements to others. In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person, which obviously would include the court, right? If I knew those cases weren't there, but you know, when I went after, as soon as Jamie brought it up to me, I have an obligation to correct it, or at the very least to acknowledge that when I get into court with Judge Harris. Now, Judge Harris, my persona was obviously intended to be extreme, but have you observed kind of maybe to a lesser extent similar behavior? And if so, how do you address it from the bench, or do you address it from the bench?
I have not seen behavior that bad. You know, I think what I see more often than truly hostile behavior like that is I see a lawyer who just can't stop themselves from interrupting. You know, and I'm always very cautious to say, sir or ma'am, I'll hear from you in a minute. But it's distracting to the court if the other lawyer is making their point and you stand up, because standing up to me is prefatory to I'm about to interrupt. So interrupting is not helpful. If you do, I can tell you, I'm going to nicely say, I'll hear from you in a minute, but let opposing counsel finish. The other thing that I would suggest, and I picked this up, I didn't emulate him well enough, but I picked this up from a trial partner I had years ago when I was on that side of the bench. He was excellent at taking the temperature down in the room, which is wonderful for judges and frankly for the proceeding. If you can be the one that takes the temperature down, and what he would do, you know, after the histrionics from the other side, and, you know, as soon as the judge looked at me, he would looked at him, he would say, Judge, may I respond? And I mean, that just took the temperature way down, because now he's putting himself in the position of being polite to the court, polite to the other side. And that just, anything you can do to take the temperature down, I mean, that's going to affect how the court looks at you and how the court listens to you. The other thing is, you know, when you've got the other side that's just going on and on and on and being, you know, histrionic about a variety of things, I would say focus on the important stuff. If the other side is bringing up everything but the kitchen sink, you know, depend on your judge to kind of sort out the detritus, so to speak. You know, if you've got important points, you know, Judge, may I respond? The three things I would ask the court to focus on. And all of a sudden you've kind of totally switched it, because you've calmed things down. And then you've said, Judge, here's what's really important. You've kind of signposted it. Whereas, you know, the other side may have just been kind of foaming at the mouth. So, I mean, that's a couple of thoughts I have right off the bat.
Very good. Judge Ben?
I have seen that bad of behavior in the courtroom. It was on a criminal case. It was not civil. It was a murder case that was coming back to our court that someone had been convicted, and it came back on a habeas 17 years later.
Ugh.
They had been convicted originally of 2 life sentences plus 40, coming back to me, and we had about 20 criminal motions pending. And the prosecutor and the defense attorney had words and called each other names in open court, and it was very, very ugly. And they're both very good attorneys, but it got very personal between them. And I had to admonish them and tell them to stop. I felt like I was dealing with 5-year-olds. And that's just not a good look, right? So it's the only time I've seen anything like that since going on the bench. I know there are times where attorneys say things to each other kind of under their breath, but this was more than that. But judges notice, they see the eye rolls, they see the pettiness, all those kind of things. And judges do talk, and they do remember, you know, who has a pattern of that kind of behavior. So ask you all just to think about what you're doing because it matters. You know, behavior matters.
And what about if somebody really does misrepresent a legal or factual argument? What kind of impact does that have on the case moving forward once that's uncovered?
It adds to our work. It means you're not gonna get your orders quick because now we feel like we're gonna have to fly spec everything you send us. And again, the other thing is, we remember it. You know, if I get misled on something about the law, you know, we remember it. And it might not be, and when I say we remember it, I don't just mean it goes up and it gets reversed and it comes back and I go, ah. But, you know, we get in the back and, you know, we're having like this moment with our staff attorney where it's like, wait a minute, that was crazy. That is not the law. You know, sometimes somebody will say something so kind of out there and you're like, is that really the law? I mean, have I missed something? And again, you know, we talk with our staff attorney, it's like, wow. And you don't want that reputation. I mean, y'all, how many of y'all, because I know there's some older folks here, how many of y'all are young to the profession? I mean, you've been a lawyer a couple of years, or maybe you haven't been a trial attorney at all. Okay. And some of y'all have not been trial attorneys. When it comes to being a trial attorney, especially, and you're in court arguing, all you have is your reputation. Okay. You're not selling widgets. You're not getting salesman of the year because you hit your bonus marks or anything. All you have is your reputation. And it's sort of like when you start out as a freshman in college, and if your GPA is in the cellar and you struggle for the next 3.5 years to pull that GPA up, you know, if you start with a bad reputation, you're going to work a long time to get it back. So just remember that, because that's really important.
Judge Benton, anything to add?
I had one other unfortunate experience in court this year where we called a case in for trial and they said they had a conflict, that they were on trial in another county. So we called and checked, as we always do, and they were in fact not on trial in another
Yikes.
county. That case had been continued till December. So we set a contempt hearing for that attorney. And I used it as a teaching moment. They were contrite and sorry. They were very young, a new lawyer. It wasn't like somebody had been practicing 30 years that did it. And I just said, look, there are judges in my circuit, in my county, that would fine you or jail you for lying to the court. But I'm going to use this as a teaching moment. And don't do it again, because you ruin your reputation. And let's just reset the button. Let's just not do that again. Let's give it another chance. But yes, I'm going to remember that lawyer and probably just hope that that doesn't happen again, because they're probably not going to get the same grace a second time, right? But just know that as a general practice that we actually do check leaves.
Yep.
If we're looking for you to call your case in and you're saying you're somewhere else, we are going to be calling the other judge's office to find out where you are. And also, as a courtesy to the court, if you know you're going to be late because you're somewhere else in another court, just keep us updated as to where you are. And if you're going to be there, that's all we ask. Don't make us chase you down. I'm shocked at the number of cases we have where we're trying to find the lawyers versus y'all updating us. It's just common courtesy to say, hey, we're in Cobb County. We'll be there by 1 p.m. Okay, great. That's all I need to know.
Yeah. And oh, by the way, how about copy your opposing counsel on that email? That's even nicer, you know? I mean, so that everybody knows, because
Yeah.
again, the last thing we want to do is keep somebody, you know, sitting there on ice for 3 hours because we don't know where you are. And, you know, and then ultimately we have to continue it. I mean, it's just basic courtesy, you know?
Yeah. I've had judges from other courtrooms come in my courtroom looking for attorneys, because there's some that just are really notoriously bad about filing a leave or filing a conflict letter. And judges literally go looking for these attorneys that they're trying to get into trial. And it should not be like that. We need better practice out of the bar.
Yeah, absolutely. Just a couple other things I want to point out, both from the Lawyer's Creed and the aspirational statement, because I think these are things we can use, and keep in mind that when there are professional issues. It ultimately goes before the Supreme Court, and they're who put both of these pieces of information out. From a lawyer's creed, it says, "To the courts and other tribunals and to those who assist them, I offer respect, candor, and courtesy." So that's what the Supreme Court expects from, no matter how zealous of an advocate you want to be, the Supreme Court expects that to include respect, candor, and courtesy. And I will strive to do honor for the search for justice, it says. And then in the aspirational statement, it goes on to say that I will aspire to treat opposing counsel in a manner consistent with his or her professional obligations and consistency with the dignity for the search of justice. So just keep those in mind as you are being that zealous advocate, what our professional obligations require. And with that, we're going to move on to the scenario number 2. And Judge Benton's going to lead this one.
Ms. Perez, I understand we're here on your motion for injunction and a motion for attorney's fees. You can proceed.
Thank you, Your Honor. I have here a stack of emails from opposing counsel throughout the litigation that I would like to put on the record. In this
Oh,
one,
what are we, Ms. Perez, in kindergarten? You're going to run to the judge every time and tattletale on me?
Mr. Chambers, please don't interrupt Ms. Perez. You'll have your opportunity to respond. Ms. Perez, please continue.
Thank you, Your Honor. As I was saying, in this first email, he uses derogatory language towards me and my client. Here, he asked me if English is not my first language. Here, he tells me to F off. In this one, he tells me in all caps that he knows where I live and threatens my family.
Mr. Chambers, do you acknowledge that you sent these emails to opposing counsel?
Judge Benton, I was just being a zealous advocate for Mr. Doe, Your Honor. Sure, maybe I went over the top a few times, but as I said in my response to Ms. Perez's motion, I apologized and I told her I would stop.
Your Honor, I have never received an apology from Mr. Chambers for any of these communications, despite my numerous requests for him to stop. And I just received one such email from him yesterday, knowing we would be in front of you this morning.
Mr. Chambers, do you have proof of this alleged apology?
Your Honor, I'm sure I apologized at some point for something, but I'm having a hard time putting my finger on it at this particular moment. All right, NC. All right, those are all examples I pulled from a quick Google search of bad emails lawyers have sent. All of those examples came from real cases where lawyers have been criticized or punished for their behaviors, including suspension and disbarment that came from some of the behavior of these particular lawyers. So those are not things I made up. Those are real from across the country emails that we've seen. So again, turning to the judges, what are some of the rules that I may have violated in this scenario? Judge Benton, we'll start with you again.
Okay. Rule 3.1, meritorious claims and contentions. In the representation of a client, a lawyer should not take on the action on behalf of the client when the lawyer knows or when it is obvious that the action would serve merely to harass or maliciously injure another. And the advocate has a duty to use legal procedure to the fullest benefit of the client's cause, but also a duty not to abuse the legal procedure.
Judge Harris?
You know, we kind of get back to, and this is more from the lawyer's creed, but it talks about, I offer fairness, integrity, and civility. And what he offered was none of the above, you know, and particularly with regards to emails, to the point that I think, Eric, you made earlier, that those emails are going to come back to haunt you. But to give you an example, and this was, wow, this might have been pre-COVID. Y'all have that sense of, you know, time. It's like, was this actually before COVID? I think this may have actually been pre-COVID. And it was a lawyer who I knew was a zealous advocate and was usually very right on the law. And frankly, he knew, I mean, full disclosure, my background was not civil. It was criminal. I mean, he knew the intricacies of the Civil Procedure Code in a way that I will, God help me, probably never know. So I had a great deal of respect for him until I got an email, and it was literally Exhibit A. And to opposing counsel, he dropped the F-bomb twice, and opposing counsel represented the wife, and he used the C word. And and the first time I saw it was actually on the bench. And it was like for 5 minutes, I didn't even hear what he was saying because I was so horrified. And that's been years ago now. But you know what? When I think of that person, that's the first thing I think of is that email. So, and I would hope none of y'all would ever do that, but I mean, emails are just, they will come back to haunt you. And, you know, I know we all have that tendency, especially if you're working on something late at night and you're going on 4 cups of coffee and you got a hearing tomorrow, and then you run across something and you're like, unfreaking believable. And you want to fire off an email. I mean, don't press send, okay? Just let it sit there and think about it again at 6 o'clock in the morning after you've had a few hours sleep. And I mean, I hope I haven't been guilty of it as a judge, but I mean, you know, there are times, you know, we all have that email we want to send. Get up and walk away. Okay, walk away, even if it's just for 30 minutes or to walk around the block. Please walk away, okay? And then come back and read it again. And you may still need to send it, but maybe you rephrase it. Maybe you make it a little more polite. Maybe you don't make it quite so strident. I promise you, you will not regret rephrasing it after you've calmed down a little bit. But there's a much greater chance that you will regret hitting send, okay? I just, emails are just terrible.
Judge Benton, how do you define zealous advocacy in the realm of particularly family law, and how, you know, when lawyers use that to justify their behavior, have you heard that type of excuse before?
Well, I mean, there's zealous advocacy and then there's bullying and there's gaslighting and there, you know, you cross the line at some point. I think if you can back your arguments up with statutes or rules or standing orders or prior orders of the court, that there's been a violation of, you can marry the facts to a rule, you can advocate in that way. Your client has violated the temporary order in the following ways, A, B, C, and D. This is what I am hearing. Please respond. Let's do something to change this, or else we are going to have to go to the court on a contempt action. You know, please let us hear from you within 24 hours. If you can marry an order or a statute, a standing order, something that they have done to violate, you can back it up with a rule to sort of give some teeth to what you're saying versus just your client's an ass, or, you know, name calling or gaslighting or bullying somebody into a position, or just frankly, what I call just wasting money.
Right.
Because what action are you going to get out of it? I mean, what is the next step other than they get your letter and then they have to respond? You're just churning fees at that point. If you can't tie it to something rational, you know, an order or something like that, then do you really need to send it? You know, why are you doing this? And then that's when I think you've maybe crossed into the area of just harassment or gaslighting, or just because your client wants you to send something, you know?
Yeah, go ahead, Judge.
I was just gonna say, if I could add just a couple things to follow up on that. First, you know, as judges, we are incredibly busy, and y'all's case is very important to us, but we have, you know, a whole bunch of other domestic cases. And then at least if you're in Cobb, I got civil stuff and I got criminal stuff too. And so if you end up coming into court on a motion that you think is groundless, that's not gonna, you're not gonna endear yourself or your client to us. So, you know, take some of the responsibility for client control and don't come to us with something that you know doesn't stand a hope, and you don't have a really good basis for bringing it, you know. But the other thing I was going to mention was, and I know this is antithetical to us who are or were trial lawyers, but sometimes killing them with kindness can be great, because there's nothing more, there's nothing that enhances you in front of a judge. You know, if there's a discovery problem or something like that, if it's like, well, before I even sent a 6.4 letter, I did X, and here's the email. And even after I sent it, I still gave them extra time to respond, and here's that email. And I'm sitting there and I'm like, now I'm thinking in my head on the other side, what is wrong with you? You know, I mean, so there can be a big advantage to taking the high road when you do end up in court on it, because now it looks like you bent over backwards and did more than was necessary to try to get to the right result. And it's the other side that was just being a total horse's ass, you know?
Now, one thing I learned early in my career is that emails have really changed, obviously, everything, but particularly the practice of law, because it can be so easy to spout off that email. And if you can wait right? Have a delay on your response. I think a lot of times that will help with a lot of these oopsies. I shouldn't have sent that then ends up on Judge Harris or Judge Benton's desk. Another real practical tip I learned early in my career was to never refer to the opposing counsel, right, as you did this or you. You can bring the temperature down a lot by saying Mr. Doe. It is my understanding that Mr. Doe X, right? Because there's always probably 4 sides to every story. Your client's the other side, the truth, and the one the court's going to see, right? There's always 4 different sides of the story. So if you can preface it as this is what I've been told, essentially, right? Because we're not in these people's lives, right? We may have seen the nasty text message, but they may have cut off the text message they sent before that led to this message. And we'll get into this a little bit with the next scenario, but maintaining a level of skepticism in what your client is telling you is an extremely important part of this job, right? Of asking the question, can I see the text message you sent before she sent that one, right? And also, if we can keep in mind that our clients oftentimes, when they use Our Family Wizard, they have to install Tone Meter, right? I often think, I wish that lawyer would install Tone Meter on their emails, right? So that I could, so that they would have had a reminder before they sent it that that particular phrase or the way they said that to me was not respectful. I think we kind of keep Tone Meter in the back of our head, that can help a lot as well in kind of avoiding these email issues.
Oh, also, one final practice pointer. Please don't include our staff attorneys in your emails. I mean, that seems to happen.
Or us.
Well, definitely don't include us. But, when you loop our staff attorney into these emails that just go right off a cliff with ugliness and pettiness, I mean, I can't tell you how many times my staff attorney has said, I had to tell them, get me out of your email loop. Okay, that's the last thing you want to do. But I'm always surprised at the people who somehow the staff attorney ends up in the email chain. Ooh.
Anything else? Other points?
Just refrain from the exclamation points and the all bold and the all cap letters. I can remember one year at Family Law Institute, they put up on the screen some examples of emails that were particularly nasty that people had sent, and I recognized who the lawyer was in some of them. It didn't have names, those were cut off, but they were just using examples. But I knew who one of those came from because that was their style of speaking and writing, and charged a lot of money for those kind of emails, which is not funny, but just don't be that attorney. It's not good. It ruins your reputation.
All right, we're gonna move to scenario 3 now. Judge Harris.
Let's. Where's the, okay. All right. Thank you both for agreeing to a pretrial conference before we start the temporary hearing. Maybe y'all can each tell me a little bit about your client's positions, Mr. Perez.
Thank you, Your Honor.
I'm sorry.
I represent husband John Doe in this matter. This is a 30-year marriage. My client has been the primary breadwinner, and Mr. Chambers' client has been a stay-at-home wife and mom. My client is willing to pay a reasonable amount of alimony to Ms. Doe on a temporary basis and contribute to her attorney's fees.
Okay, that sounds promising. Is this something y'all think we could settle with a little bit of more time this morning?
Unfortunately, I don't think so. Mr. Chambers' client is seeking what would be the equivalent of 80% of my client's net income in alimony when the family has lived a modest lifestyle and her need is less than half of what she is requesting.
Okay, well, is there a dispute about Mr. Doe's income or Ms. Doe's need? Is that part of where y'all can't agree?
No, Your Honor, we have actually stipulated to my client's income, and we do not dispute Ms. Doe's stated need on her financial affidavit.
Mr. Chambers, is that true?
Yes, Your Honor, we don't dispute Mr. Doe's income, and it's my understanding he accepts my client's stated need.
Okay, well, I'm having a little bit of a hard time understanding why your client is seeking such a significant alimony award. Can you help me out a little bit?
It's Mr. Doe's conduct, Your Honor. Ms. Doe will testify about Mr. Doe's adultery, active drug use, and the dissipation of marital assets, and I believe her. She's a real sweet, honest lady, Your Honor.
Your Honor, that is simply not accurate. We have a clean drug test for Mr. Doe and evidence that Ms. Doe has been actively having an affair and sending money to her paramour in Europe.
Mr. Chambers.
I'd like an opportunity to speak to my client for a moment, Your Honor. All right. All right, Judge Harris, we'll start with you this time. What is some of the rules that may be addressed there if we went a little further?
Well, the first one that sticks out is Rule 1.1 that talks about competence, because competence really goes to more than just legal knowledge. Competence requires, this is a quote here, legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And then the comment, competent handling of a particular matter includes inquiry into and analysis of the factual and legal elements of the problem. It also includes adequate preparation. The required attention and preparation are determined in part by what's at stake. Major litigation, complex transactions ordinarily require more elaborate treatment than matters of lesser consequence. So, and at least for me, I'm kind of focusing, well, the legal knowledge I have a little bit of a question about, especially since we're here on a temporary. But the thoroughness and the preparation, that just really seem to be lacking.
Ben, anything to add there? Rules?
Yeah, Rule 3.1, meritorious claims and contentions, and action is frivolous if the client desires to have the action taken primarily for the purpose of harassing or maliciously injuring a person, or if the lawyer is unable either to make a good faith argument on the merits of the action taken or to support the action taken by a good faith argument for an extension, modification, or reversal of existing law. And I think we see that a lot, and Judge Harris was sort of alluding to that we see a lot of frivolous motions. People bring motions with no grounds for them. You really got to dig into your case and figure out, can you support it with the law and the facts? Because if you can't, you should not be in court. And it costs real people. These aren't corporations picking up the tab for these attorneys' fees. These are real people having to pay fees. And there are many judges, including myself, that are willing to award fees to attorneys. And it's particularly disappointing to see clients paying for bad lawyering.
Yeah, and I think a lot of this starts right from the very first consultation that we have with the client. Rule 2.1 reminds us that in addition to being zealous advocates, we are also advisors, right? We wear two hats in this. And so Rule 2.1 says, in representing a client, a lawyer shall exercise independent professional judgment and render candid advice. A lawyer should not be deterred from giving candid advice by the prospect that the advice will be unpalatable to the client. How often in this world particularly do we have to give our clients unpalatable advice? The reality is they're not going to get 100% of the estate, right? When they come and say, I want lifetime alimony, they're not probably going to get lifetime alimony. I mean, know your judge, and we'll talk a little bit about that in terms of what your alimony award might be, but that is our job, right? If a client says 100% of the estate, I'm going to say, you should probably go get a second and third opinion. And usually, hopefully they circle back to me and say, you're right, I'm not going to get 100% of the estate. Let's move forward. But if they don't, that's something I'm not going to go to court and ask for 100% of the estate, barring some significant wild circumstances of dissipation, right? That's because, again, my reputation, our reputation matters in this line of work. And if we go to court asking for something ridiculous, oftentimes it is because we didn't start by rendering advice early on, right? And so we oversell what we tell our clients we think we can get them. And then you go to the first temporary hearing, get knocked down a few peds, and the client's going, what happened, right? And it's because you couldn't give them the moon and the stars that they thought you could give.
Well, and in that vein, I heard a practitioner say one time, and I thought, oh, that's excellent. She said, if your lawyer is telling you, talking about the client, if your lawyer is telling you something you don't want to hear, that means that lawyer is working very hard for you, and it's probably worth reminding your clients if you're having one of those uncomfortable conversations, if you're telling them things they don't want to hear, you're really working hard for them. The other thing is, and I think Eric, you alluded to it a minute ago, you need to play devil's advocate with your client. The stuff here about, active drug use, she told me all this stuff and I believed her. Well, what's the other side going to say? You need to ask your client, what am I going to hear in response to this? Or, tell me how long the active drug use has been going on, because if it's a long, I mean, if they've been married 30 years, but if she starts with, well, you know, when I met him 30 years ago, it was really just a little bit of marijuana and occasionally cocaine, it's gonna be like, and so you married him anyway, you know? I mean, that's what we're gonna be thinking as a judge. So, and had 3 kids with him, to your point. Yeah. And the other thing too is, you know, this is a temporary, and, you know, there's a lot of judges, myself included, that it's like, I have limited time, and if we're here on a temporary, I don't have 3 hours to hear about the bad behavior. We can save that for the final if you can't work it out. But for example, if it's a 30-year marriage and there's active drug use, well, I'm thinking probably the kids are grown. So we're dealing with 2 adults. And so why do I care about that on a temporary, you know? Because there's not a safety issue involved with children. So, you know, just play devil's advocate with your client if they start telling you a bunch of, you know, stuff that may be true about the other side, but you know, what am I going to hear back? What's the other lawyer going to tell me? And, you know, just tell your client, I will hear it in court. If there's something that you don't want to come out, I'm telling you, it will come out. So you better tell me now when we can deal with it, you know, then I find out in court and I look like an idiot and the judge is looking at me and saying, really, Mr. Chambers, really? Yeah.
Is this enhanced when custody is at issue, right? This need to take reasonable versus taking unreasonable positions. How do you all view that when, particularly when there's custody involved and when we're looking at the best interest of the child?
I think that I haven't heard a lot of unreasonable positions, where it was just outrageous. Usually it's, a parent wanting to be involved and the other has gate kept the child, okay? Or they've both been involved, and how are we just gonna sort it all out? You know, what is the parenting plan gonna look like? Because they can't agree on some things about the parenting plan. I've never seen anything off the rails where like somebody wants sole custody and they had no basis for it. I feel like people generally can back up what they're arguing for. Where I think people make missteps or misjudge in custody cases is when they've had very bad co-parenting and very bad behavior, thinking that there might not be a shift in what's going to happen because they've been a bad actor, a really bad actor, and thinking that they're going to keep all of that power, and that may not continue. That's where I see the missteps with the lawyers and the parties of thinking that just because I've had complete control for the past 10 years, I should keep complete control. And that is not necessarily true.
Judge Harris, anything to add there?
You know, I just know in more than one case, when the parties are in front of me, especially early on, you know, I've had to tell them, y'all are about to get divorced. Life as you've been operating under for the last 10 years is going to change. You know, you're now going to be a single parent. So the finances are going to be really different. And, you know, it's those kinds of conversations. And sometimes I wonder if it just helps them to hear that from a judge. You know, the woman who was a stay-at-home mom for 10 years, I mean, she may, depending on the financial circumstances, she's probably going to need to find some kind of employment, you know, because that division of responsibilities that may have worked while they were married is just not going to work once they're split up. I'm trying to remember, because you said something that made me think, and it slipped my mind. I know, and this kind of goes back to the gatekeeping. You know, you may have a client who has been putting up with bad behavior for years. And I'll give an example. I don't think that lawyer's here.
Scan the room.
No. I mean, it wasn't terrible, but it wasn't helpful to the court. I think the husband probably was an alcoholic. He'd probably been an alcoholic for a number of years. I mean, there wasn't like, you know, there wasn't anything like, you know, he got a DUI with the kid in the car or anything like that, I don't think. But he had agreed, and this was early on in the case, he had agreed to SoberLink before his parenting time. And there was a contempt that was in front of me for his failure to comply with the temporary agreement with regards to the SoberLink. But when we got into court and I started seeing the exhibits, it was like he was 3 minutes late blowing into it. Or it was like he did it and it was 0.001 and he did it 30 minutes later and it was like 0.00001. It was just, it was really, to me, it was borderline ridiculous. And I'm sure the wife was sitting there thinking, see, this is what I mean. This is what I mean, because he's not living by the letter of it. But, you know, again, the reasonableness of your position. I mean, somebody that's 3 minutes late with a SoberLink, if they've got alcohol in their system, 3 minutes, it's not gonna make a difference. You know, it's just not. And so just counsel your client real carefully about what you need to go to court on, because, you know, at the end of the day, do I think dad was out there just semi sort of thumbing his nose at the rules? It's like, really, dude, you couldn't blow into it at, you know, you had to do it 32 minutes before your visitation instead of 29. So I didn't appreciate that behavior. But on the other hand, they asked for an hour and to argue about this kind of stuff. And I just felt kind of like we need a little bit of reasonableness here. And I know that can be a hard conversation to have with your client if she's or he has been putting up with this kind of behavior for years. But, you know.
I mean, I got to the point in my practice where I would not take a client if I thought they were going to be unreasonable. If the red flags went up, that they wanted an unreasonable position taken that was contrary to my advice, I would decline the case. But also I think once you're in the case, if something comes up and you know it's meritless, meaning there's no way they have an arguable position, I think you have an obligation to get out of the case. Help them find another lawyer rather than just abandoning them. I think you need to sit down and talk with them. I think you need to document your file as to why you're doing what you're doing and follow all the rules about, you know, help and substitute counsel, et cetera. I think there's right ways to handle that and wrong ways to handle it, but I think you can get really sideways with the court if you're bringing before the court frivolous actions and subject yourself to attorney's fees and your law firm, not just the client.
Right. And just a few more pieces on that I think kind of get missed on candor towards the tribunal with this, that in the scenario, I didn't know they had all this evidence. But sometimes we do when we try to hide, we try not to bring up the negative things. But there are a couple comments in Rule 3.3 that I think are important. Comment 3 says there are circumstances where failure to make a disclosure is the equivalent of an affirmative misrepresentation. So just be mindful of that. And then comment 8, and this is a partial quote from that, says, a lawyer's reasonable belief that evidence is false does not preclude its presentation to the trier of fact. A lawyer's knowledge that evidence is false, however, can be inferred from the circumstances, right? So it's not just that you absolutely had a knowledge that there was a misrepresentation being made, but that you could have or should have known can be inferred from the circumstances, I think. So in the last few minutes that we have, judges, I just want to ask one final question, then we'll see if we have a couple minutes for questions. The aspirational statement on professionalism identifies, quote, negative trends towards commercialization and loss of community in our profession. Is that something you've noticed? And if so, what trends or even just some examples that we haven't already gone over have you seen in terms of the loss of professionalism, particularly post-COVID? I've heard a lot of this gotten a lot worse in the last few years.
Yeah, Zoom was great, you know, when there was no alternative. But ultimately it has not helped things. I will tell you personally, the thing that I observe, and you know, this goes beyond just the courtroom or cases, is everybody seems to go from 0 to 60 in 2.8 seconds flat. And that is not helpful to the practice of law. And I mean, frankly, it's not helpful in your personal life either with your own personal relationships, but it's definitely not helpful with the court. I think there is such a tendency now, and I don't know to what extent it is a product of COVID and not having face-to-face interaction, but it's that almost like people are looking to take offense instead of taking what somebody says or what somebody writes and say, okay, maybe they didn't mean this the way it sounded. Let me give them the benefit of the doubt. It's almost like we've switched that presumption to saying, you know, I'm offended and I'm going to respond in kind. And I just find those two things to be unhelpful and disappointing in the way we interact with each other. Is just going from 0 to 60 and nothing flat and looking for offense as opposed to starting from the presumption of, I don't think they realize how this sounded, and trying to give each other the benefit of the doubt, you know?
Ben?
I would say Zoom really messed up lawyers because it got too casual. How people were dressed was inappropriate, and I include attorneys in that, were too inappropriately dressed for a court type situation. And distracting backgrounds and just
Cats.
ads and people walking through, or them looking off screen and maybe being coached. I mean, just all the things with Zoom. We've all seen it because we've all been on Zoom. That said, if there is evidence to be taken in my courtroom, I have you do it in person. I'm okay with calendar calls and those kind of things to be on Zoom because it's more convenient for people. You know, why come down to Fulton County Courthouse for 10 minutes announcement when you can do it on Zoom? That's fine. But if you're going to have a contested hearing, a temporary or a final hearing, let's do it in person, get all the witnesses there, and let's do it in the courtroom. That said, I think a lot of people have gotten lax on evidence rules.
Yes.
They've sort of forgotten the rules of evidence and they don't know how to make proper objections. So people need to brush up. I think people have gotten a little lax on being respectful to opposing counsel and to the court and to witnesses. Stand when you make an objection. Be courteous, ask when you can approach witnesses, just all the formality of how we treat court, I think needs to come back. And why is that? Because along with that is the civility and professionalism towards others. You know, check the pettiness at the door. I've had an attorney come in and brought a handwritten copy for everyone but opposing counsel.
Oh,
Okay, why, guys? That just slows us down. You know, just don't behave that way. You know, just don't talk over other people. Just be respectful and stand when you make your objections. Just all the things that what we think court should be needs to come back and actually be happening. There's a reason for that. Now there have been times where I've relaxed things if it's just the attorneys and maybe clients aren't there. I've said you can be seated at table. You know, you don't have to jump up and down when it's just counsel and me. But if you're in a final trial, it needs to feel like a formal final trial, because guess what? When it goes up on appeal, they're gonna be looking for the formality. Did you object on time? Did you make a legal proper objection? Did you put in the proper evidence for your attorney's fees? You know, all of those things, the Court of Appeals and the Supreme Court are not going to relax for you. So people need to get back in the habit of properly putting in evidence, properly making objections, and acting like it's a real trial and not just a Zoom hearing.
Perfect. Well, Jamie just gave my 1 minute sign about a minute ago, so we're going to go ahead and wrap up. But I just want to give a big shout out and thank you to Judge Ben and Judge Harris for being with us today. Thank you. Thanks,
Thank you
Jamie.
so much.
Yes, thank you.
Good job.
hope it was helpful. Yeah. Or you're.
Yeah.
The Latin word?
The dramatic.
Dramatist or something.
I did start laughing.
I know. It's so contrary to.
Oh, all right, did you get your purse? I don't want you to leave something.
Not my purse, not my coat. Got all my stuff.
Off to my hearing.
So much for taking time.
Thank y'all
out of
for-
your
yes.
schedule.
See you later.
All right, we'll get started with our next presentation. Ashley and Tori, if you want to make your way up here. Our next session is on guardians ad litem. And we have Ashley Wine and Tori White, who are both very experienced guardians. Ashley is with Wine Family Law, owner and founder, and is a graduate of Stetson University College of Law. And Tori is owner and founder of Tori White Legal Group and a graduate of John Marshall Law School. So thank you. Welcome, ladies.
We just have they have the materials, right? All right, morning. We are going to be talking to you about guardians and really focusing on how to effectively use them in your different cases. We have come up with kind of a do's and don'ts list and want to talk through the different ways that we think that you can be more effective in making sure that the guardians have the information that they need and that that information is really then kind of trickling down to the court in the way that it needs to be handled. Give me 1 second. Okay. One of the first things that I have really started to notice in getting to sit into more and more of these final hearings is I think that there is an issue with these cases, especially these custody cases that go on for literally years at a time, 2, 3, 4 years. And the animosity and the conflict and the issues that are going on in that case then translating into a courtroom. And I think that attorneys need to be focusing on how do they get the information to the guardian and how are they able to use the guardian so that the court can have kind of the same lived experience that the attorneys and the parties and everyone involved in the case has had during that period of time. Because when you end up in front of court, you really only get the court's attention maybe a couple of hours, maybe a couple of days, but you're talking about years and years of these children's lives, these parties' experience. And I think it's not translating in the way that I think many people think that it is. So starting at the beginning of the case, I personally think, and I think Tori does as well, that it's really important for the attorneys to get on the phone and there to be kind of an attorney and guardian phone call, making sure that the attorney is really having a clear understanding of what the issues are in the case, what the procedural history is, and doing this before you get into this first meeting with the client. It lays the groundwork, it helps set expectations, and I think lawyer to lawyer, you can really cover a lot more ground that then will save time when the person actually comes in. The other thing that I think that attorneys could really do a much better job of kind of managing and handling with the guardian is making sure from the onset that the expectations are clear about deadlines, mediations, hearings, anything that may impact the timeline in that case. So if you're starting a case and the issue is where is the child going to school next year, making sure that at the very beginning, the guardian ad litem understands that we need to have some sort of resolution or recommendation on this issue by this particular date and time. And I think sometimes that gets missed or lost in translation or things get kind of conflated. And I think trying to do what you can to focus on the main issues is really important. I also think that sometimes it's good for just the attorneys to be on the phone and for the client to not have to be a part of every single part of the process. I know that you need to be advocating for your client, and I think it's really important for you to make sure that they understand that you are strongly advocating for them, but they don't have to be a part of every single phone call. I will say the one thing, we kind of did this as a joking don't call the guardian and tell them how to handle the case. So you sometimes get these phone calls from the attorneys and they're like, you need to do this, this, and this, and you need to do this at this point in time. It is certainly appropriate for you to suggest or to have certain things in mind, or for you if you think that there are certain things that need to be investigated or looked into. But I think sometimes people come in, I would say a little hot, and kind of want to tell you how to run the case. And then they get frustrated or disappointed if they don't think that you're handling things in the exact way that they want them to be handled. And so I think managing all of those expectations and getting on the same page about that is really important from the get-go.
Which is a great segue. I wanted to back up just a moment and share as a primer, as an initial phone call, before you even engage the guardian, have a really a thorough discussion with the prospective guardians that you and opposing counsel are considering. Does your case need a guardian? I'm probably, it's a self-defeating next position, considering that I do primarily guardian work, but not all custody cases need a guardian ad litem. And we see a lot of, Ashley and I were discussing a lot of cases where it's a poor dynamic, which is certainly something that is imposing on the child, but we are attorneys, and in your role of advocacy, you can certainly present that case and frame it to the judge adequately without the guardian ad litem. Now, certainly there are reasonable strategies, perhaps evidentiary strategies that would guide you to using a guardian and making your case presentable, if you will. But from the outset, I'd like to know that in my primer phone call before we even are engaged.
Absolutely. Tori, why don't you talk to us a little bit about the initial guardian ad litem meeting and how to make that most effective?
Excellent. Before the meeting, it's so important that I have the pleadings in the case, that's the instant case as well as the preceding cases. Oftentimes we are guardians in modifications or perhaps contempt petitions, et cetera, where custody may be an issue. I need to know what the basis of the case, the instant case certainly, but also those previous cases. It is hard, and it's getting harder these days. Everyone knows the stories about the clerk's offices and Odyssey and Peach Court and how they never cooperate with you. But the more information I can have before that preliminary meeting, the better it is. Because unfortunately, that cost, we pass it on to your client. So the more legwork you can do initially is super important. Important and in terms of preparation for that meeting, this is not the only time that your client will be able to speak to myself or Ashley. In fact, it will be one of many meetings. And so if they know that from the beginning, there's not as much hesitancy going into the meeting, and they don't feel that they need to get their entire story out in one fell swoop. So preliminarily, share that you will be able to speak with the guardian as often as you need to about any concerns that may pop up. But that initial meeting is just to give us a lens about what the parent feels about the child, the lens about where they want to go and what they want to happen, and then certainly a background, right? A background about how they got there. I don't need to know the Jerry Springer context necessarily, but were they even a couple? Is there foundation for their relationship? Those are important little tidbits for Ashley and I to take into consideration before we get started with that preliminary meeting. I host most of my initial meetings on Zoom for convenience primarily, but it doesn't have to be. I'm certainly happy to have folks in the office. And that's something that you want to share with your client. If they prefer to meet in person, just tell me and I can make arrangements to do that. I've worked with Ashley several times as a guardian, and in her litigation cases, most of the time, I think, Ashley, you attend the meetings with the guardian and the client. And I love it because I get the procedural landscape from Ashley, a little bit of the nuances that her client will inevitably overlook. And it's a management, if you will, right? And so I enjoy when attorneys join us on meetings, but it's certainly not a requirement. But if that's something that you think would be helpful to facilitate this meeting as an advocate, just ask me. It's not something that I volunteer when I schedule that initial meeting, however. Also make sure that they have an outline and a timeline of important events, and critical mass, where they want to go. They don't need to know the language necessarily, joint custody, legal custody, physical custody, but an idea about what they want their family to look like moving forward, so that I can encapsulate that and help draft an eventual parenting plan.
I think the big thing is just really making sure that the preparation is done ahead of time, making sure that they understand the purpose of this meeting, making sure that they understand that they may be talking about things not just about what's going on in this case. And I think doing the legwork ahead of time is really going to help streamline that meeting and make it effective, cost effective, and set you up for success throughout the entire litigation, because then you have kind of a roadmap of all of the things that need to be focused on. One of the things that I wanted to bring up, and I think it's kind of an old school thing, but things that also people still continue to do, is the guardian ad litem notebook. So I kind of think about it back in the day, and there are still firms that do this, where you're like served with this like 4-inch 3-ring binder that is just full of what these people think is like the most important information on the case. I think it's very important to get to the guardian the collateral information that is important. I think the medical records, or signing the releases for them to get the medical records, if you have certified copies of police reports, if you have report cards, if you have certain correspondence. But I personally do not find the guardian ad litem notebooks that are kind of inundated with this snapshot of just the way that you want your client to be pictured are very helpful in the guardian ad litem process. Because what it makes me do typically is piques my curiosity of like, well, where's the rest of the conversation? Where are the other Our Family Wizard messages? What's the other side of this look like? Because it doesn't provide the complete picture. I think if you are going to provide these sorts of things to the guardian, providing them completeness and then providing them in a way that I think highlights the things that you want them to highlight while still allowing the guardian to look at things in their totality is more effective. I would certainly say, do not delay the scheduling of your initial guardian ad litem meeting to do these notebooks. I think, as Tori said, getting the background information, getting pleadings, which at this point in time certainly should all be sent over electronically, I think are very helpful. But waiting for you to have this total notebook to go through, it is likely an unrealistic expectation that the guardian is going to have an opportunity to review that, nor do you necessarily want them to review that when they really haven't gotten kind of their feet on the ground on the case. Pictures, I hate to even have to talk about this. Pictures are great. I think it's really sweet to be able to see the children who you're going to be meeting and to see some pictures. A couple. I do not need a notebook of every vacation, every birthday party, it really just doesn't, I think, sway the needle in any way, shape, or form. I think also knowing your guardian and inquiring as to whether they want things paper or electronic. Different people kind of process and review things in different ways. And I think presenting the information in the way that the guardian is going to be most receptive to it is going to be the most beneficial to you. Also knowing that you don't have to provide things in this like one lump sum, and this is the way you get the information to the guardian and there's no other way to process it. I actually find it to be pretty helpful to kind of get these chunks throughout the case, especially if it's related to something that's going on. So if we have something that comes up that's like a particular medical issue, and then I get, okay, here's this medical issue, but here's some other documentation that shows the history, it allows me to kind of process and compartmentalize a little bit better than just kind of getting a data dump. Yeah. Do you have anything else to add?
I'm a stickler, and this is just after so long, you figure out a way to work. I'm a stickler for when you share things with me, either electronically or in a hard copy, ask your guardian first their preferences. I know a lot of folks use Dropbox. In our office, we use ShareFile. If you think about it, I have many cases, and if I have multitudes of ways of sharing information with me, we could never keep up. And we're very strict about the way that we receive information. So we want that phone call in that initial phone call. And I will share with you, we exclusively use ShareFile. And if you have it on Dropbox, that's fine, but we will convert it to ShareFile and we'll add you to the folder. And that goes for the notebooks as well, because we only have so much space and I can't carry around these big binders, and my binders too. So ask your guardian their preferences and how they like to receive information, including those notebooks.
What about home visits?
Oh, boy. What everyone is living for, the home visits. First, clearing up the suspicion, not all visits are unannounced or surprise home visits. I think in 16 years, I've done a handful of unannounced visits. And clients typically are very afraid of that potential. So unless there are issues related to drugs or neglect, cleanliness, things like that, maybe a sleeping dynamic, I'm not going to make an unannounced home visit. And the purpose is what I'd like to emphasize for us today of the home visit is generally, most times, not the structure, not the four walls and the roof. The purpose of the home visit is actually to determine the engagement of the child with the parent, or the child with his or her siblings, or the child with any step or bonus parents. Very few times have I visited homes and there has been an issue that warranted a note in my records, meaning that the home was unclean or unsavory or the dynamic was poor. But it is really just a general observation of their interaction together. Having said that, do ensure that the children are present in the home visit. Because again, it's not to see the structure, but the interaction. A lot of times folks will have me over and I'll have to make subsequent visits because the children were not present, or an integral party was not present, a step parent. Or if there's a difficult sibling dynamic, that particular sibling was not present. You need to ensure before I schedule those home visits that those folks are going to be present. And oftentimes you do make multiple home visits for different reasons. Relocation is a big one. When folks are nesting initially and they relocate, you would need to make a different home visit after that relocation. And that the home visit is not the time for me to engage with the child about the dynamic. I typically have children come to my office independently with either parent for that type of engagement. And the home visit is the worst place for that because that's the child's comfort area, if you think about it. And so I wouldn't impose on their safe space unnecessarily. So a little guidance from you to your client would be helpful. And by way of that, I mean, parent A, this is not the time for Tori to talk to the child about preferences or elections or things that are not going well in their dynamic. This really is a time for Tori to see how we interact as a family and our strengths and sometimes our weaknesses. And that's it. I will make subsequent visits to engage the child as necessary. And I always like to be offered a glass of water at a home visit. You'd be surprised how people do not offer a glass of water at home visits.
I thought you were going to say a
Yeah.
glass of wine.
Wine would not be bad either. Wine would not be bad because it's often my second or third home visit. You're exactly right. Yeah.
I agree completely. I think managing everyone's expectations and really from a guardian perspective, we are not the children's attorney. We are appointed to represent their best interests. And I feel pretty strongly, and I think Tori does as well, that part of that is really trying to insulate them from this litigation as much as possible. So I think that there is this misnomer that we're going to come to the house and sit down with the 4-year-old and kind of have this intensive conversation about whether they like to be at mommy's house or daddy's house. And that's really not the point of these home visits, especially with small children. I want to keep as much unfocused on me being a lawyer or a guardian or any of those sorts of things as possible. And you want to try to normalize yourself and make them feel just like a normal guest in their home. It is surprising to me how easy children warm up to you, but it's also you were there and you're so focused on them that they get really excited. They enjoy doing things with you. They think that you're there to kind of meet their needs, which I think makes the home visits go a lot easier than I think people expect them to. So again, I think one of the biggest takeaways, if you take away anything from this, is communication with your client, managing expectations, preparing them for these different landmarks, and helping them understand to help cut down on some of their anxiety. which leads me kind of perfectly into our next thing, which is availability to the client. I certainly understand that when you are in the middle of litigation, that the expense of litigation can get out of hand very quickly when you're paying a lawyer and you're paying a guardian. And, sometimes these cases also involve drug testing and PEth testing and psychological evaluators that people try to cut cost where they can. But when that happens sometimes, and when the attorney kind of takes a major step back when the guardian gets involved, I think it does a huge disservice to the client. And then it causes the client to go elsewhere to try to meet their needs and have their expectations met. So one of my big concerns and things that I continue to have happen is that the clients are calling me and saying, I can't get in touch with my lawyer. I need to know about X, Y, and Z. And I'm having to constantly kind of redirect, or they're calling to get an update on the case, or they're calling about, all sorts of different things that I really am not able to engage with them in. Um, and I think that that is causing them to have a greater level of anxiety because they're not feeling the support from their counsel like they need to. So even once the guardian ad litem becomes involved in your case, I think it's really important for you to still continue to check in with your client, check in with the guardian. You would be surprised the number of attorneys who kind of never check in with the guardian to see how things are going on. And I think it will make your case move more effectively. The other, I think, real important kind of part about this is really what the guardian's role is. We can make recommendations. At the end of the day, we are not the end all be all. We cannot make people do things that they don't want to do. We can certainly discuss, we were talking about, for example, if we think psychological evaluations are necessary, and say, we certainly think that the judge will agree with our recommendation in that regard. But I think sometimes people think that the guardian ad litems are there to referee and to resolve by dispute as they come up. And I think that this causes unnecessary conflict and detracts away from the guardian's ability to actually do their job and to get through the investigation.
Absolutely. Absolutely. I think one of my mentors shared with me that there are two types of guardians, a social work guardian and a data collection guardian. I tend to trend towards social work guardian because for various reasons, but I think part of my duty to the child is to ensure that they are better off than when I found them. However, at the end of the day, Rule 24.9 is quite clear about my scope and my role. And it is to gather information, synthesize that information, and share it with the court. And I know along the way, as advocates, sometimes my intervention is helpful, and it certainly assists the dynamic. And I'm happy to do that with the party's consent or the attorney's consent. But I never impose my will on anyone because I don't have the authority to do that. Not that I'm disinterested, it's not my role.
And I think in more of these high conflict cases, it becomes it's like almost a full-time job.
Absolutely.
It's different than if you have a one-off and they're asking for what your thoughts are on something. I think that that is certainly appropriate and something that happens. But when you end up in these high conflict cases and there is an issue with almost every visitation or every doctor's appointment, you end up then feeling, like I said, more of a referee than a guardian.
Sure, definitely. Segueing into professional witnesses, and then Ashley will discuss lay witnesses or collateral witnesses. Witnesses are a thorn in anyone's side because oftentimes the parties, through perhaps the guidance of their attorneys, believe that the witnesses are the crucial component of their case or the investigation. Unfortunately, the reality is most times they are not. And I think the reason is, quite frankly, attorneys don't do a very good job sussing out or fleshing out witnesses prior to their client sharing the list with me. And by that, I mean, if you don't have an understanding or appreciation about what that witness will tell me, I should not have access to him or her. And what they have to tell me should be relevant and it should be timely, and relevance as to time. And a great example is I'll call a witness and ask a therapist, for example, when was the last time you saw the kids, or how frequently do you see the kids? And the therapist will say, well, I haven't seen them, assuming I can speak with them as a professional witness. I haven't seen them in 6 years, and I only saw them for 3 visits. That's not really helpful for me. So why were they included on that witness list to start with? And perhaps you think an exhaustive witness list is helpful, but please clear up that misperception after this talk. There needs to be a really heavy effort in resolving the witness list before it's even handed over to me. And professional witnesses are the gold mine of the contact with outside sources. And by that, I mean therapists, teachers, counselors, coaches, folks, clergy that have had access to the child. And it needs to be that connection, that proximity is very important. If you are a clergy and you just see the child in passing at mass or at temple, that's not a helpful witness for me, and I shouldn't be contacting them. So call your list with the help of your client and have an outline about what they potentially will say to me. And then I do my own digging, certainly, because sometimes there's a connective tissue and I can take from one witness and get to another one. But initially, that groundwork should be laid between you and your client before it ever arrives on my desk.
So, and mirroring some of the same things, but probably reiterating them even further, more is not better when it comes to lay witnesses. So more often than not, I get this list of witnesses that can be anywhere from 5 to 15 people. And when I start to peel back the layers with the client about who these people are, what interactions that they've had with the child, how recently they've seen them, you really start to understand that they're not going to have relevant and meaningful information. So we gave a little bit more leeway, I think, during COVID, because the question of how recently did you see the child was a much more interesting one because people were not seeing each other. But we're currently 5 years post-COVID. If you have not seen and had meaningful interaction with this child on an ongoing basis within the last 6 months, you're really not going to have, I think, very meaningful information that you're going to be able to share with me as the guardian about that. The best witnesses are obviously the ones who know both parents, who interact with the child, who have some sort of understanding about what the family dynamic looks like. But that's not, that's a pie in the sky kind of expectation. But the neighbor who sees the kid on a regular basis, sees them getting on and off the bus, sees them interacting with other children, for me, that's another person who is a really good witness. Mom's best friend from college who lives in Ohio and FaceTimes with the child, to me, is not going to be very helpful. I mean, there's the implicit layer of bias that's kind of in there because these witnesses are getting so much information from that particular party about what's going on. And then we have the issue of they're not really laying eyes on the child. I mean, doing some of these FaceTime calls are fine, but it's not providing me with meaningful data that I'm able to use to make a recommendation. The ones that probably drive me the most kind of nutty are the ones where they just call in and tell me that the person is a good parent. So it's like the other parent on the soccer team. So, Johnny plays soccer, dad takes him to all his soccer practices, and they're like, he's at all the soccer practices, and I think he's a really good dad. That is great. I mean, 90% of the time, whether a parent is a good parent is not an issue. For me, that doesn't move the needle at all. And I just think that these questionnaires get done and the attorneys do not have any conversations with their client about who they are putting on there. It's wasting time, it's wasting money, and it's not helping move their case in a direction that I think is actually being meaningful for them. I think also managing your client's expectations about when these phone calls will happen. It varies widely on how guardians kind of deal with the witnesses. I personally do it as the last part of my investigation because I want to have as much information as possible by the time I go to talk with these people. And I have these people sometimes who are like, well, you haven't talked to my witnesses. You haven't talked to my witnesses. I tell them at the beginning, I tell them in the middle, and I think that that's, again, where kind of the attorney can come in and say, this is normal, this is reasonable, this is why track about how to best advocate for them and move their case forward in a meaningful direction.
Absolutely, yeah. And I cover witnesses in my initial interview with your client So mark that as a question that they certainly should ask me. How often I'm going to contact a witness, or when, or at what stage in the process. And I'm happy to share that. And most times I find that parties are interested in whether they should forecast my phone call. And I'm happy to guide them in that direction with your guidance in that initial meeting with your client.
Yeah, I think if nothing else, I think what we would just like the takeaway to be is be involved, stay in touch with your client, answer their questions, try to help manage their expectations. And in doing so, you'll be doing a great job as an advocate and preparing them for a good outcome in their case.
Yes. And tell me what you want.
Yeah.
All right. Thank you so much, ladies. All right, now it's lunchtime, so if you want to make your way back out to the lobby, we'll take a half hour. We'll be back here at, what time is it right now? We'll be back here at 12:15 to start the next presentation. So, like I said, if you didn't sign up for your CLE credits, make sure you do that while you're out there. And if you have any questions, come and find one of us or someone at the registration table. All right, we're going to go ahead and get started with the next presentation. This is going to be on seminal family law cases in Georgia, cases that every family law attorney should know. We have Michelle Jordan presenting and Nilufar Abdi Tabari. Both are, I'm used to calling you Nilu, so both are with the Atlanta Legal Aid Society. Michelle is the senior family law attorney in the Brief Services and Centralized Intake Unit. She is a graduate of Emory University School of Law. She previously served on the State Bar Family Law Section Executive Committee, heading up the Child Support Worksheet Hotline and the Inclusion Committee. She is also a recently published author of the book North under Anne Michelle Harris. Available now on Amazon. Go buy it. I read it. It is amazing. So I highly recommend that, and always encouraging any of us to get outside of the family law world to do something we are passionate about. So she's an inspiration. Nilu is the managing attorney of the Domestic Relations Unit at Atlanta Legal Aid Society. She's a graduate of John Marshall Law School. She currently serves on the State Bar Executive Committee and is currently the head of the Inclusion Subcommittee. I will turn it over to you now. Thank you.
Okay, hi everyone. Feel free to keep eating if you're still eating. So today we're going to go over 10 essential family law appellate cases. And we decided to come up with kind of like a range of topics and types of cases for these. And as you know, family law is a practice area that is extremely discretionary. So these are some cases you can look to give you some guidance when you're trying to convince the judge to rule your way on certain issues. So this is not an exhaustive list at all. This is just our selection. And many of these cases are cases that have been clarified by later cases, or they are follow-ups to prior cases, and I'll go into some of those details as well. So I'm going to go through the first 5, and then Neely will do the second 5. So the first case is Thomas v. Thomas. So Thomas v. Thomas is a classic landmark case that you should know if you're a family lawyer, and it deals with the issue of marital property division. And as you may know, property, generally speaking, that's acquired before the marriage is considered separate property. Property that is acquired during the marriage is considered marital property, and that's regardless of whose name it's in. When I tell clients that, they freak out and everything, and I'm like, no, it doesn't mean if it's marital, that means it's subject to equitable division, and equitable does not always mean equal. It is what the judge thinks is fair. So, but what about property that you got before the marriage and you continue to use during the marriage? What happens with that? So that's what Thomas v. Thomas is about. It's about how to deal with property that has been acquired before the marriage and is increased in value during the marriage. And Thomas gives us the rule. It discusses the source of the funds rule, and basically it talks about the fact that you're going to figure out what the premarital portion is, and then how much value is brought into the marriage in that property. And then figure out what the marital portion is, and then divide it up using the corresponding percentages. And I usually, at legal aid, we usually see this with a house that, say, wife bought during, prior to the marriage, and that house has a certain amount of equity coming into the marriage, and then at the time of the divorce, we're looking at how much additional value that is. And then how are we going to divide it up? So that is Thomas v. Thomas. It's a good case to refer to. There are a lot of cases that came after it, but if you're looking to research it, that's a good central place to start. Okay. And then the next case that's a classic is Varn v. Varn. This case deals with the idea of alimony waiver in a alimony modification case. So under Varn, if parties reach a settlement agreement on alimony, and in the future someone wants to modify it, just because there's a settlement agreement doesn't mean you can't modify it unless you've had clear, specific language waiving the right to modify it in the future. So we call that the Varn language, and a lot of settlement agreements specifically will say, pursuant to Varn, we are waiving the issues in the future. So that is that case. If you ever see in a form settlement agreement, that is what that one is. Okay, and then the next one is Clark v. Wade. So Clark v. Wade is the landmark case for grandparent or relative custody. And generally, in Georgia, parents are presumed, it's presumed that it's in the best interest of a child to be with their parents. So that's where we start from. However, that can change. And Georgia created the grandparent custody statute. And I say grandparent, but it also covers aunts and uncles and adult siblings as well, and great-grandparents. So under that statute, which is OCGA 1971B.1, a grandparent can petition for custody. And under the statute, it says the presumption is that the child should be with the parent, but it can be overcome by the grandparent showing that it's in the best interest for the grandparent to have custody. So that seems simple because we hear best interest, and we use that a lot in our divorce cases or contests between parents. But Clark v. Wade, that court decided that that's actually not okay. We don't use the same standard that we use for a contest between parents. And under Clark, the standard for a grandparent custody case or other relative custody traveling under that statute is a two-part test. And you have to show that the child will be harmed by remaining with the parents. And then you have to show that placement with the grandparent is in the child's best interest. So Clark gives us the two-part standard for relative caregiver custody. And harm means not just like grandma's got a better house or is generally a better caregiver. Harm means the child's going to be physically harmed or suffer long-term psychological harm if custody is not given to the grandparent. So it's a high standard. And under Clark, the only way the best interest standard under that statute works is if we use that definition. So different from between parents. And a little twist about that is that under Clark and later cases that came after it, because the harm standard is a requirement, you cannot have joint custody between a grandparent and a parent because the court has to find that the parent is harmful. And then the other thing to watch out for is that under Georgia's new equitable caregiver statute, there's a different analysis. So if you cannot meet the requirements under Clark v. Wade for a relative caregiver case, you may want to think about traveling under an equitable caregiver status. Under equitable caregiver, you have to show that you've acted as a parent for the child with the consent of the parent, but you don't have, it's not the same kind of harm standard you would have for grandparent, but you have to also have that history of parenting the child, which you do not have to have for grandparent custody. So just, think about that as you're strategizing which action you're going to travel under. Okay. The next case to discuss is Johnson v. Johnson, and it deals with one of my favorite fun custody issues, which is self-executing custody changes. And this applies to visitation as well. And there are other cases that deal with this, but Johnson is kind of my go-to for deciding this. So under this case, a self-executing change of visitation is illegal unless it meets certain criteria. And self-executing means that you write an order, a final order that says, if this thing happens, then visitation is going to change. So if dad tests positive for drugs, visitation is suspended. Or if mom gets a boyfriend, custody reverts to dad. Or, if mom moves out of state, dad now gets custody. So it's a future event that's going to change what's in the order. And under Johnson, you cannot do that if it involves an uncertain future event or if it involves a third party who's not the judge making a decision. And the way that comes up often, which is a classic thing that people put in their orders, and it really makes sense to us just as human beings, it makes sense, but in the law, it does not. So a classic thing is to have an order that says, dad has supervised visitation until the therapist says it is okay to move to supervised visitation. And when the therapist decides dad has done what he needs to do, then he'll switch to unsupervised. And that is, you can't do that. That is not allowed under Johnson because it is an improper self-executing change that involves a third party who is not the judge to make that decision. So what you want to do is make sure that your self-executing changes are based on a date certain or have some parameters that will survive the idea of a third party making the ruling in the case. And as you see on the slide, it's important to also know that if you do accidentally end up with a self-executing change, which happens, and someone takes it up on appeal, the remedy is not to retry the case under Izunu versus Moultrie, which is a case we did at Legal Aid. The court held that if you do have a self-executing portion, it just gets struck. It's gone. So be careful about that because then you might end up with no visitation at all. So just a practice tip there on that. Okay. And then the next one is Davis versus Labreck. Oops, sorry, I skipped that. Did I go out of order? I'm sorry. Okay, yeah. All right, so Davis versus Labreck. So Davis versus Labreck is the case that gives us the standard for legitimation. I actually remember this case because I knew one of the parties a long time ago. It's wild that this case is so old now. So as you know, in Georgia, if the parties are not married, if parents are not married to each other, only the mother has custody rights to the child. Custody defaults to the mother in Georgia unless there is a court order. If they are not married, if they are married, then parents have equal custody. In order for a dad to get custody, he's got to do a thing called a legitimation. And that's a court case to declare himself the legal father. And as part of that, the court can decide, custody, parenting time, all of those things. And generally, that's something the courts want. They want kids to have two parents. They want the dad to be involved, all of that. So it is really hard to lose a legitimation case in Georgia, like legitimation itself, which is just being acknowledged as a father. You may not get primary custody, but it's pretty much going to be granted in most cases. However, under Labreck, it is possible that it may not be granted. And that is because you have to, under Labreck, the court said, you have to decide if the father has waived, the biological father has waived his opportunity interest in pursuing the legitimation. And the situation in Labreck was that mom had this child and had a boyfriend, and boyfriend legitimated the child. And mom kept custody. But then boyfriend decided he wanted custody and filed to get custody from mom and was successful with that. But turned out boyfriend was not actually the biological father. And then the actual biological father came along and decided to sue for custody. And the court said that he had waived his opportunity interest and that the analysis is to decide if the biological father has waived their opportunity interest, which means they have taken too long to show up and say they are dad to this child. And then the court will also look at whether the legitimation is in the best interests of the child. So it is not an automatic thing. You have to meet these kind of criteria for legitimation. So just keep that in mind as you're doing legitimation cases, as you want to show that the opportunity interest was not waived and that it's in the best interest of the child. And if there's nobody else competing for this, you're probably going to be okay. But if you have a case where the biological father is extremely dangerous and not safe to be around the child, such that it would be better not to have any contact at all, then that's a defense you can potentially consider raising under the Labreck case. So, all right, thanks. I'm going to hand it over to Neil now.
All right, good afternoon, everyone. All right, so I'm going to start with Body v. Daniels, and this is a case on minor guardianship termination. And with this, we're going to see a return to the standard that was established in Clark v. Wade. So in Body v. Daniels, we had a temporary guardianship that took place. We had mom who files a notice of termination per the rules. It was transferred to the guardian objected. It was transferred to juvenile court. The juvenile court denied the termination and maintained the guardianship. And from that, we see the Clark v. Wade standard get applied to guardianships, as well as what we saw in Clark v. Wade, which was the grandparent custody action. So sort of to reiterate, the standard is that the third party must prove by clear and convincing evidence that the child will suffer physical and or emotional harm if custody is awarded to the biological parent. That is the first step that needs to be established. And when we talk about physical harm is relatively apparent in terms of definition. When we talk about emotional harm, they mean long-term significant emotional harm. The case specifically states that some level of stress and discomfort may be warranted when it comes to reuniting the minor child with their biological parent. So that is certainly something to keep in mind. The case does do an evaluation of comparing the guardianship role and the custody role and finding them to parallel each other, which is why they applied the Clark v. Wade standard to guardianships. Okay, so the next case that we have is Mallon v. Mallon, and it establishes the factors to consider when you're looking at the enforceability of prenuptial agreements. The facts in this case were kind of interesting. So we see the three factors that are laid out there, and the case does a really great job of really evaluating each of these components, even breaking out fraud, duress, or mistake in that first requirement. But I think some of the key takeaways in this case were we had parties who get married after living together for 4 years. Husband had a net worth of, I think it was saying 8 million at the time of the marriage. The wife was a hostess at a restaurant. And after 18 years of marriage and 4 children, the court enforced the prenuptial agreement that the parties had signed. I think it was like 10 days before the wedding. And there's some other factors that went into consideration as well. One of the interesting things about this case was that when it came to the duress component in that first evaluation, it really said that it set a very high standard for duress. So one of the cases that they looked at parties who had gotten married where wife was pregnant, didn't speak English. Her visa status was coming to an end. She did not have the funds or the resources to obtain an attorney. And it was under those particular factors that the court found that there was duress. In this case, where parties had lived together for 4 years, where they felt like everybody was already aware of the standards in which they were living, they held the wife to a very different standard and didn't find any duress. They clearly didn't find any fraud. They did do an evaluation of some foreign, so some state laws from states outside of Georgia in this case. And what they really did was look to California law when it came to non-disclosure of assets and income, because neither party had disclosed their income when they signed the prenuptial agreement. And what they found was a spouse seeking to set aside such an agreement has a general idea of the character and the extent of financial assets and income of the other. And if that exists, then the non-disclosure wasn't as relevant. Again, in this case, the parties had been living together for 4 years. So they felt that they all had a base knowledge of what was going on. And then I think from there, I want to jump to the third element when we talk about the change of circumstances, because the facts in this case, you see a $14 million increase during that 18 years of marriage. And so the court did not find that to be a change of circumstances because they felt that the husband had an $8 million worth of assets at the time of the marriage. Parties had lived together for 4 years, that it was reasonable to believe that there would be an increase in the value of those assets. So again, this is a really great case in terms of really going into detail and evaluating those factors in terms of a prenuptial agreement. So our next case is Miller v. Miller, and this refers to business valuations. I'm going to go ahead and say, if you have too many questions about this, I'm going to head you in the direction of our high asset attorneys in the room. It's not that we don't see these issues at Legal Aid, but they're not going to be as prevalent as with our high asset attorneys. So if I redirect you or punt the ball, that's the reason why. But what Miller established was essentially the 3 methods of business valuation in divorce cases. So it identified income or capitalized earnings method, the market approach method, and the cost method. And it established and confirmed that the decision as to which valuation method to rely on is a factual determination to be made by the trial court. And I think, in fact, in this case, the trial court used a combination of these business valuation methods, and they still upheld it. So again, it is the decision of the trial court in terms of which business valuation method to utilize. So they're just going to look to the evidence that the parties are going to present in terms of which valuation method they choose. So our next case is actually a fan favorite of Michelle Jordan, so I'm not sure how I got stuck with it, but I think this is something that everyone is going to find really interesting. I ended up reading the case several times because I found it so interesting. So here, what we're talking about is a child support equitable exception. So the facts in this case are actually very important in terms of the decision that was made. So in this case, mom was awarded primary physical custody of the children, but during the time after the divorce was entered, mom asked dad to take primary physical custody of the children for, it seemed, roughly 6 to 7 months while she completed her education. So during that time, the children lived with dad. Dad took on complete care for the children. Then mom took back custody after that 6-month period, and she filed to collect the child support that he did not pay during the time that the parties had agreed that the children would live with him. So from this case, we see a equitable exception to the traditional rules. So typically when we talk about child support, one of the things that we often put in many of our agreements or orders is, private agreements do not equal a modification. So if you come to an agreement to the side between the parties, that doesn't modify the order, right? Or typically the courts have ruled that no voluntary expenditures do not equal child support, right? So if dad decides to buy $500 worth of school supplies, that doesn't mitigate the fact that he owes $500 of child support for that month. But under this specific set of facts, the court said that the father may be given credit if equity would so dictate under the particular circumstances involved, provided such an allowance would not do an injustice to the mother. So in this case, the court said dad does not have to pay. I think he was ordered to pay $117 a month. I believe this is a case from the 70s, so it feels really low. But he did not have to repay the $117 a month in child support for the time in which the children were living with him. The parties had agreed to the children living with him. One of the things that the court noted in this case is that the holding in this case is limited to the unusual combination of facts in this case. So I think that if someone is seeking relief under this particular case, then you really want to look to the facts of your case. But we're seeing more and more cases where we have parents sort of switching custody for extended periods of time for whatever reason, and then seeking to recover child support that wasn't paid during that time. So it is not that there is no relief, but under limited fact patterns, there is some relief available. And in closing, I'm going to close with Lewis v. Lewis, and I absolutely forgot to make a slide for it, even though TPOs are my favorite thing. So in Lewis v. Lewis addresses temporary protective orders, and I would be remiss not to point out that I believe this is actually a legal aid case, as is a few of the cases that have that we've presented to you this afternoon. I was about to say morning. So, we always like to toot our own horns. We do a good job. So what Lewis v. Lewis addresses is OCGA 1913-3. So what the court found was in this particular case, they were finding that in terms of establishing protective orders, the rule is, right, you need an act of family violence, you need a past act of violence, and there should be a risk of an act to occur in the future. So we're looking to future acts, past acts, and an act of family that falls under the statute in terms of family violence. Well, the court had held that there had to be that they had made a decision not granting a 12-month protective order, holding there was a requirement of reasonably recent acts. And in this case, they said that does not exist in the statute. And so what we had in this particular case was parties married in 2007. In 2010, we see an escalation in terms of physical violence. At some point, dad is arrested. He moves out of state. Almost a year later, he moves back into the state, and his behavior starts to look exactly like the behavior before there are acts of violence. As for many of us that work with victims of intimate partner violence, we know that they can usually pick up on those behaviors long before the act actually takes place. So in fear of what was to come, the client had filed for a protective order, and her 12-month protective order was not granted because of that lapse of time between 2010 and 2011. And the court said, no, we just need a past act. Now, one of the things that I always point out when we're discussing these requirements is when we move further and further in time, in terms of a past act to filing, can it possibly weaken a case? Certainly, right? So it doesn't mean it doesn't impact the case. It just means this does not statutorily exist. And there are many reasons why we might see a delay in filing for a protective order. If the abuser is in jail for a year and is about to get out of jail, and now I feel the need for a protective order because, well, he's been locked up, so I was safe. Well, that lapse in time shouldn't preclude a victim from obtaining the protective order because just simply for the lapse of time, right? The act took place, it could likely take place again. And so with that, we end our presentation. Thank you so much for hearing us out right after lunch. And feel free to direct all questions to Michelle. She is much smarter than I am.
Thank you, ladies, so much. And speaking of questions, you may have seen there's now microphones. So if we do get a chance for questions, because I know everybody's running up to the last minute, which is great, but if we do get a chance for questions, we are going to ask that you use the microphones. That way everybody can hear your question. And so we are next up. You guys mind putting those on? So that I can get over there. What? Charlie's going to pop them. So now we have the psychological, custodial, and parental fitness evaluations presentation. We have Megan Wiss. She is a partner at Boyd Collar, Nolan Tuggle, and Roddenberry, graduate of Villanova University School of Law. She serves on the executive committee, and as you saw earlier, she is our Family Law Institute sponsorship chair. And she is also running for Board of Governors post 6, so vote for her if you are in that region in Cobb County. We also have Dr. Allison Hill with Peachtree Integrated Psychology. She has her doctoral degree in clinical forensic psychology from Drexel University and her law degree also from Villanova University School of Law. And she is adjunct faculty at Emory School of Medicine. So take it away.
Thank you so much, Jamie. Hi, everyone. I will be kind of presenting on the practitioner's perspective, whereas Dr. Hill will be more on the clinician's perspective. But it's important when you're going about obtaining these type of evaluations, not only as a practitioner, but if you're serving as a guardian ad litem or working with the guardian ad litem, they have the power to request these type of evaluations as well, as do judges. So if your judge, for example, is saying, I need a psychological evaluation of the parties, it's important to know what kind, what you want the outcome to be. Each of these have their own components, their own results, and like what's going to be a product of this type of evaluation and how it's used. So I think first going into the, you put the animations on.
Did I?
We need. Sorry, you have the clicker thing.
Yes.
And is it on? Sure. And
So
then you just have to
technical.
press the down. Wait, I think we have to start it this way. Hold on. Give me one sec, and then I think, yep. So press down. To
Okay.
Down.
Okay. Okay. So Dr. Hill, can you talk about what the actual differences are in these types of evaluations?
Sure. So I think it's really helpful when my office gets the call on our side of things to get really, really clear about what we call the referral question. So what are you guys looking for? I think a general trend we're seeing is that these evals are taking a long time and judges are getting impatient, guardians are getting impatient. And most concerning for us on the mental health side of things is like the families are staying really stuck in this like really adversarial, intense process. So the clearer you guys are about what you're looking for, the easier it helps us
direct you or assist you. So a lot of people will call and ask for a psychological evaluation, which is great. I sometimes really push back and wonder why, because obviously something's going on in the system and no one should be doing a psychological evaluation and then making a statement about anyone's parenting ability. Now, people do it, right? But so in terms of your work, I don't know if that's going to get you what you want. So just be really thoughtful about that. That will get you a true diagnosis and treatment recommendations, including perhaps medication recommendations for that individual. But it's not going to help you move the bar forward in terms of your custody case. Separate from that is a psychological evaluation for a child, or sometimes what we call psycho-ed evals for a kid. More and more in our practice, we're seeing kids coming in these situations that have a lot of misdiagnoses. This is a really important point, especially for guardians. I can't tell you how many parents are in my office fighting that they are the superior parent that's cared for little Johnny forever. And little Johnny walks into my office and at 10, I can tell he has autism. And so I'm like, great, mom and dad, you've missed a big, big part of little Johnny, right? So just also be thoughtful. We're not just looking at the parents in these cases, it is a system. So you might see a kid in your case or might be hearing about a kid that's really hard to parent. Our kids with special needs, our kids who are neurodivergent, they are hard to parent. So a lot of the family system conflict might be because we have a really unique kid. And has anyone looked at that kid? So maybe what you're asking the judge for is a psychological evaluation of the child. And maybe mom and dad can then get some answers around that and co-parent together. Then we have what we call parental fitness, which is a psych eval plus, right? And that can give you a recommendation with regards to that person's parenting strengths and weaknesses. They need to see that parent with the child to speak to that. So as part of the eval, everyone needs to consent to, even if it's just of one party, that little Johnny comes in, or they cannot speak to parenting capacity. And then obviously a child custody evaluation is kind of one step forward. That evaluator should have access to all family members and can make recommendations around custody, not just speak to parenting strengths and weaknesses, but actually take it one step forward and make those final recommendations. And then kind of the more, aberrant ones, but are important, are when there's a question of, sexual deviance or inappropriate behaviors, where you could get a psychosexual eval or a substance use eval, and those are specific too. And so if anyone also has follow-up questions, that's fair too. We just wanted to give an overview because people are always calling saying, I need an eval. And it's like, okay, what type, tell me a little more.
And one of the biggest concerns we have often with our clients are the cost, right? These things are extremely expensive. We go into these often asking that the parties split the cost, or the higher earner or wrongdoer, for lack of better words, bear the cost. We always have the option of asking that the judge have the right to reapportion costs at the end of the case. In my career, I've not seen actual reapportionment all that often, maybe 1 or 2 times in 13 years. But that's always an option if you need it to kind of push the negotiations to consent to these things over the edge. Or a judge can just order it. You can say, go into court, say, we agree to a psychological evaluation. The concern is cost. Here are financial affidavits, and let the judge decide. Allison, can you speak to maybe the difference in cost of these things and if there's any less expensive alternative?
Less expensive. Well, so one of the things, like an easy low-hanging fruit area, there are these child evals, right? Because we have laws in terms of the educational abilities that our schools have to provide. A lot of times when I get a call from AVLF or a guardian involved in one of those cases, I'm like, have they asked the school for a 504 eval or an IEP? Because that'll start to get us some answers about this kid in terms of his or her academic or social and emotional needs for free, right? The school has to give us some answers. So the first step for me, if we're hearing that a kid is struggling, is to get eyes on that kid, right? I know that we tend to really focus on what the parents are doing wrong, but getting an eval of a kid is a really easy thing given a lot of the laws in our state. So sometimes I'm always like, have they asked the school for an eval? Have they asked the school for a 504? And again, it might require some collaboration, but that is also going to give the guardian or whoever might have to come in next a lot of data about how these parents manage that. So, we might as well start there. I'm a adjunct member of the Psychiatry and Law Service at Emory. There are still professionals that want to do this work. So let's not scare them off, right? I think be thoughtful about that when you call and ask for these evals. Be thoughtful about that when you're cross-examining the professionals who've done these evals. This is a scary territory for our trainees, but I am always supervising postdocs and residents who do want to do it. I send them a lot of the AVLF cases, but if you call me and you say, listen, these are our real circumstances and this is the real need, I have access to a fair amount of doctoral students who might want a chance, right? Now, then if you go in and tear them up on cross-examination, I'm not going to answer your call again, but just know that there are opportunities out there where people are trying to learn and be supervised by other clinicians who are doing these evals at a lower cost. Some substance abuse evals we can bill through insurance. So that's just another option. And sometimes we have to get creative. I mean, I have a few slides in here about where our field is really moving with these families, which is don't spend 12 or 18 months on an eval, quite frankly. We're moving to more of what we call like a brief focused assessment model, which is like 60 to 90 days. What's the one question you're really struggling with, judge or guardian ad litem, that you do think, being a family law attorney, you can't already answer the question, right? Because I think everyone in here can also be a psychologist in different ways. And so we're really trying to kind of craft orders that are a lot more specific and a lot more efficient. We bill by the hour just like y'all do. So if an eval is going to take 100 hours, that's going to be an expensive eval. If we can get eyes on this family and I can give an opinion on something in 10 hours to keep it moving, but no, I'm not going to have dotted every I and crossed every T and spoken to every collateral source, then that's a more kind of budget-friendly alternative, and it keeps the family tracking forward. But you can't then ask for that and agree to that process and then slam us on the backside because we didn't, do it the way you wanted. If that makes sense.
And a lot of times we hear our clients say things like, the evaluator's not going to understand my spouse unless they speak to, whatever, the nanny, my mother-in-law, some blah, blah, blah. Which one of these types of evaluations allow for collateral witnesses and collateral evidence?
So all evaluation should be multimodal, right? And multi-method. So maybe you do psych testing, maybe you do interviews, maybe you do collateral witnesses. I don't even do a psych eval of a party in a high conflict dispute without speaking to the person on the other side as a collateral witness, right? Because they're a huge source of data for me, even about the situational stress that the person in front of me is experiencing, right? 60 minutes with the person they're divorcing, and I've got a really clear picture of what's going on in this person's life and what's causing them anxiety or depression or to drink too much, right? So I would just say it's probably like all of us. You sit with these people, you know it, right? I mean, the trends and dynamics we see, talking to the nanny may or may not give you, that final answer you're looking for. But again, at the end of the day, like they all have to coexist on the other side of this, right? And also I have the luxury in my job of catching people post litigation. I get appointed as their PC or as their co-parenting therapist. And a poorly done eval or an eval that's used in the wrong way can really set them back in terms of their trauma going through this, right? So we want to be thoughtful about that too. If talking to a grandmother who's going to be picking up the carpool is going to have that grandmother put herself on the line and have a tense relationship with one of these parents, and that's going to trickle down to little Johnny, why do I need to talk to grandma? Right? I mean, what are we trying to achieve here? And that's what I'm always kind of going to be asking the attorneys in the room too, like, why? Right? Like, is this just about hurting someone else, or is it going to give me another flavor? I usually tell people to give me their top 3 collaterals. And then obviously if there's something that comes up, we reserve the right to kind of circle back, and certainly, before trial, we always like to know any holes that you might have thought we've missed. But, I always take a very strengths-based approach to evals occurring in this context, because on the other side of this, they're going to have to move forward for these kids' sake. And I think we have to be really thoughtful about that too.
Are there, and this is kind of putting you on the spot. So say if a judge has ordered both parties to undergo parental fitness evaluation. And for example, we have one from your office that's very comprehensive, spoken to collaterals, considered collateral evidence. And then the other side is just a baseline, evaluation that doesn't have a lot of meat to it, how would you recommend kind of approaching that other clinician? Is there best practices that you would think that they would follow?
Yeah, I would get them on the phone, especially a lot of clinicians are really scared of attorneys, I mean, y'all are scary. Um, and so, don't send them a subpoena. Don't first, right? I mean, again, if the clinician's problematic, then the separate thing, but don't out of the gate start adversarial, right? I mean, just call and be like, I need 60 minutes, right? I need you to take me through what happened here. I need you to take me through your outcome. I need you to understand why you didn't put that in writing. If I put you on the stand, would I hear something else from you? Maybe. I mean, again, I have parents who are holding up evals from 12 years ago, reading portions to their kids in my office, right? So I think when you see that side of it, you get a lot more thoughtful about what you send out, right? Or how you ask the judge to protect this information. And so, ask the practitioner, is this a standard eval for you? Right? There are certainly guidelines and we all want to be as professional as possible. So if someone's doing bad work, that's a different thing. But I would always start with like a conversation and just see kind of what their rationale is,
And how involved do you expect the attorneys to be in the evaluation process?
Well, I love my attorneys. That's why we're doing this talk together, because we have each other's cell phones, we text each other. Listen, I mean, we're marching these people through it together, right? And if y'all are calling me, the system is in a bad spot. And I think our best practices are collaboration and teamwork, right? So if we have good attorneys on both sides, that's the best. So if I get brought in to do certainly a child custody eval, I have an initial phone call with the attorneys out of the gate anyways. This is my process. This is how I work. I don't want any pushback on it. So if you don't want me, go on, right? We have waiting lists in our office. We're fine, right? But try not to make our lives harder, right? We want to collaborate. We want to hear what you think is the most important. We love binders. We love documents. We love doc dumps. We'll go through it all. It's fine. But don't kind of be adversarial with us, right? I mean, we were talking about one of my colleagues, Megan was on a call with she and another attorney. The other attorney just like took this really adversarial approach, and it like, to what end, right? These aren't our families, we have a job to do, you have a job to do. We can keep it professional. But if you want to collaborate, and I love an attorney that's like, hey, my guy's not perfect. But like, what do I need to know? I love to work with attorneys. But we also have a list in our office of attorneys we don't work with anymore.
Okay, I guess we.
Oh, down?
Yeah.
Yeah. Well, and I can just be, so, I mean, again, we are hearing everyone loud and clear. These are expensive. Y'all want the answers, right? And so, but again, you guys have to support what we're saying is most important too, right? So if we're gonna kind of fast pass this, right? Like, then don't come back and be like, did you read that 1,000-page journal I gave you? No, we didn't, right? So again, just know the process you're buying into. If you want an 18-month eval, great. I think it really detonates a family and keeps them in a really bad spot. But it just depends on what you ask for. And I just also want to say, like, these people are coming to us that, probably have a lot of pathology anyways that got them to these relationships, that has them like fighting to the death over their children, right? And so just know that like we are dealing with people at their worst. Like, we don't need to meet them there, right? We can stay up here. But I mean, most of the clients who are going to end up in these evals have significant mental health problems, both of them, right? And so just know that going in, and that these people are presenting to us in really bad ways.
And one thing we see as practitioners is, I guess, and you see obviously as clinician, is evaluations that have no reliable results, right? As defensive responses or things like that. How do you move forward after that as a clinician, and will any further testing have a different result?
Yeah, so the process is not perfect, so I think people are always trying to hang their hat on a piece of data that really helps them. I always laugh about like giving a psych test. I think if the testing is good for your client, you want all of the results to be based on the psychological test. I think if the testing is bad for your client, you want to be like, oh, let's forget we did the testing. You know, and you can't have it both ways. It's a piece, right? So just resist the urge to have a clinician who's like, based on this one piece of data, I'm making all of these conclusions, right? We want multimodal, multi-method, right? Yes, you can testify about the reliability and validity of data, but these are systems. These are people in dynamics. They are constantly being tested and retested. And there is no psychological test that can kind of speak to all of that. And so you really want, people who are flexible and agile and can kind of speak to kind of the dysfunction. As I say to people all the time, like the wheels have been falling off this bus. We all are now here, right? Watching it kind of derail, but like this has all started way long before we got here. And again, yes, like what's the best way to move this family forward? And obviously keeping the kids safe and making sure that they have the healthiest parents possible is important. But this system has usually been kind of building up for years.
And other than contacting your office, what's the best way to identify clinicians that do this type of work? When I initially practiced, there were maybe 10 people that did this type of work that were used regularly, and now it's like 4, right? So how do we identify more and more people to do this type of work?
Well, I mean, the one blessing that's come out of COVID for our work has been just the ability, like what we've been able to do over Zoom. And I think it's interesting because I now practice in 40 different states because I have a very niche practice if you think about it. But that's amazing because I'm collaborating with people in Boston and DC who are writing the codes and publishing these articles and kind of the leaders of our industry. And I'm bringing the way they work in those states like back here or wherever, right? So kind of within our field, there aren't a ton of us, but you now can have people, you can get access to the best. So we work in a lot of teams in our office. And so if dad needs a parenting coach and little Johnny needs a therapist, like dad's parenting coach might be like a really solid guy in Boston, right? Because he's the best for this type of narcissistic dad, right? And I've done an eval and this is who I think this guy needs. Great. Now they can meet over Zoom, and they can do the work. So we now can get people access to people all over the country. And obviously we collaborate with everyone who does this in Atlanta. And again, we want more people to do this work, but there are people out there and I think it's just getting bigger just because of what Zoom, and people have asked me like early on in 2020 in March, I just gotten an order for an eval like that second week. And then the world shut down and I was like, oh, like, I don't even know how to do this work over Zoom. I felt pretty comfortable meeting with parents over Zoom, but I was really worried about building rapport and aligning with the child. And then time ticked on and I was like, I got to meet with this kid over Zoom for the first time. And so I'm, doing my thing, trying to establish rapport. And I didn't even know there was a chat feature in Zoom. And the child typed in the chat, heads up, my mom is recording you. And I was like, I was like, but what I realized in that moment was a few things. One, mom is a psycho. No, I'm just kidding. But like data point, right, for my custody eval, big mistake. If you get an eval, do not have your clients record the evaluator. But also like I had established enough rapport with that kid in that moment that she was already connected with me more than mom. Right. And so that was huge. That was a huge learning experience for me in terms of how I work in Zoom and how we try to establish rapport if we can't be in person. Now, even like some cases I have in DC, even if I've met with the kids a lot over Zoom, I'll get up to DC and see them in person. Again, it just is how we frame it. But I mean, they're great providers nationally. So don't stay confined to just needing it to happen in Georgia, because we can now even do the testing over Zoom. Certainly the interviews of adults can happen over Zoom. So there's just like a lot of resources out there.
Are there licensure restrictions as far as testing goes?
So COVID opened up what we call like an interjurisdictional practice. So I and most of the practitioners in our office were members of what we call SIPACT. And so if a state has opted into SIPACT, we can practice in any participating state. So right now there's about 40 or 42, which again has made our work so much richer, right? Because we're working in these teams of people across the country and really learning from each other. So as long as it's a SIPACT state, we're good to go.
Okay,
Yeah.
that's great. And maybe I can speak to this as well as you, but
I talked a lot.
what do you think can be gained or lost from the use of a psych eval or some sort of evaluation? Obviously, you have to really balance you have to know your client first. I think getting to know your client's very important. A lot of times you have allegations of mental health issues right out of the gate, but knowing your client and knowing your client's pros and cons on their side will help you long-term understand how useful these evaluations are going to be, and getting your client connected with a good provider who's also going to give you insight into your client. So for example, Allison and I have a case right now where she's our client's individual therapist and has helped our client understand the divorce process and understand the other party, but also helped us understand how to maybe break bad news to our client or help manage his expectations of us or the legal process. Knowing those things before you get into a deep evaluation will help you understand, is this going to be a positive outcome for my client? You know, no one's client is perfect. If you think your client's perfect, then, you know, that's a problem in and of itself.
And in a very hopeful perspective, but
But no, speaking and working with a clinician that has worked with your client, they may be able to say, you know, if you undergo a psych eval, their, you know, outcome is going to say, you know, bipolar disorder, or their outcome is going to say some type of depression or anxiety disorder. That's important to know ahead of time. I don't know if you have any thoughts about what negative outcomes could mean for a family.
yeah, I mean, again, like, hopefully it's about just getting information, right? Not like, sticking it to someone else, right? Again, we want the information if it's going to help move the family forward. If it's just to kind of, trash the other party, then we can get into murky territory. But, what I'll also say, and I love being like an individual parenting coach and then working in collaboration with the legal team, because like, we get trained on the PhD side about what these people pull for and what we literally feel and the need to kind of, we're all here to help people, obviously, and like how to manage that, what we call counter transference. But then I'll be talking to Megan and she's like, and I'm like, okay, no, he's pulling for that. And no, like, nope, we're not doing that. And so, I mean, I love kind of being able to say, like, what you're feeling in that moment is really valid, and they're hard to manage and their expectations are hard. So also just always call and just chat it through with one of us about, like, I'm feeling this way about my client and I want to advocate for them, but does this make sense? Because we can say, like, yes. And that's part of their pathology, is that they're hoping to get that response from you, that, like, I'm going to make it all better. And, you are right. And at the end of the day, there's like no right and wrong. The system is grieving. The system is going through trauma. The level of grief and trauma might be trickling down to a little person. And that's like what we all need to keep at the forefront of why we did this, right? It's like, how much is what these parents are experiencing impacting these kids? And how do we get the answers we need?
And one thing I think we as practitioners really need to be careful of are how the orders are written that order these things. We may see language about who can read the evaluation, who can have a copy of the evaluation, can you provide it to other people? And because there's really not, I guess, Allison, can you speak to the confidentiality or lack thereof of these evaluations?
Yes, or maybe you. But again, I mean, most of the work is per court order, so then it's not confidential or privileged. Now, again, I don't like releasing reports to attorneys or clients. I usually ask the judge if I can release it to the judge, right? And then the judge can decide, because then I'm off the hook. But again, it's like documenting people at their worst, right? And sometimes the documenting goes on for hundreds of pages. And so I think it's on all of us to make sure we handle that, in the most respectful way. I say to parents all the time, if someone was following me around, watching me parent all day, every day, I would be a real mess. I mean, rainy Monday, carpool this morning, not pretty in my household, right? But thank goodness there's not some evaluator behind me saying, oh, you screamed, oh, what'd they have for breakfast? We're all human, and we have the privilege of interacting with these people in their lowest moments. And so I think how we handle that information is really important. And we can't guarantee that I won't have to testify to a judge about it, but I can hopefully guarantee that their ex isn't going to be showing it to their kid in a few years.
And from a practitioner's perspective is I want that report. I want that evaluation. I want to be able to read it. I want to be able to read the one that the other side has gotten as well if you're getting two opposing evaluations. So perhaps something you put in the court order is the attorney has the right to review the order. They don't provide it to their client. They don't have, or I know I've seen ones where the client can come into your office to read it, but they can't take notes. They can't take pictures. They can't take anything with them. All they have is basically their memory. That's one way you can deal with it, but keep in mind who your client is. If they're going to go and show this report to their child or their child in 10 years, maybe you restrict it as much as possible, or the other side, right? But me personally, as an attorney, I want to read it. I want to know what those outcomes are. And if I need to ask a question about what a certain, psychological test says, I'm going to Allison saying, okay, what does this mean, right? And what does this outcome actually practically mean for this individual or this family? So just be careful about your court orders. I know we all are extremely busy and we may have the urge to just take a standard court order, skim it and give it to the court. But it's important to read through what the rights of the evaluator are, what they can look at, who they can speak to. You don't want language in there that's overly restrictive if you're looking for a comprehensive evaluation. And things like costs are going to be outlined in there, who pays, how much they pay, when they pay, and the judge's rights as well. Does the judge have the right to read the evaluation without us reading the evaluation? That's putting something into evidence that's not really been fully vetted. So something to think about as well. And I think that's.
Yeah. Well, and I was just gonna say, that's such a great point because y'all have a different job to do, right? And I, as a practitioner, never want to keep you from doing that. So again, I want to get you the information you need so then you can do your job. Again, launching a subpoena over to my office, with 48 hours notice, like it just puts everyone on the defensive. So whether it's a kid's therapist or an evaluator, like I'm not trying to hide the ball. My process is transparent. You guys get what you need, but just be thoughtful and kind of the way you manage mental health professionals. Great.
Thank you, ladies, so much. Give them a round of applause. And would Kem and Regina? Huh? Yeah, if that's how you want to do it. Thank you, ladies. Oh, she's about to help. Okay. Thank you. So then it seems like we have to press this a couple times. There we go. And then Regina, will you press the down button and make sure it works? Okay, perfect. There we go. All right. Those are all set. Okay, next up, we have strategizing for an effective ADR session with Kem Ao and Regina Edwards. And Kem, sorry, I don't have this pulled up right. Kem is with Reese Weisbier and Associates. Am I saying that right? Okay, thank you. She's a graduate of Georgia State University College of Law. She serves on the executive committee as well and is the editor of the Family Law Review. So if you have ideas for articles, she's your person. And you probably see the blast from the State Bar, but really, if there's something you would like to have published, this is a great opportunity to get your name out there. And I'm offering you up for people to talk to after this for that purpose if they want. And Kem is also a registered neutral. And then Regina Edwards is with Edwards Family Law. She's a graduate of Tulane University School of Law. She's an avid traveler. I have to say, for those of you on the Family Law Attorney Network, she's probably the quickest to respond and most knowledgeable in her, or accurate in her responses. So thank you, Regina, for helping all of us there. She, I just have to say, notably volunteered her time and did a lot of work with ABLF during the pandemic and getting survivors into court when nobody knew how to work Zoom. So thank you to her. And I will let you guys go forward. Thanks.
Thank you, everyone. I also feel like I want to point out that Kim did the most with education and I did the least. So she also has a master's degree in health administration and then also got a JD and a master's at the same time with dual enrollment, which I find impressive.
It just means a lot of attorneys fee, what's student loan expenses?
Oh. So we are going to talk about different forms of AR.
I want to start off by saying, before you can even decide what kind of form of settlement or alternative dispute resolution you want to get into, you have to start with knowledge. You have to know your case. You have to know enough about the opposing party to understand who they are. You have to know your judges. And if you're relatively new, you won't have experience knowing the judges. You just talk to someone who might, because knowing these things helps you decide what it is that you need to do in order to be effective in mediation or whatever form of ADR you want.
I definitely agree with that. And as a newer attorney, it's difficult, especially if you're on your own, but try to develop a network where you can ask other attorneys who may be more experienced in that county. I like to stay in my lane. I'm in Gwinnett. I've managed to charm the judges somehow, so I don't want to wreck that by going outside of my comfort zone. So I stay there. So occasionally, if I have a case somewhere else, I'll call somebody else and ask, what is this judge? How does this judge look at this particular issue? So there's definitely no shame in reaching out for help if you're in front of a judge that you're, kind of unfamiliar with, because you're going to get different answers. When you have a case like alimony, you can give the same fact pattern to 10 different judges and you will get 10 different results. So as you're preparing for mediation and try to resolve your case, it does help to have a little bit of knowledge about the county, the judge that you're in front of, so you can give your client good advice. And we'll talk about that a little bit more, but we'll talk about the different forms of how to settle your case. The first are settlement conferences. Do you do a ton of settlement? I don't either. So we're not going to talk about them very long. I don't do a ton of settlement conferences anymore. For some reason, years ago, attorneys were doing them more. That's essentially mediation without a mediator. It's essentially just the attorneys, getting together. If you have a case with Randy Kessler, you'd come down to his office and he'd give you a really nice lunch. So I was in it for the free food about 15 years ago. I'm not going to lie. So I would do it a lot more often. It's not as common anymore, especially since with the advent of Zoom, everyone's kind of remote. But that is an option. Sometimes it really does just help to get on the phone and talk about what these sticking points are. And sometimes they can be very helpful. Even if you end up not resolving your case, sometimes you can figure out what the tipping point is. If you weren't able to figure it out alone in your discovery, you find out that the other side is concerned about premarital assets, or they're concerned about your client, spent $20,000 on a boat for the new girlfriend that they claim doesn't exist. So something that can sort of give you a heads up and give you more information to move forward to try to resolve the case.
Then there's the judicially hosted settlement conference. Unlike the regular settlement conference, this one is, guess what? Hosted by a judicial. It's where a judge actually sits down with you and helps the attorneys with the parties on call, see if they can work out the terms of agreement. Again, even if you don't reach a full agreement, it still can be helpful. And those also are not that common. They do tend to be sometimes ordered a lot in Fulton County, but they're not that commonly used elsewhere.
That's correct. And also, if you do a mediation with a former judge, honestly, you're going to get their opinion anyway about what they would have done while they were on the bench. Sometimes, especially if you have a very difficult client or you just have pretty complicated facts, sometimes it does help to have a senior judge or a former judge either mediate the case or to host a settlement conference to kind of give a bit more sort of gravitas to the situation. Especially if you kind of have been trying to give a reality check to your client and they're not listening to you. Sometimes they will listen to a former judge saying, look, I've heard these kind of cases before, and this is what I'd be likely to do. So I find it helpful for those reasons.
The next is the case evaluation.
Well, I think first we're gonna talk about mediation, and then how we, yes. So we're gonna talk about mediation and how to prepare for mediation. So I don't know if you can see with this, but this is kind of a little roadmap that I have done for my clients, and I put it in their sort of client packet. And I like to give them a roadmap so they can sort of see where they are in the process and where they have to go. And so in terms of preparing for mediation, obviously the discovery and creating the legal plan are the most important parts leading up to that. Everybody hates discovery, but we all have to do it. And after we gather all this information, that's where I look at everything and then create the legal plan. And the legal plan consists of a bunch of different things. In a family law case, it's going to be putting together the child support worksheet, drafting all the final orders, figuring out what your client wants out of the mediation. All of those things are going to be part of the legal plan. So Kim, what is your process for helping to create and prepare for the mediation?
Definitely, as I said before, it is knowing everything about your case. You need to know what assets exist, because let's face it, most of what we do is divorce. You need to know not only what assets exist in the marital estate, but how much, if any part of any of it is non-marital. You also need to know what your clients want for custody, what they want for division of the marital estate, whether this case is an alimony case, and come up with some idea of how you're going to calculate that alimony and the length of time for the alimony. Beyond that, though, it is managing your client, sitting down with the client, asking them what they want, and then telling them why they can't get what they want, or why part of what they want is feasible and part of it is not, and finding out for them what their bottom line is. What is it that if offered this, they would actually walk away from the table, and then working backwards from there as to where it is you want to start.
Absolutely. So here's a slide of sort of the things that I kind of do to help prepare. I like to have all the documents pre-drafted, and I go over them with the client during the pre-mediation preparation. I discuss everything with the Zoom meeting to discuss issues and documents, and we create a mediation plan and have checklists. So I've put some checklists in the materials. I don't even know if you can read that, but it's in the materials, so trust me, it makes sense. But these are all sort of the common things that come up in a family law case. And I just kind of like to have the checklist and go down the list of all of the things to make sure that I'm covering everything. Now, of course, in your cases, you're going to have other things, unusual things that pop up. Maybe you're going to have a trust, maybe you're going to have a special needs child, and that just gets added to the list. But these are sort of the basics that we start with to kind of go through everything and have my staff go through everything because they're doing the preparation for me. So if you're a newer attorney, I am just a huge fan of checklists, because even after 25 years of doing this, I'm going to forget some things. So that's why I like to have a checklist and just make sure that, everything gets crossed off. I actually share the checklists also with the clients because I want to know what's important to them as well. So in some cases, Fluffy the dog may be way more important than in other cases. So I share everything with them to make sure that we've covered all the bases for, what our mediation plan is going to be. So next slide. This is another checklist in terms of our internal process of what we do in-house. So my paralegal drafts all the documents, then I review everything, then I review them with the client, and then these are just all of the things that we do in advance of the mediation.
So we all know that if you come to a full agreement at mediation and that agreement is written down, then whatever is written and signed off on by the parties is binding. Here's the difference between an effective mediation versus a not quite so effective. Drafting that settlement agreement or the proposed consent order in advance. You leave spaces or highlights or something for the things that might change, but when you have just the mediated agreement, you have more work to do. You have more negotiating to do in order to try to reach a full settlement agreement. And you may end up in a situation that I have right now with a client where they have two different ideas of what that same mediated agreement says and cannot agree on the settlement agreement. And we're actually now 7 months past mediation where they fully reach an agreement. Whereas if you have the settlement agreement, then it's done. As soon as it's signed, you have that final pleading. While writing a settlement agreement takes a lot of time, editing it during mediation is a lot easier. So part of our recommendation, both of us, is prepare all of those documents in advance. Even if you walk into mediation thinking there isn't a chance in hell this thing is gonna settle.
Right. So here's an example of a mediation memo, but I'm going to tell you, don't do them. I refuse to do mediation memos. I refuse to sign off on mediation memos. If we're going to have an agreement, we're going to sign on all the final documents at mediation or we have no agreement. That's my stance. I don't care. I'm not doing this anymore because with mediation memos, a lot of times, you know, the client, well, sometimes it's your client, the client will sign it and then they will go home and talk to their brothers, cousins, uncles, girlfriend who has, you know, 2 years of criminal justice college and then wants to give them legal advice about the agreement.
JD.
Right. So, there is a very, I probably should have pulled the case, but there's a very on point case that says if you haven't agreed on everything, you don't have an agreement. You have an agreement to agree. So this looks great, but when it gets turned into a 20-page settlement agreement, inevitably there are going to be some things in that agreement that your client has not read. And that's just sort of an easy out for them in terms of, well, I didn't know what standard holiday parenting time was, et cetera. So my advice is take the time, pre-draft the documents. And that way at mediation, if you reach an agreement, you can just make the edits and then sign the full agreement. So I put a mediation memo in the materials. Again, I do not recommend them. The only time I would say you can just do a mediation memo and do the order later is maybe if you have a one issue case, there's a contempt where somebody owes X amount of dollars and they're agreeing to pay it. And it's just a really simple 1 or 2 issue case. But
Or if it was a 14-hour mediation and you're hangry.
that too. But I'll tell you right now, you're not gonna see me for 14 hours in mediation either. Absolutely not. Because I will be in my pajamas watching Netflix by 6 p.m. So I don't do really long mediations. I don't try to make people read long documents at the end of mediation. Sometimes I'll just say, well, we're just going to put a pin in this and we'll come back and mediate a different day. So I highly recommend doing all the documents ahead of time instead of doing a mediation memo.
So in getting ready for today, Regina and I have known each other for years, but actually have only had one case together, which
Yes.
we both got fired from.
We did. Like within 30 days of each other.
But we realized that we both agree on doing a marital balance sheet. Now, of course, this is relevant only in a divorce case, but as stated earlier, you need to know what the assets are in the marital estate and what, if any, portion of them is non-marital. This tool is also helpful in talking to your clients and showing them, okay, this is what exists. This is what's subject to being divided. And here's what it all looks like if we divide it this way versus that way versus the other way. A marital balance sheet is usually an internal tool. That's not something that you're generally going to share with the opposing party. But I have also not only found it for myself, but been told by a number of mediators that mediate some of my cases, that it is very helpful to them to hand the mediator a copy of your marital balance sheet. Let them see what it is that you're talking about. Finally, I recommend that you have the Excel version of this open with you during mediation so that as offers are being made and received, you can change that in real time to see what the bottom line is for the proposal that's in front of you.
Correct. So there's no right or wrong way to do a marital balance sheet, except the numbers should work. That would be a wrong way to do if it doesn't. This happens to be mine. I like colors. It just makes sense to me that way. So this is the way mine works. And on the far right 2 columns, you can see what's being apportioned to the wife and what's being apportioned to the husband. But it functionally works the same way. This is Kim's marital balance sheet. Something else that I like to do during the mediation is put the other side's offer into the balance sheet so I can see what they're really offering. And I find this to be the case, honestly, more often than it should be. There are just some attorneys that don't do marital balance sheet. They look at the big shine, and it's usually the person that represents what I will call the non-moneyed spouse, the spouse where the stuff really isn't in their name. They just look at the big shiny stuff. They look at the equity in the home. They look at this big old retirement account and say, I want half of that and half of that. I'm like, absolutely not. We need to look at the entire marital picture, which guess what includes debt. So if you want the marital asset, we've got to look at the marital debt. So sometimes when you put that debt on the sheet, it really skews things in your client's favor. So that's why I like to put the other side's offer and show them, if we're just looking at your offer and you haven't included any of the debt, you're asking for 80% of the marital estate, and that's just unreasonable. So Sometimes it helps to move things along in the mediation to kind of have this visual representation of what each side is asking for in order to kind of, to get some progress.
It includes the debt, it includes the cars, it includes Fluffy.
Fluffy the dog, yes. I always put Fluffy the dog in there, even though Fluffy has no value legally. Some other points I want to make about mediation. Do not be afraid to have the hard conversation with your clients early on. And I do a lot of mediations as the mediator as well. And I can tell who has had conversations with their clients and who has not, who's showing up and winging it. Because if someone is hearing for the first time, oh, I'm not getting alimony, it makes it really hard to settle that case. Because the client has come in with stars in their eyes, already shopping for their Louis Vuitton bag because they're thinking they're getting $15,000 a month in alimony, even though that's not what the income supports. So as a newer attorney, it's sometimes difficult to do, especially if facts have changed since the beginning of the case, to have those conversations, but you have to have them. And to be honest, this is just my own personal tip. You can take it for what it's worth. I tend really not to do substantive consultations in divorce cases. And this is why. If you want to get divorced and you have lived here for at least 6 months, I can handle it no matter what else comes up. What I do not want to do is have a conversation where you're asking me, what do you think I'm going to get in alimony? What do you think I'm going to get in equitable division? I have no idea, because at this point I have no discovery, I have no information, and I know clients by now. You will hang on to what I say like a dog after a bone, and you will want to hold me to it despite what the discovery reveals. So I don't want to have that conversation. So I just tell the clients early on, I'm not doing a detailed consultation with you. I will tell you about my process. I want to get information about their temperament, but we're not going to discuss my thoughts or advice about anything other than I can get you divorced. Because I tell them, after I get the discovery, we are going to have a detailed strategy meeting at that point to discuss, what the plan is, because then I have the information for you to make an informed decision. So that's just what I do. Y'all can do what you want, but I found that to be helpful.
And I'm the opposite. We have very detailed, sometimes up to 2.5-hour consultations. But when they say, how much is my alimony going to be and how much am I going to get in marital estate? I say, I have no idea. My crystal ball broke years ago and I cannot find someone to repair it. One of the things that what we're both saying, though, what's common in both what we're saying is managing and controlling your client's expectations. It is so super frustrating having an attorney on the other side who just buys everything their client says and spews it out to me as if they've never read a law in their lives. You need to make sure your clients understand what is and is not likely to happen. If you can't have that hard conversation, then soften it up. You can be kind and warm and fuzzy. I cannot. But either way, if a client is told what to expect, they're going to have a better outcome, actually, even if it doesn't settle mediation and goes into court. And if they can't handle you telling them the truth, then by all means encourage them to fire you and you find somebody better, someone else who might actually sell you a bill of goods.
Yeah, that's what happened in our case. I think she and I were on the same page about a reasonable path forward that would help, save the client's money in litigation, and they didn't like that. And they both hired people who are going to spend a whole bunch of money and ended up exactly where they would have been $100,000 in attorney's fees ago. But that's their choice. I also wanted to kind of mention that mediation can not just be a tool to settle the case, but to give you information just in case it doesn't settle. So there have been a lot of times that I've come into mediation thinking one thing, and I've gotten great information that helped me in terms of, strengthened what I felt was a really good case and made me more confident that we could get what we want at trial. Or sometimes it's the opposite. Sometimes you find out things in mediation that not so great for your client. And don't be afraid to let your client know that this fact and this perspective given by the other attorney has now changed my position on this. Recently, we did a case where I never thought the case would settle, but midway through the first mediation, the other attorney brought out a point that was very negative against my client. And after they sent me the information that verified it, it sort of changed my perspective on the case. So we paused. We already had a forensic accountant, so we sent this negative information to the forensic accountant to evaluate, and then we came back for mediation part 2 and we were able to settle it. So I think without mediation and without honestly good counsel on both sides being open and honest about what the pain point, instead of, they could have saved it for trial. Because what they knew wasn't discoverable, put it that way. So, having good counsel that's committed to resolving the case and just telling you up front, these are what our issues are, it gives you a chance to work through it, or if not, at least gives you a heads up of what to expect at trial.
We've mentioned meeting with your clients. I personally would rather never see them again after consultation until mediation or until the actual final hearing. That's only because as much as I love people, I can't stand people. However, there's certain times when you just have to actually be looking at their faces when talking about things. Preparing for mediation is one of them. What you had in the slide earlier was to meet with clients by Zoom. We highly recommend you meet with them by Zoom or in person. This is one of those things that cannot happen, definitely not by email and not limited to just telephone calls.
Absolutely, because sometimes you just kind of need to see the reaction on your client's face where you say, it just because, your husband gave your child the wrong flavor of jelly beans probably doesn't mean that he's going to get supervised parenting time. You need to see if it's a sort of resigned acceptance or shock or horror or whatever, because that'll give you guidance of how to sort of move forward. But I have loved Zoom for this reason, mostly because I also do not like people, and I'm certainly not doing a 2.5-hour consultation. I don't know what that's about, but I like Zoom because you do have the face-to-face interaction that you otherwise wouldn't, and it really does help you sort of get a rapport for your client and then get them sort of accustomed to Zoom before the actual Zoom mediation. So I think we've beaten
So
mediation to death, but do you have
Slightly
anything else?
cover, no.
Okay.
Let's slightly cover some of the other forms of alternative dispute resolution. There is late case evaluation. That's another one of those things that tends to happen or get ordered rather frequently in Fulton County and not much anywhere else. And it is, all of these things kind of are what they sound like. Late case evaluation is having an experienced senior attorney or a senior judge listen to both sides about the facts of their case, and then evaluate the possibility of what can happen in trial. Late case evaluation is the one form of ADR that does not result in finalizing the case. It just gives you some guidance in making settlement proposals or deciding that settlement is not exactly feasible. Now, of course, if you have a late case evaluation before mediation and you realize that you're not really likely to settle the case, you still have to mediate because we are in Georgia and the standing orders generally do require mediation. But at least it gives you some ideas and strategies as to what it is you want to propose, if anything.
Yes, so this kind of outlines exactly what happens at a case valuation. Honestly, in some mediations, it sort of morphs into that. If you pick me as your mediator and if the attorneys are okay with it, I'm probably going to give you my opinion at some point, especially if it's Gwinnett, because I am very familiar with all the judges there. So I'm probably going to give you my, input at some point if we're getting sort of late in the day, and I feel like it would be helpful to the parties. One thing a late case evaluation can help with is if you have some sort of linchpin or threshold issue where you cannot resolve the case until you get past it, sometimes it helps. And what I'm talking about is something like, is this property considered to be marital? And if it's a $500,000 valued property and one person is saying it's absolutely premarital and the other person is saying it's marital, it's almost impossible to settle that case until you get someone's opinion as to, whether or not it's marital or not. Or something like, is this prenup enforceable? Something like that, where you just cannot move the case because you have this threshold issue. Okay. So I do think late case evaluation is great for that. What is next? I don't even know what's next. Arbitration, yes.
So arbitration, unlike mediation is two sides trying to reach an agreement. Arbitration is having someone make the decision. It is similar to a hearing in that what you end up with is a decision maker coming out with a ruling or recommendation. But it's similar to mediation in that there aren't the formalities of court. You can present evidence, you can present testimony, you can chew gum. It's a more laid back sort of judicial approach. Usually before you actually enter into arbitration, the two sides are going to agree that whatever the outcome is, whatever the arbitrator's ruling is, they are going to have that be the final judgment of that case, or final order of that case. And so the next step after getting the ruling or decision by the arbitrator is going to be to make that into the final order of the case.
Correct. And there, I believe in our materials, we have the code section where arbitration is discussed. You know, based on my reading of the rule, if you request arbitration, there's a code section for it. The judge really can't deny it. I mean, it's happened. It's happened to me. But in general, they should allow it if the parties agree for it. They should sign an arbitration order. So this is just kind of some tips of what to do before arbitration. Obviously, get the agreement in writing. If you need an order, get an order from the court to do arbitration. Give the arbitrator an outline of what they are going to be deciding. There are times, and the other thing is, you don't necessarily have to use an arbitrator for the whole case. Sometimes it's helpful to use it for these linchpin issues, like is the prenup enforceable? Is this marital property? And agree to be bound by that and then move forward with the case. You can do that as well. If there's any agreements, make sure you have a signed stipulation before arbitration, which will help narrow the issues, and then decide if the arbitrator will write the order. As an arbitrator, I like to write my own orders. That's just, I'm a control freak that way. So I'm going to write all my orders in my arbitration cases. Let's see. So these are some tips of how to prepare for mediation. Prepare your exhibits, stipulate to as many exhibits as you can. Unlike the judge, hopefully, you're not paying them by the hour. You are paying the arbitrator by the hour. So you want to make sure that you streamline the case as much as possible. Obviously, make sure you have a prep meeting with your client and prepare proposed findings and share with your client.
Basically prepare for arbitration much the same as you would for mediation and or a hearing of any sort.
Correct. So one good thing about arbitration is because it's so informal, you can ask for breaks, you can check in with your client at breaks, you can adjust your plan, proposed order, depending on the evidence. Your closing should include proposed findings with the cites to evidence. In terms of arbitration, also, there's some judges and counties where it's taking a really long time to get to trial versus you usually can arbitrate within 30 days as long as you find an arbitrator that's available. And a lot of times it's not the court's fault. They're booked. And if you have a complicated case, it's going to take 3-4 days. It's hard for them to find that space on their calendar. So that's definitely something to consider.
So finally, we want to go over a few things that you absolutely should not do if you want to have an effective mediation. First of all, you should not go into mediation having no clue whatsoever how many children are in the case or what your client's income is or any of the things that are necessary in order to try to reach a full agreement. You also, and this happened to me, don't show up at mediation and then hand over documents that are vital in order to determine whether or not an agreement can be reached. I attended a mediation once, and at mediation is when opposing counsel handed me the deeds to the home to confirm when the home and other pieces of property were given to the client. We had no choice then but to end mediation and reschedule for another day. That's a waste of time. It's a waste of the mediator's time. It's a waste of your party's funds to do it that way. So do provide all necessary information, even if it's not something in discovery. Give the most recent statement or anything that's necessary in order to try to work things out prior to mediation.
And I'm good for telling people, look, if I don't have the information I need, I'm not going to mediation because I'm not going to waste my time. But I'm nice about it. I say it a lot nicer than that. But I do send an email probably about 10 days in advance of mediation saying, hey, we sent you this good faith letter. You know, for trial, we may need all the things in our good faith letter, but for mediation, I absolutely need this, this, and this. And if you don't get me this, this, and this within the next 5 days, I'm going to have to cancel mediation until I get this, this, and this. So I tend to be pretty specific because I don't want to be given things at the last minute and then my client feels rushed because we don't have time to discuss it and things like that.
So I lately, for some reason, have a lot of people getting divorced who can't seem to do anything without their mamas.
Oh, gosh.
And sometimes it's a little difficult telling them your mommy cannot be in mediation. But by all means, you do need to make sure that it is, because it is a confidential process, it needs to be a closed process. The exception to that is if you have a person who maybe because of dementia, they have to have a guardian or somebody who's so difficult that this other person is going to be a peacekeeper. Aside from people that are going to actually help move mediation forward, make sure your clients understand that no one else is going to be there. Don't, even if it's by Zoom, I've heard a story once of somebody, when asked if they agreed with something, they looked up and said, well, what do you think? And was talking to the child who was in the room.
Oh, yeah, that was me. That was me.
That's
So
right.
that was, we'll just end on a horror story. So you may have to do a sweep of the room and ask your client to do a sweep of the room. But apparently she had stashed her 14-year-old child under the desk. And we're 3 hours into the mediation and the mediator asked something about, custody, and she just asked her kid who was sitting there listening the whole time. So don't do that. I guess maybe now we have to ask the client to do a sweep of a room to make sure that other parties are not present, but
And
that was
finally,
fun.
don't do anything to end up on the mediator's hell no list, okay? As much as we want clients to understand what's to come, you as the attorney also need to be reasonable. Remember that these cases are just a job. Even if you feel a great amount of compassion for your clients, don't take it personally.
Thank
So
you so
Great.
much.
Thank you, guys.
we'll be available in the back room for questions.
Incredibly helpful. And we appreciate you guys taking the time.
Sure.
And I will, if you want to, thank you. Thank you. Thank you so much.
Yeah.
Okay. We are moving on to our next session of temporary and permanent attorneys fee awards. We have Max Fishman. He's a partner at Kessler and Slomiani and a graduate of John Marshall Law School. And Shayna Webb Pennywell with Shockley Dodson Deeb, graduate of UGA School of Law. And she serves on the Fulton County Juvenile Court as a judge pro tem. So thank you.
Hey, good afternoon, y'all. We are here to talk about attorney's fees, how to ask for them, how to argue them, how to make sure that they do not get appealed. I will say the thing that I see most people do that gets them denied on attorney's fees right from the start is to ask for $5,000 even walking into an attorney's fee situation, which that is going to block you from getting attorney's fees pretty much every single time unless you're trying to proceed under 1962 and you're just saying, hey, I need funds to help my client. If you are going to do that, go in and tell the judge what exactly you're going to need to get those fees if you're in that sort of situation. But the thing, and I know this will surprise you, I've probably seen 10 different times in recent memory, so 5-6 years, where attorneys have asked for lump sum fees pursuant to 1993G or 19615. And you have to be hyper specific. And that's the thing with attorney's fees. If you are not hyper specific about what statute you're asking for, about what fees you incurred, walk through the reasonableness of them, walk through your qualifications, walk through your billables, walk through your paralegal. You got another attorney work with you, walk through it. Attorney's fees are overturned by far and away the most on the next level. And judges will deny you on attorney's fees because they don't want to get appealed and they don't want to get overturned. So on attorney's fees, I don't want to say more than any other type of family law practice, you have to be hyper specific, but you absolutely have to be very detailed and very specific about what you're asking for, how you're asking for it, and why you're asking for it. Anytime I'm going to have a case, it does not matter if it is a custody modification, a divorce, whatever it may be, I cite the statute in my initial pleading or in a specific motion. I mention it at the end of my opening, I mention it at the end of my closing, and then I put the specific statute in the order. I do all four things every single time, and it's overkill sometimes. I might, in a divorce, plead under 1962 on a motion, even though I have already asked for it in the initial pleading, in the complaint for divorce or the answer and counterclaim. In terms of, and we created this chart, I tried to make it as basic as possible so you could see what is required. So for example, as you all know, in 1962, which is what we all proceed under a divorce, you have to make findings related to the financial circumstances of a party. If a judge, and I've had this happen, is very angry at the opposing party and they are going to give you every dime of fees that you are asking for there. And they don't want to hear from the other side regarding their financials in the slightest anymore. And they just want to shut it all down. Make the judge hear at least 5 seconds of financial circumstances of that party before they make a ruling and tell you to get off the Zoom, and you're on your merry way. And then you have an order where you're supposed to make a finding related to the financial circumstances, and no evidence was presented related to the financial circumstances. Let's say it was a custody hearing and you were awarded fees, so you didn't produce a domestic financial affidavit. So you have to make sure, as you're going in, no matter what the statute is, make sure that you have presented on a temporary or final basis what the requirements for that specific statute. Related to if you're proceeding under 2 different statutes. So let's say you have a contempt action and a modification action. You might be proceeding under 2 different statutes. Make sure you color code the bills as to what you're presenting, even on a temporary basis. Make sure you specify what statute you're traveling under. If you're there and you're proceeding on a temporary hearing on a motion to compel, and you're proceeding under on a modification of custody, you've got to make sure you spell out, here's where I'm going under 91137, and here's where I'm going under 1993G. And I find that color coding, I included in the materials, like color code, slap a cover page on it that says, this is what I'm asking for under this is what I'm asking for under this statute. No,
Can I jump in?
please.
With that, especially when you have multiple issues, easiest is discovery dispute. And we all know how much time we spend in emails back and forth with opposing counsel, calls with the client who've reviewed the documents and are telling you so-and-so's hiding everything. All of them, now, Max and I talked, I don't create a separate matter when I know we're getting ready for a discovery dispute. However, to make life easier, in those billing entries, I may stick 01 behind whatever it was that I did in that billing entry. Client doesn't really know or care, but it makes life a whole lot easier when it comes time to actually go now, whether we have a notice of discovery dispute or motion to compel hearing. When I'm looking at the billing activity, all I have to do is tell Adobe, look for 01. It's going to highlight every single entry that specifically had to do with that discovery dispute. So in a bill that is $8,000, okay, well, now I can see only $2,700 was actually dedicated to this. I can tell the judge very clearly on these dates, these entries, obviously redacting attorney-client information. And it's super important to try and be as precise as you can, especially when it's a teleconference about discovery. We may just throw in teleconference with client, discuss strategy and matters. Well, it was a discovery teleconference. If I go back a month later and I'm trying to do my billing statement, ethics is going to dictate that if I can't remember what we talked about a month ago, then it's going to have to be redacted. And that may be the difference of a couple $100 or more. But just again, things to think about when there's multiple issues that you know that you're going to have to travel under several different attorney's fee statutes.
In a similar vein, if you're like me, I generally bill like 1 billing entry per day per client. I'm not creating 17 different billing entries over each email, each phone call, each drafting of something. However, when you start getting into cases, and that's fine under 1962, right? Because it's kind of a catch-all statute in your divorce cases. But if you're having, yesterday I was working on something and it was specifically related to a case where I got 370 requests to admit. And I also was emailing with the client about his psychological evaluation. Those are 2 separate entries, right? Because if I'm later on in the case going to be arguing about the reasonableness of what they're doing, the psychological evaluation, frankly, my client needs it. It's probably not going to go well for us, but the request to admit 370, that's insane. And so I created 2 separate billing entries so that if I'm going to go argue the reasonableness of their actions in the case later, I can go back to March 23rd and say, all right, yep, there's that one entry. And it'll save you a ton of time when you're calculating all your attorney's fees. In terms of the other kind of like general broad tips, know your jurisdiction. I had a case with somebody else who was speaking here today. We were in a county hour or so west of here. And we went in and their request on fees on a modification case, parenting time was, I think, 13,000 and mine was 8,000. And the judge told us, well, you Atlanta attorneys are never getting more than $5,000 in my courtroom. And that applies to everyone and you. And then neither one of us got any fees when I think both sides had good arguments for fees and maybe they canceled it out. But when you're going somewhere else, credit some of the time. Go, judge, yeah, our fees were $13,000, but we got it down to, we credited time and we're only asking for $9,000. So that's a good way to get a judge to argue to the judge to get your attorney's fees, because you're telling them, hey, judge, look, I'm not even asking for the full amount. I'm coming in and I'm asking for just a portion of it. You may say, well, you're selling your client out and you may not get as much, but you may end up with zero if you ask for too much. And so know your jurisdiction. One thing that, if you don't know an appellate attorney, and I do not do any appellate work, but I worked with a great, phenomenal appellate attorney, Nancy Jordan, for a few years. And anytime I was drafting an order that was, beyond a one-page little thing, I would call Nancy and go, hey, Nancy, I'm drafting an order under attorney's fees under 19,970. Here's my issue. What do you think I should put in there? Because that's who this is going to go to, because attorney's fees are the things that are appealed the most and they are what are overturned the most. So if you know an appellate attorney, buy them lunch, pick their brain for a second if you're drafting an order and you're unsure about anything. In terms of asking for temporary fees, everyone just assumes that you're going to go under 1962 in a divorce. I have a case right now. There's a prenup. All fees are waived under 1962 is specifically called out. Well, there's also a custody component to it. And so 1993G is out there. My client, I was second counsel. My client came to me and go, she can't get any attorney's fees. I want you to be aggressive. I want you to go in. And I go, well, not exactly. She can still get fees under 1993G. And normally in a custody case, you may apply that only to the guardian ad litem or in a custody case inside of a divorce. But it's pretty broad. You don't have to have the financial circumstances in it. And on top of that, it's really just reasonableness. Now, you have to give a reason as to why you got there. You can't just go in and say, judge, this entire case was $13,000. I would like $13,000 in fees, please. You have to walk through what the other party did to cause the action as a whole and to cause your fees to get to $13,000 in a parenting time, custody modification, whatever it might be. Part of the hard part with a lot of these statutes is you have to have incurred the fees. And on a temporary basis, that kind of hamstrings you. So if you've got someone that's being incredibly difficult, I had a paternity legitimation. Well, it was just a paternity action at that point. They faked a, they're not here. They faked a heart attack. And I know that they faked it on a hearing. And this was April of 2020. So the judge made us come in person to an in-person hearing. I won't say what judge it was either, but because it was ridiculous, right? And that attorney caused us, I'm just giving you one example of what that attorney did. Our fees after that hearing was done, and I know all of y'all know the firm I work for. I know all of you are going to look at me sideways when I say this, but our fees were $51,000. And it was not because of anyone ramping anything up. It was because of the other side's craziness. And my client was she can't afford that. She was a mom with 4 kids and dad had cut her off. And so if you're on a temporary basis, ask for the fees that you have incurred so far. Go in and get what you can to protect your client, because y'all, we have to be paid too. You can't run up a bill. I put in on a temporary basis a lot of these modification statutes. Frankly, I've only ever had the alimony one come up once, and we settled. I didn't actually have to have a hearing over it. Talked about paternity. We've talked about discovery on a temporary basis as well. I know I've said it. I'll say it one more time. Keep detailed track of everything related to discovery from 6.4 forward. Every single thing. And also parse out small little things in it. All right. If you guys had to spend an hour going through specific credit card statements to look for a specific type of account, call that out. be specific, because that will help you get fees on a discovery if you're going under 91137. I included pretty much all of the discovery statutes in there. I will say 91514 on a temporary basis, I've done it once that I can think of. It was a pro se litigant. It was a contempt case. It was my only path to stop them from being an abusive litigant. Just keep in mind, when you're going in on a temporary basis, sometimes getting an award of attorney's fees can be a deterrent to the bad conduct that Eric Chambers and the two judges were talking about earlier. I have gotten an award of attorney's fees that has made a party start complying. And when I say complying, I mean acting like a normal human being throughout the litigation. And my client had more costs before that temporary hearing than they did after, and it was about the same amount of time. That's pretty much it on my general thoughts. And then on a temporary basis, don't treat temporary as lesser than a final. Y'all, like, go in, and if you're asking for fees in a divorce case, where I just had a case with it's a jury trial case. The opposing side asked for the jury trial. It's going to cost my client a ton of money to prepare for a jury trial. There's very complicated issues in that case. And I filed a motion for attorney's fees and said, here's what my client has paid us so far. Here's all the 2 depositions I expect to take and how much they're going to cost. Here's how much time I think a 6-hour mediation will cost, including prep. Here's how much I think getting ready for picking a jury will take. And I walk through each individual thing related to what my client was going to need. Did I get all of it? Frankly, no. But I got more than what was already occurred in under 1962, because I'm going, hey, look, my client needs this. She cannot afford a jury trial, and you can't expect us to float it. So on a temporary basis, those are kind of don't treat it any less than final. I think that's the biggest thing I can say. Go in with a chart, go in with a cover page, go in with an Excel spreadsheet showing exactly what each person, and I think I included one in the materials, showing what each person had done. Your paralegal, another attorney that helped you, if they had previous counsel, get their bills, input it, and then just have Excel automatically tabulate it for you. That way it's way less work, because getting attorney's fees together, I know costs a lot, and you don't want to put good money after bad. I totally understand, but there are things you can do to streamline it.
Yes, agreed. And so now moving from the temporary space into preparing for a final hearing and making a presentation for your final request for attorney's fees. First thing to do is, once mediation has gone bust, you realize that the train is absolutely the last stop is going to be the courtroom. Review your pleadings, review your initial complaint, make sure that you have included all of the statutes that Max had referenced. If you may have forgotten, a statute that goes overlooked a lot, and it is included in this really, really good resource, which I have downloaded, I've saved to our firm's joint Dropbox as just a quick 1-2 resource. You can figure out the issue and find it, but one of the easily traveled paths would be 13-6-11, which is a prevailing party statute. And when you read the statute, everybody panics and says, hey, wait, I think this only applies in cases of contract. So if we're in the contempt realm, can we get 13-6-11? Well, I did, and I found it this morning just to make sure. 13-6-11 can apply to both contracts and equitable requests before the court. Specifically, and it's not in our materials to see who is listening still at this late hour in the afternoon, the case of Brooks versus Brooks, which is at 366 Georgia App 650, decided February 6th of 2023. The appellate court specifically states that 13-6-11 fees are allowable in both contract and equity cases, which brings it back into our realm. The trick of this is this is one of the statutes that you must affirmatively plead somewhere. So when you know that the train is gonna end in the courtroom, you haven't pled specifically for this, it's time to amend that complaint if you can do so. 3 factors of this specific statute is that you have some bad faith that has occurred, somebody's been stubbornly litigious, or I love the litigant has caused unnecessary trouble and expense. We all can figure out a way that our opposing party has done all 3, but you don't even need all 3. You only need 1 out of the 3 in order for the courts to move forward and make a finding for you under that statute. Now, getting ready for the final hearing, we've amended all of our pleadings to include every statute that we believe has been triggered thus far. The next thing to do, going back to looking through your bills, making sure that in the case of like a 1993, it's all expenses and litigation expenses, including guardian ad litem, but it also includes that court reporter that cost $100 for takedown. We didn't get a transcript, but that was also an expense that was expensed out. It included the fact that I paid $12 to park at Cobb County, the Cobb County lot, because I wasn't there for just the benefit of seeing colleagues and friends. I was there for work. That's an expense. That went on the bill. Those are things that you want to make sure to account for. Look too at your billing statements before, because most likely in all cases that there is a request for attorney's fees, there will be an exhibit that presents a composite billing statement or multiple invoices. Obviously, we know we're going to redact for any specific attorney-client privileged information. Also, it's always great to double check to make sure that everybody's billing entries are correct. I have gone through some bills, and I think my paralegal meant to bill a 0.3, but she billed a 0.3. So, you know, we go from a couple of dollars to a couple more dollars. So wanting to just make sure, because again, these are things that we are going to present in front of a court. Our clients looking at us because they know they were on the hook for it. Now we're seeking those fees from the opponent. The other thing, especially in the context of mediation, for those who may or may not be aware, under 1996, when you are requesting those fees are coming out of the marital corpus. So it's part of the marital estate. So when, if there has been any partial agreements about nobody paying alimony, or you want to make sure, especially if it's neither side is going to pay alimony, you're going to do a barn waiver, you want to exempt the issue of attorney's fees, because it could turn around and bite you when later on you're arguing attorney's fees under 1996, excuse me, or 1962. I just get that. There you go, 1962, I just kind of top head. Because essentially, if we've said that there's no issues and we've foreclosed any fees under that statute, and now later on we're asking for attorney's fees, it's a way that it could get denied. So any partial settlements, you want to make sure that you're just reserving issues of attorney's fees. It's explicit, whether it's a mediation memo or otherwise. In preparing to present your final billing statement for the court, you also want to remember that you're in front of the court that day. So your billing statement may be up to date all the way through night before trial. As soon as you get in your car, your timer starts and it continues to go. And you want to make sure that on the record, in your opening, you can say, we have incurred X amount of dollars worth of attorney's fees to this point. Obviously, we're here today, court, and we anticipate that Those fees will be added in addition to any exhibits that we will present to you today. Then even in the closing, you want to remind the court, yep, we've been here for 6.5 hours. And you're feeling confident that you're going to be on the prevailing side and the court's going to be looking for you to draft final orders. You also want to have an idea of how long that's going to take you, because you'd like for that to be inclusive in any award for attorney's fees. So just at least having an idea of what that time frame looks like, because I have done it multiple times, and probably after maybe the 10th time I learned my lesson, is to go ahead and estimate that remaining amount of time for drafting. So when your client gets this very last bill, they're like, no, I thought I got an attorney's fee award. I don't owe you anything else. I'm like, but we do. So the other thing is collection, because we ask for fees and how do we get them? Thankfully, because we are all operating in the domestic realm, most attorneys' fees awards that we will get under most of the statutes listed in the slide outline are going to be exempt from bankruptcy discharge, because they are going to be considered domestic support obligations. So specifically, when trying to figure out what the opposing party could bankrupt out of, the statute you're going to look at is 11 USC section 523 A5, A6, leave A7. So that is going to, and essentially the bankruptcy code tells us domestic support obligations are not dischargeable, and bad faith, any attorney's fees awards based on bad faith or willful misconduct, those are also not dischargeable. So much like you are going to be required, and the court has to make specific findings of fact under 9, 15, 14, A or B, you want to make sure that if it is a 13-611, you've put enough information in there so that should the other side decide that they want to go through bankruptcy, a trustee can look at this and clearly distinguish, oh, this was based on stubbornly litigious. This was based on undue and unnecessary trouble and expenses.
I can take over.
Yeah, I'm gonna get back to Max.
Y'all, just keep in mind one thing that I forgot to mention earlier, settlement offer letters. I know we all think that, okay, we're gonna send this, and if they ever disagree, we'll be able to show the judge that this person was so unreasonable. I could tell you that especially if you're doing it in a divorce context, it's not always gonna work out that way. That can't be the sole factor. As the person to my left here actually told me in one of my cases where I was trying to do that, because that was really all we had to go under. So don't just rely on settlement offers thinking that they're going to be the ace in the hole for attorney's fees. The last thing is, it's okay to do overkill in pleading and proving your case on attorney's fees. I cannot reiterate enough. Like, I had a 9/15/14 case where the judge just cut me off in the middle of my argument related to it. And I'm just going, well, I didn't get everything out there that I needed to get to justify my fees. I also presented that same judge with a chart showing like, hey, here's the fees post a point in the action where things went south real quick. And the judge awarded me $13,000 even in fees. And it was 9/15/14. And yeah, that we had to negotiate that downwards, and my client lost out on fees because the judge cut me off and didn't want to listen and only just did what she wanted. So make sure that you force the judge on the record to let you make your argument. If the judge is getting mad at you, y'all, so what? Like, just make your argument so that you can protect your client in terms of the attorney's fees. Good.
All right. Thank you both so much. Awesome job. All right, Kristen and Rosalind.
You want me to move these?
All right, I'll move this in just a second for you. So now we have our last session of the day. We're almost done, and I'm sure what will be our most exciting session of the day, strategizing, and officially preparing for hearings and trials. Kristen Files is partner and co-founder of Files Hale. She's a graduate of John Marshall Law School. I guess I should talk closer to this. She's a prior co-chair of the Wildy Family Law Section and is a certified mediator and trained guardian ad litem. Rosalind Holcomb is a partner and founder of the Grant Group, graduate of UGA Law School, and she is a member of the executive committee and is our incoming secretary. So this is her baby next year. So they will take us through to the end of this, and then I just have a few announcements at the end. Thank you.
Okay, while Kristen is getting us set up, I'd like to take this moment to thank the section and the committee for allowing us the honor to present. To me, it's always an honor to get to appear and speak before esteemed colleagues. I thought that we were going to have to beg people to stay to hear us today, but it seems like the weather did us a favor so that you guys would not be trying to race out of here for a happy hour. So anyway, without further ado, I will go ahead and tell you give you some judge's perspective. And I was laughing because I heard Max just say, like, don't mind that judge that cut you off, just go ahead, even though you're gonna piss off the judge. Well, of course, I'm gonna disagree because what Jamie didn't tell you is that for 4 years, I sat as a judicial officer in Fulton County Superior Court. So for those of you who don't practice in Fulton, Fulton has a pretty unique system in the family court division. There are 20 Superior Court judges. 4 of those judges are in the family division. And of those 4 judges, each judge has a judicial officer that works under them. And so I like to tell clients when I'm explaining this to them that the Superior Court judge is like the big judge, or like the Ruth's Chris, right? Steakhouse. You get to lay out everything and spend your week if you want to have a trial before them. But the judicial officers are like, we're like the short order cooks, more like Waffle House, right? For judges. So what do people want when they go to Waffle House? They want it short, fast, quick, and cheap, right? So when you go before us, it's like, get straight to the point. There is no time for fat. So that's what we're gonna help you figure out how to do today. And it's kind of ironic. I mean, our presentation is on brevity, but we have lots of materials. And the reason that is because most of what you will do to present with brevity and impact begins before your hearing. It's what you do before to prepare for your 15 minutes. And that's what I was going to tell you as a judicial officer. Most people don't realize because you would never see our calendars. But when you come in, I'd see maybe 20 to 30 cases a day. And the time amount that I've been given for each case was probably 15 minutes, literally. So when the judges cut you off or tell you to get to the end or make it quick and short, it's not just because they don't want to listen to you. It's because one of the few measures of how successful we are as judges is how fast we get cases resolved, right? And we have all of those other people waiting for us that day. So just keep that in mind. It's not just about us being, I was going to say donkey's behind. Yeah, a donkey's behind. All right, so just keep that in mind. Preparing to be brief takes a lot of work, in short. The first thing that you should do, and I know, Kristen, you do this too, just like me, in getting ready for a hearing, is review all of the pleadings. And the reason that this is important is because the average family law case, as you all know, is probably 6 months to a year lifespan. Of course, you have outliers for that. But if you're going to trial, that's about how long it's been usually that you've been, at least, that you've been on the case. And when that happens, life goes on while our cases are evolving, right? Parties, I don't know, all the gamut of things, they lose jobs, they post
All
on
sorts
social media, all
Yeah,
sorts of
facts
things.
change.
Facts change, they leave the marital residence. And so what you initially ask for in your initial pleadings may may no longer be relief that your client still seeks, or there may be new relief that your client seeks that you want to advise the court of. So just consider that. It's also helpful because when you review the pleadings, if there is something you can do to, maybe you need to amend a pleading if there's ample time, or maybe you need to file a supplemental motion. And so in your materials, I included an example of this, and that's a motion in limine and for a more definite statement. And most of you are saying, I'm not familiar with motions in limine in a civil domestic context, but guess what? You too can use them. And so if you take a look at our materials and that appendix, you will see that in this case, opposing counsel had filed a motion that was over 93 pages. And so I'm reviewing paragraph 15 and 16 specifically. I said, Judge, our hearing is scheduled for Tuesday, July 13, 2021 at 2 p.m. While no time limit for our hearing was specified in the notice, presumably we will have no more than 3 hours for movement to make their case and for us to respond. If this court were to allow movement to present testimony evidence based upon the convoluted 93-page contempt filed by the petitioner, and we have to cipher our way through it with respect to every incident expressly mentioned or implied, over 25 that responded deduced, there would likely be no way that the court will have enough time to hear our issues. So when you do that, and then in the motion, I lay out more specifically. I just didn't do this because of the time issue. I did this because their motion went well beyond what should have been addressed based on the fact that the parties had just been in court 2 years prior. So consider that.
Jump over here. Okay, I want to talk a little bit about streamlining your evidence. And luckily, I had a partner who is both a judicial officer, judge, and a litigant. I'm speaking from the practitioner's perspective. And so we were talking about in the beginning, so much of what we do beforehand to present to the judges, all of that work that we do in advance with our client and ourselves is to make this as efficient as possible for the judge and hopefully get the best ruling for your client. So you want to streamline that evidence. We're all in an electronic age. Most people's files are digitized. That's perfect. However, you can't assume that the court has all of those electronic copies when you get ready to go. You need to have printed copies of each exhibit that you intend to use. I heard a judge earlier mentioning that counsel had showed up and only provided copies to one side instead of the other. You want to be courteous, have enough copies for everyone, for yourself, the client, the court, and opposing counsel, so that you can easily reference what you're discussing. In your materials, we talk about the Uniform Superior Court rules that require certain pleadings to be submitted at temporary hearings, at final hearings, and some of those are domestic relations financial affidavit, your child support worksheet, your parenting plan. So we know that when you're getting ready to go into a hearing that's about child support, the judge needs to have the information about how much income, gross income each party has. So ideally, you have that financial affidavit submitted 5 days beforehand as the rules require. But if nothing else, you at least have an idea of the income when you walk into that hearing.
Exactly. And I'll add here, Kristen, that the last two presenters gave great examples of ways to streamline your evidence. You'll recall Regina Edwards, and she had a very complex marital balance sheet that was exemplary, right? And then also the attorney's fees. The last speakers gave you examples of how, and that's another example of maybe you doing your separate affidavit that details what fees you're asking for under what statute and why, and also reminds the court what the parties' respective incomes are. A lot of times when judges don't have time to listen to you present, they will have time to read or review, and they'll either make that time before you appear before them or after. As long as you get it in writing, that's going to be very helpful to your side.
Absolutely. I'm sure we're all familiar with Our Family Wizard as well, right? We have materials in our appendices that have some samples of exhibits you can present as well. There's an Our Family Wizard exchange. that is a great way to have a comprehensive exhibit of what the parties have communicated, the date, time stamp, who said, who responded. Judges need all of that information. We also have some demonstrative exhibits in the materials that are helpful. And I'll just briefly talk about one that I've done for child support and alimony arrearages. You do not want to present to the judge a bunch of receipts or have your client trying to, off of their memory, describe how many payments they've gotten. Making a chart, an Excel spreadsheet as a demonstrative that summarizes voluminous information is admissible if you lay the correct foundation and is very helpful in streamlining the hearing. Another example I'd give is in being prepared. I was just in court last week where counsel used a PowerPoint presentation for their closing argument, which was very helpful in outlining the particular parts of the statute that they were asking for attorney fees under. In advance of that, it was very clear that she'd reached out to the court in advance, asked what type of technology setup they had, and it was a streamless process getting her closing PowerPoint queued up. Same with video or recording materials. You do not want be in court fumbling around trying to get technology to work. That's going to make the process less efficient and potentially upset the judge.
Exactly. Our next clue, again, the previous speakers or tip, the previous speakers covered as well. Prepare your client. You would be amazed at how many times I said in court hearings and I could see the client over at their attorney like, what's going on? Like they're trying to figure out what's going on because their attorney has not given them an idea of what to expect. And so we practitioners, you guys, we take for granted that we're in court all of the time. So the things, everything from the parking lot situation and do you need cash and what's the closest parking lot to going through security and not having your mace in your pocket or your switchblade. Also what to wear, bringing a light jacket. Also childcare. How many people have said, oh, we should be through by 2, right? So I can make it to the bus stop by 3 to pick up my little. No, you don't want your client in the hearing worrying about, are we gonna finish in time for me to go pick up my 4-year-old from the bus stop? You don't want them to worry about, so you wanna tell them in advance, listen, I don't know if we're gonna be there for 2 hours or 6 hours. So make other arrangements for childcare, so on and so forth. So
one thing I would add there as well, you also want to prepare your client depending upon what you're presenting that day. If you're presenting and asking for alimony for your client who's a wife, maybe you want to advise her not to wear her most expensive bag that day or her most expensive shoes that day.
Leave that Gucci at home.
Right, like that's not helping to make your point that she's needing of finances when she's in luxury clothes and diamonds.
I know my favorite is when people take an expensive car, like an opposing party. Have you ever had that happen? And someone is going to say, you know what? He's driving a Cadillac Escalade. And then he comes in court and says, oh, a friend of mine bought that. That's not really my car. A friend of mine bought that. And she's looking for child support or alimony. That's not great for your client. So remind them of these things that they think won't matter once they set foot in front of the judge and can finesse the judge.
Draft and present a proposed order. It is such good practice to have a proposed order prepared, give that to the judge at the start of the hearing when you're making your opening. And it really guides the judge's thinking throughout your case and is another way for you to advocate for your client. We have in our materials a checklist that was prepared by Roslyn as well as some other judges. And it gives a good checklist for things to consider including in any proposed orders, but you want to have findings of facts, conclusions of law, any legal authorities that apply to the arguments that you're making. And of course, there are contested issues that you don't know how the judge will rule on, right? And in those instances, leave a blank so that the judge can make edits as appropriate. We all know at this point, or should know, a good practice tip is that whenever you're submitting proposed orders to the court electronically, you want to send a Word version and a PDF version to the judge's staff attorney to allow them to make edits as they feel appropriate.
Absolutely. I would say judges love getting proposed orders because even though you may know, okay, you know, you've just reviewed the facts for this case. Whenever you have that piece of paper in front of you that tells you, boom, 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 here are the issues, here are the facts as we see them, it's a great guide for you. So that's very helpful. Another huge pointer is discuss issues with the opposition or opposing counsel before your hearing. So I'm smiling because how many of you have tried to reach out to opposing counsel or the opposing party prior to a hearing and not got a response? Okay, it's very frustrating, I know. But how many of you have reached out and gotten a response and been able to reduce some of the issues for the judge? Okay, so the judges love, love, love this. A couple of times I remember being in front of people would come to the judicial conferences and say, you know, tell me all their issues. And I'm listening to both sides and I'm like, what have you guys worked out? You know, this case involves children, so you know that temporary parenting time, custody and parenting time need to be established, that child support needs to establish. Go back out in the hallway and work through those issues. And I remind the parties, you guys are paying them a lot of money, a lot more money than I'm making to sit here and rule on this. You're paying them more than that to help advocate for your side. They already know what the court is going to want to address. They know or should know. So make them work for you. And I said, you guys come back, and in the times that I've done it, almost every time, the attorneys have come back with a consent agreement. Because you know this.
Right. I just had a judge do that last week where the counsel said, well, we've already tried to talk. And the judge was like, well, go try again, because I'm sure you can work something out. And sometimes it could be as seemingly small as stipulating to evidence, stipulating to exhibits that are going to be admitted. So there's not the time waste of objecting based on evidentiary issues. It could be as simple as figuring out how to limit the issues if there's one small thing you agree to. So anything can help streamline.
And going back to those of us who've had difficulty, which is almost probably most of us, communicating with opposing counsel when you reach out. If you've not been able to connect with opposing counsel, but you've made the effort, be sure to share that with the judge. Because if you heard the professionalism panel speak earlier, the judge is looking for the person who's going to be, you know, most of us are used to being the star student or star pupils. We want to know who is doing their best to work the case and help make our lives easier. So if you say, Judge, I'm sorry that, you know, I don't have this proposal. I've reached out to counsel, you know, by phone and email. Unfortunately, without being a tattletale, so to speak, but say, unfortunately, we've not been able to resolve these issues in advance, but I think these are our proposals for what our side would like to propose. And to that point, when you are able to connect with opposing counsel, I have two really great examples of this happening for me. If you look at your appendices, there's a stipulations list for the court's consideration and a proposed final parenting plan. So these are actually, it's kind of ironic, this was actually the Smith case. But anyway, in this case, opposing counsel and I worked together to do all of these factual stipulations about how and when the parties met, what they had. And really the main issue that we had in our case was custody. And it was a hard case because it was a relocation case. My client had relocated to Chicago with the minor child. And so the parties were fighting over where he was going to end up, and it was a younger child. And the other thing that we did that was pretty unique, and I think it is always worth your time to try to come up with creative solutions where you can agree prior to the hearing again, is we actually did a final parenting plan, and I call this a blind parenting plan because we didn't know who the custodial parent was going to be. That's what we were litigating over. But we did know that whoever got primary custody, the other parent was going to be the non-custodial parent, and they were going to get parenting time, long distance parenting time. So we both convinced our clients that, look, the fairest way to come up with a plan in case you don't get custody for your time is to do it this way, because everybody is thinking when they're planning, I could be the person with that time. So both parents were going to be generous, and they were. And I know the court really appreciated that, even though we had a days-long hearing still over custody, that was very fruitful. Say during your hearing, all right, and this is key. And this is, I feel like this is like the 15 minutes of fame for all the other 85% of work that you've done. During your hearing, let the court know what to expect. So whether you have an unusually long opening statement, whether you have multiple exhibits or several other witnesses, or whether you as an attorney have medical issues or reasons why you may need to take frequent breaks, whatever it is, always make the court aware of what to expect. It kind of reminds me of when they tell you when you get pulled over by a police officer, before you make any moves, tell them,
Right.
I'm reaching for my wallet, I'm doing
Right.
this, I'm doing that. It's kind of the same thing. It's very helpful when you tell the judge what to expect. So they
And one
don't.
way you can phrase that is
Yeah.
to say, Your Honor, I have a few housekeeping issues I'd like to address before we begin. That could be, as Rosalind just mentioned, I have an issue that requires me to need X. How would the court like me to handle that? We have a witness who has been subpoenaed here. How would the court like us to handle the time in which they're called? May we be able to call them first
Especially expert witnesses,
Right.
because your clients are paying
for their time?
for their time. So, and the courts usually are very sympathetic to other witnesses, because we know, especially doctors, if you've ever subpoenaed a doctor to testify, they do not want to be there. I think they're
Right.
worse than lawyers personally. But yeah, so the reason that we picked this picture of Kim Kardashian and what is this, like Chris Humphries, is because it's like, this is the most obvious thing. Like, an important fact in this instance would be the fact that I think he filed for divorce in their divorce or / annulment case, and she was the respondent party. But the fact that the respondent is a reality show person, and the fact that the parties were only married after spending, I don't know, $2 million on their wedding, they were married and together 90 days. So those are the types of facts that the court will want to know. They're relevant, you know. When I was a judge, I remember someone from, I think it was the Love and Hip Hop franchise, and they had got in touch with our staff and said, hey, is there any way you guys could move that hearing up for us because it's more in line with our production schedule? And we were like, no, we did not do that here. That's not what we will be doing. But anyway, so that's important though.
Definitely.
Yeah.
So in the same vein of telling the court what to expect, tell the court what your client wants and why they should get it. This is not the time to be coy, be direct, advocate for your client, and be specific. So we've included in the materials some language that we feel are examples of not so efficient language and language that's a little more efficient. For example, if I am asking, and we've been talking about attorney's fees, so that's in my head. If I'm asking for attorney's fees in my closing argument, because at this point, right, we are now through the case, we have presented our evidence, our very consolidated demonstrative exhibits, and we are now coming towards the ending, and we're about to make our closing statement. I am telling the court again, reminding the court again, not just saying, and Your Honor, my client wants attorney's fees. Thank you. No, it is, my client is asking for attorney's fees under statute XYZ based on, remind the court of the facts that were presented that go directly to that legal analysis under that statute. And also remember to reference any exhibits or materials that you have submitted into evidence throughout your hearing, because this is your opportunity to wrap everything up for the court. You don't want to be long-winded, but going based upon the notes you have from earlier and your exhibits from earlier helps you to do that in a streamlined, concise way.
Absolutely. I was going to say, don't just get up there and remind the court your client's asking for alimony. Now is the time to say she's asking for $600 a month for the next 36 months or until X, Y, and Z happens. Like, be very,
Exactly.
and I would say, don't bank on the fact that you're going to have an opportunity to do a closing argument. Okay. I mean, it's rarely going to happen. Your opening is your best opportunity to get the judge's full and undivided attention, true story. And also that proposed order that you can reference or other material. And I think Chris is going to discuss that next.
No, exactly. That proposed order is a perfect, again, opportunity to walk through that in your closing, very streamlined, to remind the judge. And then they also have it in front of them. I'm sure many of us have gotten through a final trial and then a hearing, and a judge is like, so do you need a closing? Do you want to close? It's kind of like, do you really need to tell me this again? So
They
you
don't
want to,
bring it up.
right, by that point, hopefully all of your information is out. And, you know, the last thing we would say is, we talked about referencing material and thanking the court. Hopefully you have made a good impression on the judge and the court by being prepared, concise, and to the point. But gratitude also goes a long way. Judges appreciate when you're kind to your opposing counsel, to them, to the court staff. So a simple, thank you for your time today, Your Honor. Thank you for listening today. We recommend you doing that for sure.
Yeah. And that is it for us. We have finished ahead of schedule today. And
One,
one
sorry. One last thing I was going to add that I didn't reference is that in our materials as well is a checklist that goes through everything we've just talked about in all of our materials that you can use when you're preparing for hearings and during hearings to make sure you've covered all your bases.
Absolutely. So utilize that. And I would just say, I know there's some of you that want to get out, but if you can stay and you have any questions for us, we can answer those questions right now if we have a few more minutes to do that. If anyone has any questions about anything that we've said. Okay, doesn't look like we have any
Got it.
questions. You guys have got it. Our materials are great. Use them. Thank you for listening.
Thank you so much.
Thank you, ladies. Yes, what great last presenters to finish ahead of schedule. So I'm not going to keep you. I just want to say thank you for being here. Thank you again to the State Bar for helping put this on. And thank you to our speakers. This is a lot of work to put together, but not anything compared to the amount of time all of our presenters had to put in to research their papers and put together their presentations and then be here today and take away from their billable time. So I really appreciate that. I want to do a quick reminder about Family Law Institute sponsorships before you leave. Again, if we are on track to raise the same amounts that we've been raising in the past years, that means that we are going to have no choice but to raise registration prices. So we're really hopeful that the family law community will step up to help sponsor and get us back on track to higher numbers as costs rise, which I know is a hard thing to ask when you're also facing rising costs. But it's kind of like an all-around thing that we're all facing. And so please, when you see that email come out, it's an easy online link to click. Finally, please make sure you complete your evaluations that were sent via email. Thank you so much.